Well, good morning, everyone. It's now 9:30. The inquiry is now resumed. I trust everyone had sleep last night after our long evening. Welcome back those who endured our long session yesterday. We're not always like that. Sometimes we are, sometimes we aren't. It depends. But thank you for those who enjoyed it through to the end yesterday, and welcome back this morning as well. I hope you're refreshed from your however many hours night's sleep you managed to get last night. All right, I'm sure you can all hear me, as you always can. My name is Stephen Normington. I've been appointed by the Secretary of State to hold this inquiry into an appeal made by Cemex UK Operations Limited. The appeal relates to the refusal of a plan application by Hampshire County Council for the proposed extraction of sand and gravel with restoration to grazing land and recreation using imported inert restoration materials, the erection of associated plant and infrastructure, and the creation of a new footpath and access onto Hamble Lane. And the appeal site is located at the former Hamble Airfield, Hamble Lane, Hamble, Rice, Hampshire. My role is to carefully consider the evidence provided this inquiry and to make a decision whether the appeal should be allowed or dismissed. Before we can go any further, can I ask the Council for the usual announcements about fire alarms and housekeeping?
Thank you, sir. Good morning, everyone. We had a fire alarm yesterday. We're not expecting one today, but if there is a fire alarm, a continuous alarm, if you go out this door here, out through to the main entrance of the County Council buildings, follow it round to the left, past the Westgate pub to the Great Hall where the fire evacuation points are. Toilets are just out of this door again, and then round to the right near the Nightingale room, and obviously out on the concourse you've got refreshments available at the breaks. In terms of mobile phones, please can I ask that all mobile phones are put onto silent. And for witnesses and anyone who comes on mic today, can you just make sure the mics are close enough to you? There were some issues with pickup of some of the audio yesterday, so please make sure your mic is as close to you as possible. And then finally, obviously, as I mentioned yesterday, this is being recorded. The recording information is outside of the main doors there to give you more information on the recording of this meeting. But by being in the room, you are essentially agreeing to be recorded for the purposes of the inquiry. Thank you, sir.
Thank you very much indeed. Today is day 6 of the inquiry. In a moment, we'll hear the re-examination of Mr. Howard, which closes the traffic and transportation evidence. The rest of the day will be hearing planning evidence, which will start with Ms. Kirby Hawkes on behalf of the Council, which will probably take us to lunch. This afternoon, it will be Ms. Else on behalf of the Rule 6 Party, followed by Ms. Pearman on behalf of the Appellant. As I did yesterday, with the appellant's witness, I will permit some questioning of Ms. Pearman at the end of the cross-examination questions. Just a couple of housekeeping matters from my end. I will start with the closing submissions. And I've had another think about this last night, just thought about some implications which are overcomable, I think. But I'll say what I need to say probably. Tomorrow morning on the schedule is closing submissions, and I appreciate if we have a night like we had last night, that doesn't give advocates a fair crack at the whip in writing up those closing submissions. So we've kind of 3 options as far as I see it, and I need you to have a chat about those 3 options and come to an agreement between you as to what you would prefer to do in representing the best interests of your client, really, and for the best interests of the inquiry. So firstly, we can proceed as we are and have the closing submissions tomorrow morning at 9:30 as per the programme. Or we could not sit tomorrow morning and start closing submissions around 1:30 to 2 o'clock tomorrow to give advocates the morning to write up. That's one option. That ensures that we use this room. If people want to observe those, they can do, and the live streaming is available. That's fine. Just for people sat in the audience today, closing submissions are basically the last submissions made by the advocates on behalf of their relevant clients. It's not something that anybody can ask questions of. It's not something that I would ask questions of. Those submissions are effectively provided in written form, which will also be on the inquiry website. So effectively advocates are reading out their final submission, which is a statement that's placed on the website. So in terms of engagement by interested parties or myself, there isn't any. It's basically reading something out that will be made available. So my preference probably would be to go tomorrow afternoon, if we can, because people can watch that in the audience if they so wish. But if we are struggling a bit with time, then we could go to look at virtual submissions. There is a little bit of a caveat with that, because I'm only available next week on Monday or Friday. I'm not available the 3 days in between. So that's one caveat. It would also require the council to be able to live stream those submissions from a Teams call, which I understand they can do. But I'm kind of open to that, as kind of my preference would be tomorrow afternoon if we can, then people in the room. If we've got some difficulty with that, and I appreciate you need time to get your head around some of the massive issues that's been arisen, I'm quite open to going to a Monday or a Friday next week, closing submission, probably Monday afternoon to keep it fresh, would be the first choice, Friday if not. But if we were to do that, I think I need the agreement of all parties, the three advocates, to say, yeah, that our preference is. Not now, probably by the end of club, we'll see where we are tonight. And confirmation that the council can do that as a live stream. I understand they can, because we had that conversation this morning. And I understand there is some capacity on Monday and Friday next week. And fortuitously, that's the kind of only time that capacity is available because of the democratic meetings. So it can be done that way. So all I'm going to say is that we need to see where we are at. I will go with whatever the collective agreement is, but I need you to all agree a route. So by the time I adjourn for tonight's session, I need to be able to clearly say, right, this is what's going to happen next. All right, so I'm entirely in your hands. I'm comfortable with it either way. There'll be no prejudice as far as I'm concerned from any interested parties because they can watch those submissions live streamed. And there's no interaction in any event. There's nobody that's going to be prejudiced by not being able to participate or ask questions, including myself. So we'll see where we are tonight. So watch out for the announcement, and then we'll put some kind of notification somewhere, probably on the website, about what happens next and when that might be. All right. Last part of housekeeping from my position. And there's something I just need to attend to here, actually. We left an issue last night about looking at some indicative costings for shared surfacing. If I can by the end of tonight have some kind of note on that, I'm sure the appellant will start to lead on that from looking at the SPONS data. If there is disagreement with those figures, because there'll be lots of other contingencies and there'll be lots of the abnormalities and all sorts of things in a total costing. I'm only really looking at the cost of shared surfacing. We don't need to go through all the other contingencies and costs unless you can show that. It's just to give me an indicative ballpark as to what you get for your money in terms of 700 plus metres of hard surface. At least it just gives me some indication. So you're not going to be able to do detailed costings. I wouldn't expect you to do that. And from your position, Mr. Fulbrook, I'm not expecting you, if necessary, to agree that, as long as you identify the reasons why you don't agree. But at the end of play today, I prefer for a little bit of a note saying, using the SPONS data, this is the cost, agreed, or if disagreed, these are the reasons why we disagree. And I appreciate, I'm not asking to do detailed costings, that would be unfair. It's a council scheme in any event. I just want to know really the cost of shared surfacing, if you can do that.
Yes, so thank you. I think broadly we're happy with that. And I'm sure Mr. Whitting will take this up with Mr. Howard once he's out of the box. I think we're keen that one of the difficulties is understanding exactly how much shared surface is being permitted.
Yep.
They can obviously discuss that, but we're obviously keen that it is the full schema shown on the plans. Yeah, well, I think we'll have to take that up with the experts. Will take that up, so we'll obviously get some.
Yeah, see where we are.
Yeah.
Say I'm not. It can't be detailed costing. It would be unfair to me to ask for that. But there was some issues raised about the what you get for your money in terms of SPONS data, and I'd just like you to just have a look at that and just tell me as a ballpark what you get for your money. I can't place too much reliance on that because it's not the council scheme. All it does is tell me one way or the other as to how far we're off the equation, really, of the 500k as an indicative figure. And it's something I won't use in detail, but it's something that will steer me one way or the other as to how close are we, and are we way out here. All right.
Yeah, thank you, sir.
That's the only housekeeping that I have. Mr. Strawn, anything from your perspective?
No, thank you very much, sir.
Mr. Lewis?
Nothing from me, just in case it saves time, so I'm afraid I can't do next Friday due to another inquiry, in case that helps with checking diaries and so forth, but I could do the Monday.
Thank you. Anything with housekeeping from yourself, Mr. Fulbrook?
No, thank you, sir.
In which case, I'm going to ask you to commence re-examination, Mr. Strawn, of Mr. Howard. Then we'll pause for a few moments while Mr. Howard leaves the desk, and we'll ask Mr. Kirby-Hawks to sit up.
Thank you. So I'll just respond to Mr. Lewis. I can't do the Monday, so that, but I can do the Friday. So, but anyway, rather than take time on that now, we can speak outside the inquiry. Thank you. So I'll start, if I may. Good morning, Mr. Howard.
Good morning.
You just need to cast your mind back to yesterday, not to
Doesn't seem that long ago.
No, it wasn't that long ago. But I'm going to try and, I've only got a few questions to ask you in re-examination, but I'm going to, sir, if you're happy, just do it on a sort of topics and therefore pick up some of the third-party questions you were asked about along the way rather than come back to them out of sequence, if that's all right. So just the first topic was questions about the 2024 survey. You may recall you were asked some questions both by Mr. Fulbrook, but also by Mr. Hillman and others about the 2024 survey. And the first question just relates to, I think, Mr. Hillman's question about where the data is for the 2024 survey to identify the figures. You talked about Appendix I. It was quite a rapid exchange, but you mentioned Appendix I quite a few times. Can I just get you to clarify where that is? I believe it's CD 82.
I think the data for 2022 is in Appendix I
Right.
of the TA
So that-
addendum.
So the comparison, apologies if I got that wrong, so the comparison being made between 2024 and 2022, so the question Mr. Hillman was asking was about where's the 2022 data? You were referring to Appendix I. Can you help the inquiry, and indeed Mr. Hillman, where he can find that and just take your time to identify what it, I believe it's Appendix I, because that's not a core document reference, but is CD82. Perhaps you can just help.
It's an Appendix I of the Transport Assessment Addendum, which is CDB 82.
And just to further clarify, so CDB82 has actually got three parts to it. So if you go to the CDs, there are three parts. Can you just help where it is? I mean, I think I know where it is and probably could lead on it because it's. But if you tell us which part.
Yes, it's in part 2.
Yep.
From pages in the PDF. Page 148, it says Appendix I, turning count and queue length survey data. And then it is from page 148 all the way through to all the way through to the end of that document, so to 280.
Yeah, thank you. And you explained to Mr. Hellman that you were calculating total vehicle flows through the junctions by counting out the vehicles on the turning arm, as opposed to having an ATC on the road itself.
Yeah.
Yeah, thank you. Just in relation to that, Mr. Howard, does that methodology you've used enable you to identify the flows in the relevant junctions or not?
Yes, it does, yeah. Effectively, all we're doing is just summing the number of vehicles arriving on a particular arm and then the number of vehicles that exit on that particular arm, and adding them together just to calculate the link flow.
So thank you for that, and thank you for the correction about Mr. Hellman, about 2022. Turning then to the 2024 data, and you were asked a series of questions, both again by Mr. Hellman and by the council, sorry, Mr. Fulbrook for the Rule 6 party. Just a simple question, I hope. You referred, or were referred on a number of occasions, to your table for the 2024 data, which you had updated to reflect the Friday the 18th of October. Just turn your table up again, please.
Just table 3.3.
3.3, thank you. Which is page 32 of your main proof of evidence. And if everyone's done what I've done, on the right-hand side, you'd given some figures which just update the figures for 16th to 18th rather than the 11th, which had gone in. So, for example, the first one, 1907, is 1927, I think you said.
Yeah, that's correct.
And I won't run through them all, sir, but you've probably got a note of those. But just in terms of the various questions you asked about, including from Mr. Hillman, can you just briefly explain with the updated figures as to whether you consider the unaffected roadwork figures and the affected roadwork figures for the peak hours that you're looking at are materially different in affecting your conclusions?
Yeah, I think I made that point hopefully yesterday, so it was probably confusion by too many numbers, but yeah, the numbers, from 8 to 9, we were sort of 1928 in the period unaffected by roadworks, and then 1927 in the period during the roadworks. That's 8 till 9, a difference of one vehicle. Again, 6 till 7 in the evening, 1914 versus 1903, a difference of 11 vehicles. They're incredibly comparable traffic flows.
And then just taking it a stage further, just fitting all these pieces together, that's the 2024 data, which you compared with what you've used for 2022. But I understand Mr. Hillman and others still think that that is not representative because of effects on the traffic network on particular days across the week in that period. So can you just help the inspector, what does the 2025 data, not collected by you, but by the Rule 6 party, tell you as to whether or not the 2024 data is inaccurate or invalid?
I think, sir, if I just take you to table 1.1 of the rebuttal proof, which is on page 6. I think if you compare the 2024 data versus the 2025 data, they're quite comparable in a number of periods. So 5 till 6, for example, in 2024 we surveyed 1,881 vehicles, whereas the HPDG survey surveyed 1,785. So again, a fairly comparable number. The same comparison, but between 4 and 5. We surveyed 1979 in 2024. The HPDG surveyed 2001 in 2025. All quite similar numbers. And again, if you turn over the page to page 7 to table 1.2, again, we've done a comparison of 2024 flows versus the 2025 flows. Again,
That's at the counter further down.
that's the counter to the south.
ATC2,
To the south of Mallards Road. Again, we surveyed in 2024, we surveyed 1,226 vehicles, whereas the 8PDG survey was 1,096. 8 to 9, we surveyed 1,292 in 2024, and the HPDG surveyed 1,141. They're all very, very similar numbers within the sort of fluctuations you'd expect on across any different day of a survey.
Yeah, just on that last point, you previously referred on a number of occasions to fluctuations that one gets, no doubt, between surveys and so. Just standing back and looking at all the data you've got there for Mr. Howard, you said that the 2022 data is robust to use because 2024 and 2025 aren't showing any material increase in traffic in the peak hours, I think.
Yeah.
Have you seen any data or evidence, be it the 2024, 2025, or indeed the DFT data, which leads you to question that assumption?
No.
Then DFT data, you were asked about that. Does that help with the analysis which the council required of you and you have performed in understanding the congestion on the network at the peak hours?
No, the traffic modelling that we do always focuses on the peak hours, so the busiest hours, and that DFT data does not provide that information.
And finally, on data and these figures, you explained to Mr. Fulbrook in answer to a question which Mr. Hillman then subsequently pursued, but I'm not sure you came back to it, but you explained to Mr. Fulbrook that in light of the last time we were all here, you had looked at speeds in relation to the 2024 and 2025 data to understand whether, because the suggestion being, well, if everything's at a standstill, you'll expect a lower count. And you explained, first of all, that that's not what the data is showing because of the number of vehicles still going through the junctions. But you also said you had looked at speed. Can you just clarify what you did to explain that?
Yeah. So we effectively just took the speed data that came from the 2024 surveys that we had to the south of Mallards Road, and then also the speed data from the HPDG surveys in the same location to the south of Mallards Road, and effectively just tried to sort of test the hypothesis that the traffic flows were lower because the speeds were lower, but that wasn't what we found. I won't read out all the speeds. It's too much confusion by numbers, but effectively the HPDG flows in 2025 in those locations were lower, but the speeds were higher.
Thank you. Allocated site and the local plan. You were asked serious questions about that by Mr. Howard, and you recall he was putting to you that the plan had done a strategic transport assessment for the purposes of the allocation based on 30 to 60 HGVs, and you answered a series of questions about that. Don't need to go over that. Just as a matter of principle, in terms of the use of the site for 30 to 60 HGVs that was assessed for the purpose of the allocation, are you aware of any, in principle, difficulty or problem or objection to the allocation, assuming 30 to 60 HGVs use Hamble Lane and turn into the site at a suitable point?
No.
And in terms of the scale of change, as you put it, between 30 to 60 to 126 at the maximum, so it's 90 to 126, in terms of, you talked about scale of change, whether in terms of highway safety or in terms of amenity, or to pick up another question, intimidation, can you just give your assessment whether the scale of change between 30 to 60 HGVs added into the traffic versus 90 to 126 added into traffic gives rise to any material scale of change under those topics?
No, and I think the point I was trying to make yesterday was about, we have ultimately that 30 to 60 vehicle movements that came from an assessment at the time of, the level of mineral, periods of working, how many, size of vehicles. It wasn't a case that the transport assessment that supported the Minerals and Waste Plan assessed 90 and found that to be unacceptable, or assessed 126. It was literally, that's what we think the numbers might be. We've obviously done a huge amount of technical work to support the plan application, which has been rigorously scrutinised by Hampshire County Council. We've tested 126 HGVs. There are periods when it'll be lower at 90 HGVs. And when we've done the capacity testing, all of the work in the ES looking at fear and intimidation, severance, and not identified any issues that are sort of unacceptable impact, so to speak. I think there is also a point of, clearly when you look at the number on the face of it, the difference between, let's pick 30 and 90 just for argument's sake in those smaller years, it seems like quite a big change, but actually when you break that down across what does that mean by hour of the day, number of HGVs per minute, it's not actually a big difference.
Just on that, because you then did give evidence about that in answer to the questions, the typical journey for a pedestrian and a cyclist would experience one more HGV on their journey. A pedestrian might be 2 to 3, I think, or something of that kind. So that's the point you're just making again. But can I just take that further, because there was a question from, is he the chair or deputy chair of the school? Sorry, I didn't. Deputy chair. Sorry, I forgot. The governor. Sorry, just getting your title correct. Sorry, I forgot. Is it governor of Hamble School? Vice chair. I thought. Sorry, I'm just making sure I didn't massacre your title, which I have done, so apologies. But Vice Chair, there was a question about, well, what about someone walking the full length of Hamble Lane and coming from the north beyond M27? Can I just get you to explain if you know the figures, what level of HGVs they would currently experience, as opposed to what the additional levels of HGV they're likely to experience, if you can do the calculation, just for the same principle?
Yeah, I think just to keep the maths fairly simple, I think we talked about potentially it being a 35-minute journey, but if we just called it a 30-minute journey, to avoid me having to do some very complicated maths on the spot, effectively in a 15-minute journey, we were saying at the moment you'd be passed by 370 HGVs, 370 vehicles. So if you made that a 30-minute journey, effectively you'd be passed by 740 vehicles at the moment, and we would be changing that to 750 vehicles. And in terms of HGVs, it would go from 10 HGVs to around 14 to 16 HGVs.
14 to 16, did you say? Yeah, thank you. Thank you very much. Then, safety of the access, you recall you asked about that. I'm not going to go over all those questions, but just a couple of points of clarification. Mr. Fulbrook put a question to you about safety, saying that it has to be safe for all times and all occasions, not just particular times. You recall that? Yeah. Can I just understand from you, as an experienced transport planner, in relation to safety of design and design standards for access arrangements, are they designed for adults only, or adults and children, or all users? What's the approach?
We design them for all users.
a number of occasions it was said one had to take into account children, the number of children used. You said yes. Is the design of this access in any way different or substandard, as it were, for catering for children as opposed to adults?
No, it's not. I think one of the points, again, designing for the people that are going to use it, we obviously from very early on in the process, identified the high level of use by school children, commissioned surveys that specifically identify the number of children that use it. That was obviously evidence that we put in as part of the plan application, and that the HPDG and Mr. Whittingham subsequently reproduced. And one of the things like the guard railing, for example, that was one of the things that was specifically included as a result of a conversation with Hampshire County Council, to in light of the people that we know are going to use that access.
And just another question that was asked about the numbers of children using it. Taking Mr. Fulbrook's principle, safe for all occasions, is the junction that's been designed in any respects unsafe for, say, 49 people crossing within the particular time period as opposed to 2 or 3?
No, I think we've designed it, from whether it's the size of the island in the centre. I think I mentioned it when reading through the sort of summary brief at the end, but we specifically designed the size of the island in the centre, for example, to cater for the number of children. But I think it's safe for small numbers or high numbers of people to cross.
Thank you. And then, can you help with this? It may be more of a CMX operational question for Ms. Pearman in due course, but just in terms of the suggestion that was put to you about vehicles rushing out before the restriction time comes in at 8 o'clock. So I think this contention is there would be a big surge in the numbers of HGVs exiting the site between the hours of 7:45 and 800. Do you remember that suggestion?
Yeah, I do remember that.
Can I just, if you don't know, but in terms of what the vehicles are doing and coming into the site, whether that's and what they have to do in terms of being weighed, etc., whether that's a realistic proposition?
I think the point I made was about, you've got to think that these vehicles aren't all coming from a destination that is very local to the site. They are coming from the sort of South Hampshire area. There are hours of working that they will start work on the construction industry, then have to travel to the site. I think the sort of proposition where everyone all of a sudden is going to descend on the site immediately before the restriction or be stacked up ready to leave afterwards, it doesn't take into account the reality of where vehicles are travelling from to get to the site. And then also when they turn up at the site, there is a sort of process of obviously drivers reporting in, getting weighed, collecting material, getting weighed on the way out. That effectively will give that staggering of movements.
And in answer to one of the questions that came at the very end of the day, there was this concern potentially of vehicles arriving late and not getting into the site. Again, if you can help with the CMX operation as to whether the types of vehicles and where they're going to is the type of operation where you have overnight lorries or overnight drivers who are camping on the roadside, I think was whether that's what's in contemplation here.
I mean, most of the material needs to go to sort of construction sites, which are ultimately worked. Construction hours are much, much earlier in the day. I think if you go back to the work we did looking at the profile of arrivals and departures from sites, you can see that just borne out by the sort of data, where effectively, in the kind of periods earlier in the day, as you'd expect, you're getting up to sort of 18% of movements within 7 till 8, for example, or between 10 and 11, you're still at sort of 11%. By the time you get to sort of 4 to 5, and you're approaching the period where the quarry closes, you're down at 3.3%. It is low numbers in that period because of effectively the purpose of what the vehicles need to do.
Thank you. And then the road safety audit questions, again, we're not going back over all of it, just a couple of points, please. You dealt with the swept path and what it shows, and can I just deal though with a point of principle? I think the contention is from the Rule 6 party that the swept paths should have more tolerance in them, and you said, well, you could do that, but then you're encouraging just a bigger junction.
Yeah.
As a matter of principle, if the road safety auditor, or indeed the Rule 6 party, required bigger tolerances in the junction, can that be delivered if it were necessary?
Yes, they could be provided, yeah.
Do you think it's necessary
No, I
to
don't think it's necessary, no.
adjust the detail of the design in that way?
No, I don't think it is necessary to adjust it, and I think I tried to make the point that when we're designing things, you don't want to over-provide space because ultimately you do then encourage people to drive faster. So I think we're entirely comfortable with what we've designed, but if it needed to be, the radii needed to be increased by a metre or so, it could be.
Same point in relation to the location of the crossing point. I know you're satisfied that it's safe as the road safety orders, but there was a suggestion whether you should have relocated it further into the site and then you can direct people there with railings and then they divert and cross. Again, I know you don't think it's necessary, but if it were considered required, could it be done?
Yeah, it could be done. Effectively, you would just return the footway around the radius on the northern side, cross people over, and then there's already the pedestrian route into the site anyway on the southern side to get staff in, so it could easily be done, and just relocate the tactile paving and carry that guard railing round.
And I think penultimately just the GE Aviation decision, you asked a number of questions about that and you gave various answers about the differences. I think 2 points. Mr. Fulbrook converted the delays into percentages. Do you remember that?
Yep.
I don't think that's the way the inspector did it in the decision.
No, the inspector just refers to effectively the time increases in absolute terms.
And can I just test with you, Mr. Howard, whether converting them into percentages is a helpful methodology? So if I have a 0.5 second delay currently, and it becomes a 5 second delay, I think that's I'm going to get my maths wrong, but like a 500% increase. But does converting it into a 500% increase rather than a 10% increase tell you whether the delay is in fact a material one or not?
No, I think you can get exactly the point you've made. Mathematically, you can get very large percentage increases because effectively you've got a small base on it. So no, it's not a comparison the inspector made.
By contrast, what you did put to the inspector was the baseline, the existing baseline delay, and then the increase to the delay. It tested against that. How does this proposal compare to GE Aviation?
Yes, I think we were adding at the Portsmouth Road junction, we were adding 17 seconds. That's maximum delay, so that wasn't the average delay. We did go through this yesterday, but we were adding 17 seconds maximum delay in the busiest period, again, worst case assessment. Whereas for the GE Aviation decision, it was about a minute, and it was a similar increase in terms of delay at the Tesco roundabout in the evening peak, where they were adding a minute delay, and we're adding 5 seconds, I think it was, in maximum.
And in your answers, you also pointed to the average delay, 1 to 3 seconds, I think, in most cases. Is there? I don't know if I can see it from the GE Aviation. Is there any identification or consideration of whether the inspector there was considering average delays or maximum delays to allow you to make that comparison?
No, the delays referenced in the decision are all maximum delays, which is, we've made that comparison obviously to our maximum delays. But yeah, the maximum delays can sort of skew your interpretation of how, what the impact is and how that's actually experienced by most people travelling along the corridor, which is why we've gone through a sort of process of working out the average delays, which are all listed in the Statement of Common Ground.
Finally, loss of immunity by reason of the change. You've already dealt with intimidation, safety, etc. Someone finally in the last exchange with you late last night talked about or asserted a loss of immunity. Can I just get you to respond, Mr. Howard? Do the changes in traffic that you're identifying, even at the maximum level, do they materially change the amenity of the experience of using Hamble Lane in your view?
No, the IEMA guidance that gives advice on assessing things like immunity, fear and intimidation, it's effectively got large, which are quite large bands of traffic, which gives ranges, and when we've gone through and assessed those in the ES, we don't change those existing categories effectively. So,
thank you very much. No further questions, sir. Thank you.
It's not the right time for me to ask a question, but I'm going to ask a question just to see if my understanding is correct. At the 278 stage, and the detailed design stage of the access. My assumption is that would need to go through a further safety audit.
Yeah.
Am I correct?
Yeah, that is correct. Yeah. So when we submit a 278 package for technical approval, there is then a huge raft of documents that have to go in. You do a stage 1 audit, which is what we've done at the planning stage. Once you do the detailed design, show all of your construction details, you do a stage 2 audit, and then once the scheme is effectively substantially complete, you do a stage 3 audit. And then there is also the opportunity for a stage 4 audit, which is effectively allow it to have a kind of bedding in period and go back and work out if there are any further works that need to be done. So yeah, there is a long process yet to come.
Okay, so there's 3 more audits to be done at various stages of design, construction.
Yeah.
You just tell me about the stage 4.
So 4 is effectively after a period of time. If you need to or want to, you can go back and do an audit. Sometimes after a month, sometimes after a year.
Okay. Thank you for that, Mr. Howard. I have no further questions. We'll take a brief pause, not a break, but a brief pause while Mr. Howard removes all his equipment from the witness table, and Miss Kirby-Hawkes takes place at the witness table. So we'll just take a moment of contemplation or whatever until that happens.
So while Ms. Kirby-Hawkes is preparing herself, I can say that the documents that we'll need for the examination in chief are CDK 30, which is her main proof of evidence, and K32, which is the appendix A to that proof.
Okay, welcome to the inquiry, Ms. Kirby-Hawkes. Mr. Lewis, could you please introduce the witness to the inquiry?
Certainly, sir. So I'll introduce the County Council's witness in the appeal, that is Lisa Kirby-Hawkes. Lisa Kirby-Hawkes is Head of Development Management and Flood and Water Management at the County Council. Ms. Kirby-Hawkes, you're a chartered town planner. You've over 24 years' experience in the public sector, largely in roles related to minerals and waste planning. You became the case officer with responsibility for the planning application in September 2022. You're also familiar with the history of the site allocation of Hamble Airfield within the local plan, and you tell us more about your relevant experience and expertise in section 1 of your proof of evidence. Can you confirm that your professional background and experience that's set out there in section 1 is accurate and up to date?
I can confirm that, yes.
So, Ms Kirby-Hawkes, we'll take the bulk of your evidence as read, given that we are at a relatively late stage in the inquiry. But I'll just ask some questions of clarification, confirmation, if I may, given the somewhat unusual position that the County Council is in this inquiry of not or no longer actively contesting the appeal. If we could go to section 5, please, of your proof of evidence. We see that you set out there the reasons for refusal as articulated by the Council's regulatory committee. And you'll see there in 5.1.1 the original 3 reasons for refusal fully cited. We don't need to read out those words, we're familiar with the contents. But can you help us, please, Ms Kirby-Hawkes, with what you understood and still understand today to be the significance of the words "on the basis of the information submitted" at the start of each of those reasons for refusal? What do you say that wording tells us about the nature of these reasons?
Thank you, Mr. Lewis. Yeah, essentially what we're looking at there is on the basis of the information at the planning application stage, the planning authority couldn't support the application for the reasons outlined. It's nothing to do with the acceptability of the site. It's about the information that was submitted as part of that process.
Then at paragraph 5.1.2 of your proof of evidence, you summarise for us what has happened in the course of the appeal. You tell us at 5.1.2 that the Council accepts that significant additional information provided by the appellant with its appeal has resolved the issues raised in the Council's first and third reasons for refusal. However, the Council's second reason for refusal remained outstanding when the Council published its statement of case. Since then, the provision of further information by the Council as local highway authority has satisfied the Council as planning authority that its second reason for refusal has also been overcome. One of the questions asked, Ms Kirby-Hawkes, by local people is, how did we get from the position of the Council's regulatory committee refusing planning permission for those 3 reasons that we have just looked at, to deciding in the course of this appeal no longer to maintain those reasons for refusal? Some local people have pointed out that the Council's regulatory committee didn't meet again to vote on withdrawing those reasons for refusal. Can you explain briefly to us why the Council dealt with the reasons for refusal in the way that it did in the course of this appeal?
Thank you, Mr. Lewis. As we know, the regulatory committee is responsible for making the decision, or was responsible for making the decision on the planning application. And when the appeal was submitted, the applicant, or the appellant in this case, had an opportunity to try and address those reasons for refusal. And that is what they have done with the submission of additional information. The regulatory committee's role essentially ended at the decision, and there is no constitutional requirement for us to report back to the regulatory committee. And that's a standard approach for all planning appeals. There are a number of appeals that the regulatory committee have dealt with over the years, and we've never reported back to the committee because there's no constitutional requirement for us to do so. Having said that, I did brief the chairman of the committee as our case evolved, and as for the reasons outlined in our statement of case and thereafter our proof, our case then formed on the basis of the new information before us. We essentially had a position in front of us that we could no longer resist the appeal because the evidence was showing us that the reasons for the refusal had been addressed.
Section 6.2 of your proof of evidence, you refer to the emerging partial update to the Hampshire Minerals and Waste Plan, and that it was subject to public examination in February of this year. Given the passage of time, Ms Kirby-Hawkes, since the proof of evidence was drafted, where are we now in relation to that partial update? Any update of the position from what you set out there in your proof?
Not particularly. The examination took place in February. The planning authority is now in the position of preparing main modifications to the plan, which will be consulted on later this year. So we're in a case that the examination is still live and open on the minerals waste plan, and those main modifications are being prepared.
Thank you. Section 7 of your proof of evidence is then when you set out the Minerals and Waste Planning Authority's case. On the question of need, we've not heard all that much about this particular issue yet in the course of this inquiry. For the benefit of members of the public, could I ask you please just to read paragraphs 713 and 714 of your proof of evidence by way of encapsulating your evidence in relation to need?
Certainly. Paragraph 7.13 goes as follows. Paragraphs 235 to 253 of the regulatory report, CDE1, sets out the officer's position on need and the land bank for sharp sand and gravel at the time of the decision. In summary, officers recognised, based on data from the 2022 LAA, which is CDK26, that the land bank requirement of a minimum of 7 years of permitted reserves, as required by the relevant paragraphs of the MPPF, as well as Policy 17, which is aggregate supply and capacity source of the adopted Hampshire Minerals and Waste Plan, core document H8, was met by existing quarries with planning permissions for mineral extraction in Hampshire. However, for the reasons outlined in the Regulatory Committee report, as well as the LAA 2022, there are acknowledged pressures on the certainty and location of existing supply which also need to be considered. Paragraph 253 of the Regulatory Committee report explains that the majority of existing quarries in southern Hampshire are clustered to the southwest of the county. These sites serve wider areas, including markets in the urban area around Poole and Bournemouth. Furthermore, paragraph 244 of the Regulatory Committee report notes that the majority of current sand and gravel reserves in Hampshire is contained at one site, and that's Blashford Quarry in Plumley Wood. This could have implications for the future supply if any issues with extraction at the site were encountered. The mothballing of existing quarries and the lack of implementation to date of other sites with planning permission is also an important consideration impacting the security of the supply. The second paragraph goes on to say, the Regulatory Committee report stated that it was clear that the site could feed the South Hampshire market area where there is a known need for minerals, and the site was not located in proximity to any other quarries. Officers considered that the proposal would be able to provide mineral to the geographical areas around the eastern side of Southampton and the western side of Fareham and Portsmouth by making use of road connections to the M27. Therefore, having a site located in South Hampshire would shorten the journey times of HGVs that would otherwise have to travel further, making it a more sustainable way of supplying aggregates to these areas. While no specific need to meet the minimum 7-year land bank requirement was identified at the time of decision, the need to be cautious about existing supply means that the proposed site would help to secure a steady and adequate supply of aggregates for South Hampshire, whilst also contributing to continued maintenance of the minimum land bank of at least 7 years. The position of the Council on this matter has not changed. It has also been agreed between the Council and the Appellant in the Statement of Common Ground, which is CDD 18.
Thank you. I'm going to take the rest of your need evidence as read, subject to just checking on one factual matter, please, which is your paragraph 7.1.12. In this paragraph, you refer to planning applications that were currently then being considered by the County Council when you wrote your proof of evidence. And you refer to Table 11 of the 2023 LAA highlighting that applications are currently under consideration at Purple Haze, Ashley Manor Farm, and the appeal site, giving a total of 7.2 MT of mineral currently being considered. and then you go on to tell us a little bit more about those particular applications. Is there any factual update, Ms. Kirby-Hawkes, in relation to what is set out there on the applications being considered, or is all of that still up to date?
To the largest extent, that is all up to date. The Purple Haze application hasn't progressed any further since the proof was published. We are waiting for the resolution on the Ashley Manor Farm quarry, which was the last quarry that went through the regulatory committee. And the Warren Heath application is subject to a significant Regulation 25 request.
So no material changes in effect?
No material changes.
Section 7.2 of your proof of evidence, you deal with highway safety and the free flow of traffic. Now, we know the inquiry's covered those matters in detail with the experts yesterday and re-examination this morning. I don't propose to cover that topic again with you now, save in relation to this issue of the £500,000 contribution to promoting sustainable transport modes on Hamble Lane. We know that there is a process of further verification ongoing in relation to that figure. But just help me with this, please. The full detail of your position in relation to the SIL compliance, and by that we mean compliance with the tests. They're also policy tests, but they're now also set out in Regulation 122(2) of the Community Infrastructure Levy Regulations of 2010. You set out from 7.2.12 onwards the full detail of your position as to why you're satisfied that the contribution complies with those tests. Some local people have asked questions about how the council as planning authority went from a position of still not being satisfied about the level of information provided in relation to that contribution when it drafted its statement of case for the appeal, to then stating in its proof of evidence that further information provided by the appellant in the course of the appeal process had satisfied the council as planning authority that the contribution would meet the relevant tests under the SIL regulations. So the question in short, Ms. Kirby-Hawkes, is what changed? What changed? Appended to your proof of evidence at Appendix A, and this is CDK 32, is the additional information provided by the Highway Authority in relation to the contribution. Could we go to page 4 of that document, please? I don't think the pages are individually marked with page numbering, but if we go to internal page 4 of that document. So having set out the background and the request for further information, there's a section there beginning. Can you see a response to additional questions of clarity on the proposed mitigation scheme? And there the Highway Authority sets out, following independent legal advice, the Planning Authority is seeking further detail on the mitigation scheme itself and has sought further information from the Highway Authority regarding 1, what is needed to be mitigated, 2, why the specific element of the scheme has been chosen and how it has been costed, and 3, how each specific element would mitigate the impact of the development. List ... please list each element. Could you just summarise for us, Ms. Kirby-Hawkes, upon receipt of that document, is there anything here that you'd want to highlight for us as having a particular bearing on the final judgment that the County Council made about whether this contribution complied with the tests?
Thank you. Yes, as you can see in that document, the Highway Authority has responded on those 3 points, and so we were provided with additional information on those factors at the point of this document being made available to us, and most of which we hadn't had in any particular form to that point. So those additional pieces of information gave us more certainty that the tests and the regulations were being met, in particular with regards to the level level of costings of some of the other alternative schemes, that gave us more certainty that the level of mitigation was considered to be reasonable. It's important to note here that this is the biggest financial contribution we have, certainly in my time in development management, that we have taken for a minerals extraction proposal. So we needed that certainty that what has been had been agreed between the appellant and the Highway Authority was considered to be reasonable and met the tests. And so on the basis of the additional information provided to us, we then thought we were certainly in a position that we could see that the tests had been met.
Section 7.3 on ecology matters, I'm going to take as read. My final question relates to the planning balance, which you cover at section 8 of your proof of evidence. And in this section, Ms. Kirby-Hawkes, in particular in paragraph 813, you tell us that in your judgment, this is now a case in which the proposal complies with the development plan as a whole, that it's not a case in which reliance needs to be placed on material considerations to justify a grant of planning permission. It's a straightforward case of development plan compliance. In light of the evidence you've heard at the inquiry, Ms. Kirby-Hawkes, has that assessment changed, or does your position on the planning balance remain as set out there in paragraph 813?
My conclusions in paragraph 8.13 remain. There's nothing that has changed from as part of this inquiry.
Ms. Kirby-Hawkes, those are all my questions for you. Is there anything else that you wish to say? There may not be.
Not at this time, thank you.
So those are my questions. I'm grateful.
Thank you, Mr. Lewis. Just for members of the audience today and people listening online, there's a slight change of procedures today because both advocates, so the appellant's advocate and the Rule 6 party advocate, will have the opportunity to cross-examine Ms. Kirby-Hawkes. It will be in the order of the appellant first, followed by Mr. Fulbrook. So you'll hear two advocates today before we go back to re-examination from Mr. Lewis. So a little slight change in procedures today because of how the witness aligns with the case. It's not usual, but that's how we are today. So with that, having said that, Mr. Mr. Strawn, I do appreciate, because I read from your nameplate and not from my mind. And I'll keep thinking of Gordon Strachan, and you know Gordon Strachan. So I do apologise. So Mr. Strawn, could you come into cross-examination?
You don't have to apologise, sir. My own children choose that pronunciation, which is much to my frustration. So, totally understandable. So, thank you very much. Good morning, Ms. Kirby-Hawkes. I have only got a few questions for you, but I hope they're not going to be too difficult. The first is that, of course, this is an appeal against the decision to refuse planning permission, hence the fact that I'm asking you some questions. However, as you've confirmed, the County Council's position, for the reasons you've explained, is now no longer one of opposing the appeal. But can I hope fairly, put it slightly more positively in this sense? The County Council is not identifying any basis for this appeal to be refused.
On the basis of the information before us, yes, we can no longer resist the appeal.
Yes. Sorry, no longer?
Resist the appeal.
Yes, but I know you talk about no longer resisting. As a matter of principle, under the plan-led approach, under section 38(6) of the 2004 Act, I know you're very familiar with that, and national policy, it shouldn't be a case of the county not having grounds for resisting. It should be positively supporting the development because it's in accordance with the development plan.
On the basis of the information before it accords with the development plan, yes.
And so the county should be positively and, according to national policy, speedily approving such proposals.
On the basis it accords with the policy, yes.
Thank you. And I just wanted to, if I may, just deal with the reasons for refusal as they were, for which have since been resolved. As I think you were identifying a moment ago, but we can see from the committee report, CDE1, I'm not sure you need to turn it up, but the committee report carried out an analysis of the proposal in its entirety, correct?
Correct.
And it considered things like need, which you
Correct.
just addressed. It considered things like noise,
That's correct.
air quality, dust, all of the raft of environmental considerations that are subject to technical assessment. And so far as you're concerned, Ms. Kirby-Hawkes, the council and its expert advisors, having done that, is satisfied that there is no reason to refuse planning permission here.
On the basis of the new information put in as part of the appeal, yes, that's correct.
But just what I want to be clear about, it's evident to me from the report and the extent of the advice that was sought that the council has scrutinised all of the technical material that the applicant then, appellant now, provided. Is that
That
correct?
is correct, sir, yeah.
So it's not a case of deferring to the appellant's assessments,
No,
but the council satisfied itself, be it on highways or be it on ecology or impacts on European sites.
absolutely, that is correct.
And as part of that, as I understand it, the council has indeed consulted, for example, Natural England on the impacts of the proposal, as to whether there are any adverse effects on the integrity of any European sites.
That is correct. There were a number of correspondences between us and Natural England.
So far as you're aware, is there any concern on your part that Natural England are unaware or have not scrutinised the proposal themselves?
Absolutely not.
Okay. Can I turn back, though, to the MPPF? This is going to relate to two matters, just so you're clear where I'm going. The first is about those residual reasons for refusal, and the second is to come back to the question of need, which we haven't heard much about. So just so you know where I'm
That's
going.
fine.
But I just want to use the MPPF, so the National Planning Policy Framework, for those who may not be familiar with the jargon. I've got it separately, but it is a CD somewhere. Don't know if you have your own copy, sir, but can I just ask you a few questions about this in terms of the correct planning approach to adopt? Before we get on to minerals, which we'll come to, can I just take you back to the very start of the MPPF? And although it may seem obvious, the MPPF sets out at the start the three objectives: economic, social, and environmental. And then that's a paragraph 8. And then paragraph 9 identifies planning policies and decisions should play an active role in guiding development towards sustainable solutions, taking into account local circumstances to reflect character needs. Just looking at what you were referring to in terms of the local plan here, the Minerals and Waste Plan in 2013, and the emerging plan in due course, has that process been done, to your knowledge, in allocating this site, both in 2013 and proposing it for allocation in 2025?
Would you just mind just clarifying that last bit of the question, because I wasn't quite sure.
The planning policies, in this case allocation of the site, do they or have they played an active role in guiding development towards a sustainable solution?
Yes, so obviously the adopted mineral and waste plan policies were used as part of the decision-making process when the regulatory committee was undertaking the decision. At the point of decision, the minerals and waste minerals waste plan update was only emerging, so no significant weight was applied to that.
Okay. Well, that's helpful. But just to give you the reference I was talking to a moment ago, but you confirmed anyway, but paragraph 11 of the presumption in favour of sustainable development for decision taking, paragraph C, approving development proposals that accord with an up-to-date development plan without delay. That's why I took you to task a bit for saying, well, we can't find grounds for resisting it. It should be more positive and proactive in positively supporting this proposal where it accords with the policy, shouldn't it?
That's what the National Planning Policy Framework says, and obviously for the reasons already outlined at the time of the Regulatory Committee decision, there were issues with the information before the Planning Authority which have now been resolved.
Thank you. And I'm not going to take a lot of time about this, but just if you turn to the plan making section, chapter 3, we can see the object of plans on paragraph 16, again, prepared with the objective of contributing to the achievement of sustainable development. And you've explained why the allocation here is intended to do that. If you just go down, though, please, to paragraph, sorry, I've just lost my, apologies, paragraph 39 under chapter 4. Local planning authorities, i.e. Hampshire County Council in this case, should approach decisions on proposed development in a positive and creative way and use the full range of planning tools available and work proactively with applicants to secure developments that will improve the economic, social and environmental conditions of the area. And decision makers at every level should seek to approve applications for sustainable developments where possible. Pausing there, given that it's agreed by virtue of the technical assessments that this is sustainable development for various reasons, decision makers, the county council, and indeed, I assume this may apply to the inspector, but the advice here is that one should approve the applications where possible.
Where the evidence is showing that they are acceptable, yes.
Yeah. But it just goes a stage further, doesn't it, this advice? Because where you've got an allocated site for development and one's seeking to address matters of detail about the application, the local planning authority, that's the council, is required to act in a positive and creative way, not a negative and obstructive way.
Correct. I mean, obviously, as a site allocation, the site has some weight, but the key position for the planning authority at the point of decision was whether the application was acceptable to meet that site allocation requirement.
Yeah, that includes, as saying, using the full range of planning tools available. That would include, for example, use of conditions or 106 obligations in order to address issues if they arose, rather than refuse planning permission if they can be dealt with in that way.
Agreed. If there were circumstances where conditions were considered to be reasonable and acceptable, that is the case. Certainly in the case, for example, with reason for refusal A, which was in relation to flooding, that was not considered to be acceptable.
Well, I'll just take it one stage further. It would include going back to the applicant for further information, being positive and creative, suggesting you do this and then it becomes acceptable. That I'm not going into the detail, but that's in principle, that's what this advice is telling a local planning authority to do.
Agreed.
And that also applies to consultees, doesn't it? If you go down the paragraph 43, paragraph 42, looking at the second sentence, for their role in the planning system to be effective and positive, statutory planning consultees will need to take the same early proactive approach and provide advice in a timely manner throughout the development process. So whether it's the local lead flood authority, Natural England, or the highway authority, as the county council, also a highway authority, they're under an obligation to provide information, do it in a proactive way, and provide solutions for sustainable development, aren't they?
That is correct, yes.
Yeah. And it's not simply for the appellant to, if it's were chase the highway authority to provide more information. The obligation's on the highway authority.
Agreed.
And that's consistent with paragraph 43, where there are other consenting bodies.
That's correct.
Thank you. Thank you. And I'm not going to go into the rights and wrongs of, you're aware of our position that those outstanding reasons for refusal weren't matters where those bodies did either come back to us and ask us for information before determination or provide us with information that you were requesting, for example, from the Highway Authority about their contribution. You're aware of that, but I'm not going to question you about it.
I'm aware of your position.
Other than to understand the context that we've looked at with national policy, so that's helpful. But the other theme I said I was going to get to was the relevance of the national policy on the question of need. Mm-hmm. And Ms. Kirby-Hawkes, we obviously agree with you about need for this, but I just want to understand whether the full extent of the need has been identified in your proof and indeed in the local authority documents. Mm-hmm. I know it hasn't escaped your notice or many others that this MPPF has a very significant emphasis on the delivery of new housing nationally.
That's correct.
And so I know you'll be very familiar with that, but this MPPF introduces a standard methodology for the calculation of local housing need that applies again nationally.
That is correct.
Yeah. And we're agreed, aren't we, that the mineral that we're concerned with, the inspector's concerned with here, is a mineral required for the construction industry for, amongst other things, new housing, roads, schools, any form of concrete infrastructure of that kind.
That is correct, and that's also reflected in the local aggregates assessment.
Yeah, well, that's really what I wanted to touch on. I'm taking as a given your acceptance as to the need, mm-hmm. and not just the need for the county, but a specific local need which you've identified in this location, mm-hmm. bearing in mind its proximity to urban areas. Mm-hmm. So I'm not going to question about that because we're agreed about that, but I just want to understand the full extent of the needs being understood. If we turn up, please, the latest local aggregate assessment, dated 2023, but was revised, I think, in February 2025.
That's correct.
Which is a core document. I'll just give you the reference to it. And you need to keep the MPPF, I think, there. Sorry, just
got it.
But to have too many documents. K27. So. And just important, I think, to understand the extent to which the LAA in its latest form takes account of what we're agreed, I hope, Ms. Kirby-Hawkes, is a massive upsurge in required construction if one's to meet national policy mm-hmm. requirements on housing.
Yeah, I think the LAA doesn't reference the big upsurge in the way that the next LAA will, because obviously this is a covering a period in advance of the publication of those new modelling requirements. But the LAA already says in that section, so from paragraph 7.7 onwards, it already references the need for aggregate to build homes and the fact that mineral is required to do so.
Yeah, well, can I forgive me if I just want to trace it through to see if that's fully reflected. If the inspector wants to see what's in the LAA future aggregate demand, you can turn to section 7 of that document, page 26.
Correct.
And there the inspector will see that there are 7.1 housing and transport infrastructure projects placing additional demand on future aggregate supply in Hampshire. It refers to 120,000 new homes planned within the Hampshire area over the next 15 years. And then there's a footnote 12. And if we'll go down to footnote 12, that's based upon the Hampshire Strategic Infrastructure Statement of 2019.
That's correct.
And that, but it's not a criticism, but that 2019 statement is not taking account of the massive increase in housing required for Hampshire, amongst many other areas, but Hampshire, which I'll come to, in terms of the future aggregate demand.
That is correct. It doesn't reflect that.
And therefore, as things stand now, because of the MPPF being in effect, if the inspector wants to know whether this LLA takes account of that future, I say future, it's upon us now, as I understand it, in the Survey Hawks. But if you go to housing, there's a housing section that's 7.7. Paragraph 7.17, the aggregate demand is based upon that 2019 infrastructure requirement. 7.17 flags up the new world we're living in. The new government has announced an overhaul of the planning system with a view to increase house building. There's a reference to July 2024. A revised housing method is being proposed to calculate the required delivery, which has resulted in a significant increase in housing figures for many areas of Hampshire. Many districts and boroughs are suggesting the revised figures will be a challenge to deliver. They're not optional, are they?
Not to my knowledge.
Having demonstrated a correlation between aggregate demand and housing completions, a significant increase in delivery could signal a need to increase demand, but it's not yet clear when the demand will be established through updated local plans and/or planning applications. So it's clear from that this LAA is not rising to the challenge of identifying the scale of the additional need, is it?
It's identifying that the revised housing method will be proposed to take into account the new figures. Some of the aspects you are relating to me at the moment relate to the emerging plan, where greater monitoring flexibility is going to be added into policy 17 to ensure that if there is an uplift in required demand, that the policy can respond accordingly. I'm by no means the expert on the emerging plan. I've been involved, but I'm not the lead on it. But there is flexibility in that plan as it is emerging to deal with any increase in demand.
Yeah, well, I'm not going to ask you so much about the emerging plan. It's more about this extent of the need now. We're already agreed that there's a significant need for this proposal now based on this LA approach. But I'm just testing what is already upon us as to how big the increase in that need will be. If you turn to Ms. Pearman's proof of evidence. Paragraph 628.
Okay.
Have you got that?
Yes, I have.
What Ms. Pearman's done is identify the established standard methodology uplift figures in requirement for each of the Hampshire local authority areas, so that they're known figures, aren't they?
That's correct.
And you don't dispute anything she said in this table.
I do not.
And if we look at that, well, the only area where there's a slight reduction is Southampton in terms of the standard methodology figure.
Yeah, I can
But
accept.
for places like Eastleigh and indeed all the other Hampshire areas, Eastleigh it's a 42.9% increase. Over the page you can look at all of the areas in Hampshire. The 51.3% increase in housing requirements for Hampshire,
Correct.
over and above what's already planned, that is. And you can see the number of additional houses per year for Hampshire is 4,234. And indeed for Eastleigh alone, it's 277. And she then at 629 just gives you a rough benchmark figure. Second sentence, the Mineral Products Association estimates around 200 tonnes of aggregates and associated mineral products are needed per new house constructed. Do you have an issue with that?
That's in line with what I've seen from the MPPA, yes.
So it is fair to say, isn't it, on what we know now and in what is now current policy, there is going to be a very significant need, in addition to that which has already been identified, for new aggregates of this type for this locality.
That's correct.
And I say very significant, it's going to make a very large hole, I say hole, but however you want to describe it, in terms of needing to find additional aggregates.
Aggregates will be needed to deliver the housing requirements, yes.
So there can't, I was going to suggest to you, Ms. Kirby-Hawkins, there cannot be any doubt, there wasn't already in your own proof, but there can't be any doubt, can there, as to the need for this site to yield what it does by way of sand and gravel for just a contribution towards what's going to be required for the county council's area.
Yeah, and to meet the provisions of the adopted plan.
And in terms of the environmental cost of not doing that, as you pointed out, that means one has to import from much further afield. As I understand your evidence, Ms. Kirby-Hawkes, bear in mind controls that can be put on the extraction process, which will satisfy, can regulate impacts on people who live in the area, as compared with introducing or shipping in or importing the minerals. There is an can I put it in this way, there is an overwhelming case for granting permission for this scheme now, bearing in mind that need that's existing.
On the basis of need, yes.
Let me just check my note. Thank you very much. I haven't got any further questions.
Thank you, Mr. Straw.
Thank you, Mr. Straw. We're at 11 o'clock. I'm just wondering whether that's a good time to take a break, Mr. Fulbrook.
Yes, I think excuse me, I think that would be an appropriate time as far as I'm concerned to take a break. Yeah.
All right, and then we'll come straight back with your cross-examination then. It's now at 10:58. I'm suggesting we have a 15-minute comfort break and a coffee for those that want one. If we resume back in this room at 11:15 sharp, the inquiry will resume at that particular point. So at that time, we can now stop the recording and we'll take a break. We're now adjourned. Well, welcome back, everyone. It's 11:15. The inquiry is now resumed. We're going to go straight into cross-examination of Miss Kirby Oakes by Mr. Fulbrook. I see you're just getting some things ready, Mr. Fulbrook. There's no rush when you feel comfortable and ready.
All ready, thank you, sir.
Thank you.
Good morning, Miss Kerry Hawkes.
Good morning.
Now, clearly the inquiry's already heard detailed evidence about ecology and highways matters, and you'll be aware that my clients disagree with the Minerals and Waste Planning Authority about those issues, that we say there are reasons for refusing this permission. I'm not proposing to go through all of that detail with you, you'll be pleased to hear, because the inquiry's already heard that. But I do want to spend a little bit of time just looking at the second reason for refusal that the council, this is the one that the council maintained up until I think it was about March of this year. And so that's in your proof of evidence. Sorry, I should have said that in terms of documents, I'm principally going to be looking at your proof of evidence, Ms. Kerry Hawkes, and then I'm going to take to your Annex A as well, and to the LAA, which obviously you should probably have already got open. There may be a couple of others, but that's a sort of list for now. So your proof of evidence, section 5, please.
Yeah.
Yep, so that sets out the reasons for refusal. And the second one, B, obviously we've been through this, but it was the view of the Minerals and Waste Planning Authority on the basis of the information available that the proposal was contrary to policy P12 managing traffic of the 2013 plan and policy S11 of the Eastleigh Borough plan, insofar as the identified adverse impact of the development on the highway network would not be satisfactorily mitigated and the development would not promote sustainable transport modes. So just a couple of points about that. I mean, the first is, I assume from that then, that it was that, I'll come to need in more detail in due course, but it was the position of the Minerals and Waste Planning Authority that, having identified some adverse highways impact, that the need for this development was not such as to outweigh or overcome those impacts.
On the planning balance, it
Yes.
was considered that the issue with policy 12 in relation to the proposed mitigation not meeting the regulations meant that that was the case, yes.
But yes, exactly. So just to be clear, on the planning balance, you found that the breach of policy in terms of highways, and that breach was not outweighed by, for example, the need for this particular development.
At that point, alongside the other reasons for refusal, yes,
Yes, and that was obviously the case up until March of this year.
that's correct.
And the reason why the council changed its position on that was to do with effectively you having been provided with what you say is more clarity about what the £500,000 contribution would be used for and how it had been calculated. Is that correct?
That is correct.
It was not to do with any changing view as to the nature of the need for this development.
The need has already been identified in my proof.
Yeah.
It was specific to the fact that we had new additional information which gave us certainty that it met the regulations.
Thank you. So obviously I did take Mr. Howard through some questions about the £500,000 figure, and I know that there is work underway between Mr. Whittaker and Mr. Howard about that. But I just want to understand your thought process, if you like, in relation to that, if I may, because as you have recognised, it's a matter of concern to the local community.
Of course.
Now, I suppose the first question about that is, I think you said in your evidence in chief that the £500,000 figure is the most that you have, to your knowledge, has been required for a minerals development. Is that right?
Certainly in my time at the council.
But I suppose the question is not whether it's the most that you remember, but it's about whether, obviously, this is an amount which is reasonably required to make the development acceptable in planning terms. Do you accept that?
Absolutely correct.
And of course, it could not also be the case that one of the reasons why this is the largest contribution that you recall is partly because this is a particularly sensitive or atypical site for development of this nature.
The key thing is whether it can be mitigated and on the basis of the proposal that's been put before us.
Yes, and the reason why the mitigation requires the largest sum that you can recall is because I suppose in the council's view, is the most to mitigate, I assume, than has been the case previously.
That's your words, not mine. It's the most that I have seen in my experience. I'm not going to clarify anything more about whether it's to do with the severity of the impact here. The key thing here is that it's about whether the proposal can be mitigated with the scheme before us.
Okay. Now, in your proof of evidence, you went through this morning the process that you followed to seek further clarity about the £500,000 figure, because it's obviously a matter that troubled you for quite some time.
That's correct.
And I think at 7.2.16, you explain that you sought some further information from the county. 7.2.16, you sought some further information from the County Highway Authority about that.
That's correct. 7.2.16 refers to how it was referred in the regulatory committee report. Subsequent to the decision, we have obviously then requested further information as part of the inquiry process.
Yes. Now, just the table 3 there, obviously this is a table we've seen before, because this was a table that was also included in the regulatory report as well. And as you can see, the cost of work there refers to 200 metres of new shared surface plus crossings. That's right.
That's correct, yeah.
Now, it's obviously been suggested by the appellant that that was a typographical error and it should have referred to a larger amount of shared crossings. Given that this table appeared in the committee report, which you were the author of, can you tell us whether you made a typographical error or not?
The report was provided to me by the Highway Authority, and it says very clearly in the report that that was the case. My understanding, and certainly I've sought assurance from the Highway Authority, that that is a typographical error which does not impact the outcomes of the mitigation that's been proposed.
Okay, so
And obviously that's been dealt with the new additional information that we discussed yesterday.
well, we'll go to the new additional information in a moment. But certainly it was, forgive me one moment. Yeah, so let's go to that new information now. So that's Appendix A to your proof of evidence, which is, I think, core document K32.
Yep.
Do you have that? And this is the document that you say provided you with further clarity and assured you that, I assume that where there was a reference to 200 metres, that was a typographical error.
Again, this document was provided to us by the Highway Authority, so it's very clear with regards to that. The clarification on the typographical error has come following the publication of the proof.
So at the time that you wrote your proof and you were satisfied that the £500,000 was the correct amount, you understood that that was for 200 metres of shared pathway, is that right?
On the basis of what the Highway Authority provided me, yes. I just need to clarify that the negotiation on the mitigation took place between the appellant and the Highway Authority. I was not party to those discussions, so I was provided with the information by the Highway Authority and then considered it.
I understand, but I think it just seems strange to me that, given that you were so keen to establish whether this was the correct figure or not, that even at the point at which, given that apparently this is a typographical error that's been repeated several times, it's not something that you've identified at any point.
Nope, we obviously sought clarification from the Highway Authority subsequent to the proof being published, as I've already said.
Okay. So when you decided that this wasn't enough, that the £500,000 was enough, you didn't actually know how much mitigation was to be provided then, because you would have known that 200 metres was the wrong figure if you'd known that.
We had the information, obviously, the plans that had been provided behind the scenes, obviously, but again, it comes back that that is a typographical error.
But those plans, we've looked at them in the context of the statement of common ground between the Highways Authority and the appellant, show at least 741 metres of shared path. So I just don't really follow what you're saying, because you're saying you knew about the plans, and also we know they show 741 metres. But on the other hand, in your proof and indeed in the appendix to your proof, you can see quite clearly that that costing appears to be based on 200 metres of pathway. So at no point did you realise then that there was a contradiction there?
Not to the, well, until after publication, that's correct.
Right, okay.
Yeah.
And then after publication, what happened? You realised and then you asked?
There was further clarification being sought through various freedom of information requests and discussions with the appellant. And obviously we saw some of the outcomes of that yesterday.
Okay. Can I just take you then to inquiry document 2?
Sorry, just bear with me just before I get it up. Okay.
Yeah. And then the last page of that, there's an email which I took Mr. Howard to yesterday.
Yes.
Okay. And obviously you can see that that's an email from what I assume is the County Highways Authority. It's not from you, is it?
I can't possibly comment on that. I've not seen, I don't recall sending that. I would assume it's from the Highway Authority, but I can't tell you whether that's correct.
So it could have been you who sent it.
Sorry?
It could have been you who sent it then.
I don't believe it was.
Okay. Somebody from the council sent that email, and you can see there that it's clearly states that the cost for 200 metres of new shared surface is forecast to be £460,000.
I can see that. Yeah.
So that surely, I mean, obviously you've been aware of this document for some time. That surely demonstrates quite clearly that there's not a typographical error, in fact, because this is what was being said all along, and this was sent before the regulatory report was written. It might even be the email which you based the report on.
I don't believe it was, but the key point is I can't answer for the Highway Authority. The Highway Authority have been involved in these negotiations. I take what you say there because I can see it in front of me, but I can't comment on this in relation to the Highway Authority because I am not the Highway Authority.
So just to be clear then, despite the fact that this email seems to make it as clear as day that they were initially were thinking about 200 metres, and then despite the fact that the 200 metre figure is repeated not only in the regulatory report, but also in Appendix A to your proof, which was information that the Highway Authority sent to you, so it's repeated again, you genuinely believe that it was a typographical error, and you do not accept that there has been somehow an expansion in the amount of work to be delivered with no apparent corresponding expansion in the cost.
I do not believe that. I believe that it was a typographical error, yes.
Okay. And obviously, the County Highways Authority has not decided to answer that. They've not decided to explain how the typographical error was made, and you don't know. Did you ask them?
I think it's clarified in the report, the letter that was distributed yesterday, and I have had assurances from them about it being a typographical error as well.
Okay. If we go back to Appendix A, to your proof.
Of my proof, yeah.
Yeah, no.
Okay.
If you look at page, this is not paginated, I'm afraid, but I think it's internal page 6, the PDF 6, where there are a few examples given of costings.
Okay, yes.
You've got that. So, and it's introduced by the Highways Authority. It said to provide some further context for the Planning Authority, the following schemes which involve walking, cycling, and cycle provision were undertaken with the associated costs. And can I just be clear, in relation to what you knew about the details of those schemes, this was all that you were provided with by the Highway Authority?
This appendix is what was provided to us, yes.
Nothing
correct.
else?
Nothing else.
No, okay. So, and did you use this, did you, to decide that £500,000 was an appropriate figure, did you?
A reasonable figure that met the
okay.
regulations.
So obviously, just looking at then at the cost of some of these, Elmley Road here, that's delivering 450 metres of path, segregated cycle track. That's £1.5 million. £500.
Yes, that's correct.
Okay, so that's not consistent with being able to deliver 741 metres or for £500,000, is it?
The key thing, I think, is the statement after those examples. It does say that cost of these schemes, types of schemes, does vary depending on locational constraints and extent of works. So there are some variations in what's there.
Yeah, but these are the only examples that you're provided with. So we've got example 1, Elmley Road. We've been through that. Many down initial works, 180 metres, total cost 300,000. So again, that's no way near consistent with being able to deliver 741 metres for 500,000, is it?
Again, it comes back down to the different schemes will have different variations with them.
Okay, so Brighton Way, 390 metres, 605,000. So same point really, nowhere near close.
And again, it comes back to the different schemes would be different for different reasons.
Okay, and then Stoneham Lane, 450 metres for 980,000. So same point again.
Same point for me.
Same. Well, which example then did you rely on to decide that 500 metres or the £500,000 wasn't an appropriate figure? Because these are the only examples you've been given. They're all way off. Now you say, well, it says schemes can vary, but you haven't seen anything to suggest that it is possible to deliver.
It was looking at whether the £500,000 was reasonable, and obviously you can see examples in there where there are some regions around that or above it, and we took the view that the £500,000 was a reasonable requirement for the works that have been proposed on Hamble on the basis of this.
But what in these examples led you to the view that £500,000 was a reasonable amount? Because none of them are anywhere close. That's what I don't understand.
That it's about the different, and it's taking into account the different variations of those schemes. What's not in that document is the different variations of the schemes. So why? You
said that you didn't have any. This is all you had to go on. That's what your evidence was. So
we consider the £500,000 to be of reasonable nature for the scheme that's proposed at Hamble, and we use these examples to look to sort of see how much other schemes were proposed elsewhere in Hampshire.
The truth is that the inspector looking at this is the information that he's got to go on. I mean, we've been through it. It simply does not support in any way the figure of £500,000, does it?
I do not agree.
Okay. All right. Well, I'll leave that there. The inspector's got my point. So then, just a question. Really, actually, just for the benefit of my clients, but there have been, I think, in the course of the determination of this application, conversations about a liaison group being set up between the appellant and the parish council. It's our understanding that at the moment there's no formal provision for this in either the conditions or the Section 106 agreement. So, are you able to just explain how that liaison group will be delivered or assured?
Usually when an application is determined by the regulatory committee, if there's a positive recommendation for approval, there will be an informative added to it for the establishment of the panel, and it's something that the regulatory committee is very, very interested in. In this instance, you're quite right, in the most recent schedule of changes for the Section 106 and the conditions, there isn't a requirement, but we are in discussions for that to be added into the 106 currently.
I see. Okay, thank you. So that'll be something that I think there's a draft going to be produced, isn't there? Quite soon.
I believe so. Yeah.
Okay, thank you. Well, maybe I was going to take a note if that's okay. All right, thank you. So just come back to need. I'm not going to go through this in exhaustive detail with you. And obviously, our disagreement to some extent is more with Ms. Pearman because, well, as you've seen from the evidence, but there are a few questions I want to ask based on your evidence, if I may. So you were put a series of questions by my learned friend, Mr. Strawn, about the uplift in housing targets, or the likely uplift in housing targets. Now, just in relation to those, if I could ask you to turn to the LAA, the most recent one, which is core document K 27, I think.
Okay.
Thank you. So you were taken to paragraph 7.17, where the authors of the LAA do discuss the potential effects of the revised housing method. And it's the last sentence where I just want to read to you. So having demonstrated a correlation between aggregate demand and housing completions, a significant increase in delivery could signal a need to increase demand. But it is not yet clear when that demand will be established through the updated local plans and or examination. And sorry, I should have started earlier because I missed out to say the sentence before. A revised housing method has been proposed to calculate the required delivery, which has resulted in a significant increase in housing figures for many areas of Hampshire. However, many districts and boroughs are suggesting that revised figures will be a challenge for delivery. So just in terms of what the LAA is saying about this, it's not saying, is it, that there's going to be some kind of immediate increase in demand for aggregates.
It doesn't say an immediate increase, no, but it's recognising that there could be.
There could be over a period of time, yeah. And of course, the extent to which demand increases does depend on what you can deliver in terms of new housing, doesn't it?
It will be tied to some of that, as well as wider infrastructure, yes.
And that's why this paragraph, for example, refers to potential constraints, delivery constraints, isn't it?
Potentially, I mean, obviously, I'm not a planning authority for the housing, so I can't comment on this in detail, but there is some of that identified in that paragraph.
Yes, and obviously one of the things being said about this development is that it will deliver aggregates, particularly to the local area, the vicinity of the site, isn't it?
Indeed, as in accordance with the site allocation, yes.
Yeah, but we already have heard quite a lot of evidence that there are very serious highways constraints in relation to this area, haven't we?
There's been obviously lots of discussion about highways matters in this inquiry, yes.
And that discussion involved a recognition that, for example, Hamble Lane is seriously congested.
There were discussions in relation to that yesterday.
Yes, and is that something you're prepared to accept as being correct?
I've looked at it. My officer's report says very clearly what our position is in relation to the highway capacity and safety issues already.
Okay. If there are constraints in the local area, that's obviously going to reduce the amount of new housing that could come forward. You know, we're notwithstanding local targets.
Constraints can do that, absolutely, but I can't comment on that any further.
Okay. And then if I could just ask you to turn to paragraph 7.45 of the LAA.
Okay, yes.
That just talks about capacity of minerals sites. It says capacity has broadly stayed consistent over the 3 years with just relatively small deviations. Capacity of land on aggregates has appeared to decrease this year. The combination of the decrease and the higher sales this year has suggested a reduction in headroom, although the sites appear to operate at 60% capacity, so there seems to be ample scope to increase throughput through demand if required. And I think there's a superfluous "it" at the end there. So, I mean, if it's right that there is going to be an increase in demand and sites are operating currently at 60% of capacity, if there is some kind of quick increase in demand, there is headroom. In fact, it says there may be ample headroom, seems to be ample headroom to meet that demand already on the basis of existing sites.
There is headroom, but as we've already identified, the site that's under discussion today is in South Hampshire, where there are no other quarries in its locality.
Okay. Then, if I could ask you to turn to table 3 of the LAA.
Table 3, did you
Table
say?
3. I'll give you a page number for that when I found it. That's page 15.
Yep, thank you, I've got that.
Yeah. So that obviously refers to the land bank and the various and compares it against various APR figures. Yeah. So what obviously that doesn't include is the local requirement. Now, it's the case, isn't it, that the emerging minerals waste plan review sets a much lower local requirement than the current plan. So that's right, isn't it?
That is the case, yes.
Yeah, and I mean, obviously we can go to if you want, but my understanding is that the local requirement for soft sand and gravel in the emerging plan is 0.74.
That sounds about right. I can't remember the figures exactly off the top of my head.
I think I mean that's the figure I've got, but it's roughly around that 0.74. And if you apply 0.74 to the current permitted reserve in that table, I mean I calculate that you get just for sharp sand and gravel a land bank of 12.6 years.
I don't think that's relevant because it's not adopted policy, in my view. I recognise that the Emerging Policy 17 does have variations of the figures that are in the currently adopted Policy 17. As I mentioned this morning, that policy also works into it wider monitoring requirements to ensure there is an ability to react to any increase in demand.
But at the moment, and obviously the plan's being examined and there are new housing targets. Nobody, as I understand it, is suggesting any modification to that reduced local requirement, are they?
I can't possibly comment on that in terms of detail because I'm not party to that discussion.
You're not aware of any?
Not that I'm aware of, but without consulting with other colleagues, I can't comment on that.
Okay, all right. Well, if that is the case, then it does suggest that nobody is unduly concerned about the ability to meet increased demands, or that there's going to be any massive increase in local requirement.
I think if you were at the examination, you might think slightly differently to that comment. The industry is very concerned about the reduction of Policy 17 in terms of the figures.
Okay, well, I suppose you can't really have it both ways. You can't say on the one hand, you don't know if there's any main modifications, and on the other hand, people are pushing for a high figure. We don't know. All we have is what's in the policy here is a significantly reduced local requirement.
For the emerging plan, not for the adopted. The adopted plan is currently the adopted planning policy and was what's being used to determine this planning application.
Yes, and on that, as I understand it, your proof says that there is, or certainly the regulatory report says there is a 7-year land bank.
Yeah, which is a minimum requirement.
Yeah. Mm-hmm. The reduced requirement, is it right to say that the reduced or proposed reduced requirement in the emerging plan also reflects a recognition of the increased use of recycled aggregates in development?
The figures for recycled aggregate have increased in the Emerging Policy 17, as I understand it, yes.
So again, if we're looking at future trends, is it not likely that that's also going to play a significant role in reducing or at least tempering any increase in the requirement for sort of virgin or land one aggregates?
The current plan and the emerging plan obviously very much encourages the use of recycled and secondary aggregates through policies 18 and 30. So there is that encouragement there to try and maximise the ability of the market to have that within the system. It's clear from industry that there is a ceiling to that currently, and it's estimated to be around 30% ceiling for what the kind of proportion of the market can be. But the plan strives to increase recycled and secondary aggregates use in every way it can. But that's not to say that other forms of aggregate requirement, so importation of hard rock, for example, marine one and land one is not required because it's all needed to meet the demands of the plan.
Yes, I mean, it is clearly required, but apparently less of it will be required according to the emerging plan.
Yeah, and obviously we can only enable capacity, we can't control the capacity.
Okay, thank you. Just check one thing a moment. Thank you very much, Ms. Kirby. Those are all the questions I have. Thank you, sir.
Thank you.
Thank you very much indeed, Ms. Fulbrook. In which case then, re-examination questions, Mr. Lewis.
So I don't have any re-examination. I'm very grateful.
Well, that surprised me in the timings now then. For the first time ever in this inquiry, we'll be in front of schedule. Thank you, Mr. Lewis. That brings us with a little bit of a thinking dilemma as to what to do now. We can either take a break for 45 minutes at 11:45 or 12:30 and go straight into evidence of Miss Els, or we can start with Miss evidence. And I'm really looking at, what would you prefer to do? I'm happy either way, Mr. Fulbrook, but it's a break. We can go into it. I don't know where that will take us in terms of what that might mean for lunch, in terms of the witnesses' obligations. I'm entirely in your hands. What would you prefer to do?
Well, I'm just checked with Miss Elson. She's content. I'm content to proceed to examination chief of her, and obviously she'll have to observe her distance from us during the lunch break, which I'm sure is something she's probably very keen to do anyway. So I've no objection. And in terms of timing, I expect, in fact, that I'll be only about half an hour in evidence in chief, so that should obviously, hopefully, finish around about 12:30 latest. So
If you're content, I'm absolutely content with that as well then. So we'll just do some witness swap over, and we'll just pause a few moments from saying anything else. While we're doing that, can I thank Ms Hawkes for a contribution, Kerry Hawkes for a contribution to the inquiry. I try to do that with all witnesses, but sometimes I forget, but thank you for your contribution.
Ready.
Thank you, Ms Else. In which case, Mr Fulbrook, could you please introduce Ms Else to the inquiry?
certainly. So Miss Else, you've produced a proof of evidence for this inquiry along with a summary proof of evidence. If I may, section 1 of your proof of evidence, you set out your qualifications and relevant experience. I'll just check some of that with you, if I may. So you are a member of the RTPI, you hold a Bachelor of Science degree with honours in environmental planning and a postgraduate diploma in town and country planning. After completing your studies in 2011, you joined the Environment Agency before progressing to a planning officer within the development management team at Solihull, Metropolitan Borough Council, and your employment there meant considering planning applications of various scales across the central area of the borough. And that included applications relating to quarries within the Greenbelt, as well as the expansion of Birmingham Airport. You also dealt with applications and appeals relating to major developments for housing, commercial developments, as well as household applications and waste disposal proposals, and you frequently presented to the planning committee. After leaving Solihull, you joined RPS Planning as a planning consultant, where you established a knowledge of planning development and successfully became associate director. You have now more than 10 years experience. You had more than 10 years experience at RPS Planning, and you gained experience in environmental impact assessment for housing, as well as minerals schemes, leading negotiations demonstrating policy compliance and exceptional circumstances. After working at RPS and then Barton Wilmore, you established Claremont Planning as an independent consultancy, and following that you've sought to advise clients on the optimum form of developments achievable in various characteristics, and you are now an established planning consultancy within Birmingham and across England. And in terms of relevant experience, as you said, throughout working at the Environment Agency, and as a consultant you've had extensive experience with mineral proposals, and that's included assessing the appropriateness of mineral applications through the preparation of Environment Agency planning liaison responses, alongside the production of EIA for new quarries and ROMP applications as a consultant. And you've got experience of this particular context, having promoted development sites across Eastleigh Borough for 10 years and having achieved planning consent for residential developments. And you participated in the Eastleigh local plan examination, so you're aware of the considerations that influence planning decisions within the appeal site's context. Is that all correct, is it?
That's right, yes.
Excellent, thank you very much. Now, if I could ask you to turn up your summary proof of evidence, if I may. That's called document L71. I'm not going to ask you to read the entirety of that document. Much of it we can take as read, but I wonder if I could ask you to read, for the benefit of those in the room, everything after paragraph 16 under the heading Policy Conflict, please.
Thank you. Yes, in terms of policy conflict, Policy 1 of the Hampshire Minerals and Waste Plan Review and paragraph 1.9 of the adopted Minerals and Waste Plan instructs decision makers that the policies in the plan are to be regarded as a whole and that proposals should be expected to conform to all relevant policies of the plan. Based upon this recommended approach to the assessment of impacts, it can be considered that the proposal is contrary to Policy 3, Protection of Habitats and Species, Policy 5, Protection of the Countryside, and Policy 12, Managing Traffic. The proposal is considered to have some conflict also with the objectives of Policy 25, particularly in respect of the competition for inert waste and the pressure on using recycled aggregates in favour of Land 1 virgin materials, and that is in relation to Policy 25, Sustainable Waste Management. The proposal is also contrary to the Eastleigh Local Plan in respect of Strategic Policy S11, Transport Infrastructure, and Policy DM11, Nature Conservation. Through my assessment of the appeal development, the evidence submitted by the Rule 6 party has confirmed my opinion with respect to the levels of impact and their inappropriateness. These findings have been important when considering the appeal proposals against the policy support of its allocation and the waste policy requirements to maintain a supply of sharp sand and gravel. However, what is clear from the development plan policy and the appeal site's specific allocation wording is that the working of mineral sites cannot automatically be agreed. Instead, they must satisfy numerous detailed requirements and justify that any development will not result in severe impacts or adverse effects to the locality or upon nationally important designations. The appeal development has been identified as failing the requirement of the Hamble airfield site allocation. Without any demonstrable need or urgency for the working of the allocation, the impacts arising are found to be unacceptably detrimental. On this basis, the proposal should be refused. Mr. Clothier has set out harm to the water environment in his evidence. Mr. Whittingham has set out the harm due to additional traffic movements alongside conflict with pedestrians and cycles in his proof. Mr. Andrews has set out the harm to the ecological environment and biodiversity in terms of the site environment, local designations as well as national designations. Taking these impacts into account and the harm that they represent, it can be identified that the harm arising to the designated sites, water environment and the local highway prevent the appeal development from being considered as sustainable development. Through the analysis of the impacts arising from the appeal development, it has been found that the proposal is not sustainable development as identified through the framework. The benefits arising from the provision of materials and method of public access proposed is not considered to outweigh the extent and significance of the detrimental impacts that we have identified. On the basis that the presented scheme to extract minerals from the appeal site is inappropriate and would give rise to unacceptable detrimental impacts on the environment, accessibility of the area and highway networks, the limited benefits arising from accessing the aggregates do not overcome the scale of harm identified. This harm to the environment and highway amenity means there is limited public benefit to the proposal and planning permission should be resisted.
Thank you very much, Ms. Els. Now I'm just going to ask you a few questions really to get your response to comments that are made against you by Ms. Pearman, just for the inspector's benefit. But first of all, obviously the HPDG, the Rule 6 party, has taken a point about need in this inquiry. Can you just help us? What's the role of the need for this development in the planning balance that the inspector has to undertake here?
The site is allocated and there is no getting around that, and it is allocated for a certain level of sand and gravel extraction. However, that need is on the proviso that any development and any extraction is delivered in accordance with the local plan policies and doesn't give rise to unacceptable impacts and harm. Given the availability of other sources of sand and gravel, it's my opinion that the requirements for that level of sand or gravel doesn't override the environmental impacts, and that's in terms of the hydrology, hydrogeology, highways and overall environmental detriment. So in my opinion, it doesn't fulfil the site allocation requirements and should therefore be resisted. At this moment in time, there is no information before me that demonstrates that there is such a level of need that means that these shortcomings are overcome.
Thank you. You obviously touched on Ms. Pearman, you touched on the relevance of the allocation, and Ms. Pearman says, well, if a site is allocated, there's no policy requirement to demonstrate need. What's your response to that?
Well, I think when you're delivering an allocation, you have to be policy compliant and therefore satisfy the allocation requirements and the other policy requirements. And I don't think the delivery of sand and gravel at this location overcomes that in any way.
In relation to need then, just in more detail, you say in your proof at paragraph 5.3.9 that sufficient land bank exists for sharp sand and gravel for all scenarios and envisaged supply rates. And in her rebuttal, paragraph 2.9, Ms. Pearman says this is simply incorrect. What's your response to that?
Looking at the latest LAA, the February 25 version, I believe that there is the required level of sand and gravel. I know that there's been much discussion over the version of the LLA and what tables show which, but in my opinion, there is still the satisfied level of sand and gravel, and it exceeds 7 years. In addition, there are other sources of aggregates that should be taken into account when meeting these needs that the appellant has raised. There is an increasing market potential and also need for recycled materials to be used, especially in building and infrastructure. And then, given our position on the coast, we also have the resources of the marine one gravel that contribute as well.
At paragraph 2.5 of her rebuttal, Ms. Pearman refers to your figure 5.2 in your proof and says that it's based on the wrong figures. She provides what she says is a corrected table. I mean, what's your response to that? If Ms. Pearman's figures are correct, how does this affect the analysis that you have undertaken?
If I could just get her, if you could just give me a moment to get her table up.
Of course.
So from the review of the table and the rebuttal provided, it still satisfies the required level of sand and gravel requirements. So although there are maybe some questions over the figures and in terms of which LAA was used, the figures in the rebuttal don't show any shortfall in provision, in my opinion.
Okay, and is there anything else you want to say about those figures in particular?
I think there's been a lot of discussion about the pressures on sand and gravel, particularly in terms of development pressures from new housing and infrastructure. But this is influenced by market demand, and this puts pressure on sites to be delivered, sites to be won, sites to be extended. And we've seen through the LAA and also the emerging plan that actually there have been extensions and proposals to existing quarries that have satisfied the requirements for aggregates before the delivery of this allocation and others. So I would argue that the need that is identified or allocated does not really justify the development.
Sticking with Ms. Pearman's rebuttal, paragraph 2.52, she makes a number of points, and I think sort of basically those points are that the figures in that table assume that the sites can deliver at one point in time, which is never the case, and that therefore the total land bank is a sort of artificial construction. What's your response to that?
I believe that, in terms of that table and the following paragraph, I don't believe that referring to the resources that fulfills a mineral and waste plan's supply is an unrealistic and also inappropriate way of assessing the land, or rather the aggregates that are going to come forward. I think there was some discussion about market influences and also, that some quarries haven't been delivered, whereas I think the Mineral Planning Authority has already identified that they are still approving new quarries and extensions. So I don't believe that this criticism is applicable going forward. And I think if I could just add, the main criticism, I think, was on reaching the 7-year supply, but the level of deficit, that was indicated, which I think from memory was 6.94, I don't believe that level of deficiency is enough to overcome the identified harms.
Do you know, in terms of that deficiency, whether that's relates to aggregates as a whole or sharp sand and gravel as distinct from soft sand, for example?
I think that's just sand and gravel.
Yeah. Your summary paragraph of your proof of evidence at 5.3.18
Yep.
Miss L says in relation to this, you say that there's no demonstrated deficit in materials to be satisfied or forecast under provision through the emerging plan that would be increased if the appeal site was not brought forward at this time. Miss Pearman in her rebuttal says that this is clearly incorrect. Just wondered what your response to that is.
Well, given the status of the emerging plan examination, so it has weight, I think in the previous examination there was discussion about the reduced requirement for sand and gravel. So I don't believe that the forecast that's set out in the LAAA and the level of supply that's been established can be disregarded. It's also, the authorities' role to maintain a supply and to monitor the supply, which is what the LAA has done, and has done satisfactorily, in my opinion. And then, from my review of the delivery of quarries and the delivery of the sand and gravel, it has been influenced by market requirements, and specifically the lack of building during the COVID lockdowns, shall we say, and how this has had extended implications in terms of the working lifetime of quarries. So I think it's unrealistic to think that quarries aren't going to happen, that those delayed quarries aren't going to deliver, because they're still there and they're still provided for.
Just briefly then about inert waste. Now, and its relation to policy 25 of the Hampshire Minerals and Waste Plan. Now, Ms. Pearman says in her proof of evidence that the deposition of inert waste in a quarry is not landfilling, and so it complies with policy 25. Now, what's your view on how policy 25 interacts with the use of inert waste in these circumstances?
I have to agree that policy 25 does allow inert waste to be imported to restore quarries, but I do believe that there's increasing market pressures on those inert wastes in terms of delivery and the fact that those wastes are more likely now to go to alternative construction sources, and that they are more likely to be used in building, the developments that we've discussed may be coming forward, and those ones that are committed in terms of infrastructure. I believe that, therefore, that the provision of inert wastes to restore this quarry could have market difficulties.
If the inspector doesn't have sufficient insurance, having heard the evidence that there is enough inert waste availability to meet the current restoration timetable for this development, how do you say he should deal with that or reflect that in the planning balance and decision that he has to undertake?
Well, I think in terms of the planning balance, it has to probably review the assessments and the conclusions that have been undertaken, because they are based upon a restoration timetable that will be extended if inert materials aren't available and the restoration is delayed. That, of course, from the Rule 6 parties' point of view, will have an extended impact upon their highway safety, the highway impact along Hamble Lane, as well as the identified hydrology and hydrogeology impacts.
All right. Just then, a couple of final questions. A number of planning benefits are asserted in relation to this development, and that I think they're most clearly set out at core document B60. I don't know if you're able to access that. That's the planning statement.
Okay. Just give me a second.
That's fine.
So E16 or 60, sorry.
E for Bravo 60.
I'm going to-
Bravo 60. And once you're in there, it's page 28. I think of that. No, I don't think that's right. Page 30.
Yes, I've got that.
You have that. Okay. I mean, is there anything you want to say about these benefits and any weight that should be given to those?
I think, obviously, the delivery of the local building materials or building materials from this site is, of course, it has weight given its allocation, but I do believe that there are other sources, so it is not an overriding consideration that overcomes other issues. In terms of the other benefits, such as employment, the application reports that I believe 7 members of staff will be employed on site, and there will be lorry drivers associated with the deliveries. But I don't believe that this is a level of employment that will substantially benefit the local area, or that those employment positions would only be filled by people locally. So I do question how significant employment will be in terms of the economic benefits. I can't believe that 7 additional people are really going to have much of an impact on the Hamble shops and economic relations, really. Equally, in terms of business rates, that's a very subliminal one in my opinion, because even though they pay a rate, they also have an impact, and the whole point of business rates is to mitigate impacts as well. So I don't believe that that's necessarily associated with a benefit. In terms of the aggregate levy, obviously this is dependent on the amount of aggregate that's won from the sites, but this would also be received by any other quarry coming forward or any other extension to quarries. So if we are meeting the 7-year supply or exceeding it, then the same level of that levy would result anyway. And there was reference to biodiversity benefits, whereas I think that those are also being taken, or should be taken with some caution, given the impact that is going to happen. It is not demonstrating any sort of gain over the existing environment, in my opinion, and therefore there is question over what substantial benefit that will be. And in terms of the public access and the new footpath, I think when that's compared from the Rule 6 party's point of view to the access right now, the fact that the only difference will be certainty of access, I don't think that's of a level that would be appropriate to justify the harms. And in terms of the flood storage capacity, this is preventing flooding from the sites. So I wouldn't see that as a benefit. I'd see that as essential requirements of development. In our discussions on conditions, there's already been a response back from the appellant identifying that they will not stop overland flood routes or will not redirect them because they are existing. That could be a benefit that could have been tied into the development if flood storage and flood route attenuation was part of the benefits, and I don't see that it is.
Then I think just want to clarify some of the wording you used in your proof of evidence. So paragraph 4.2.23 of your proof.
Yep, got that.
You say in relation to the public right of way, find the right paragraph for that now.
Yeah.
I did say that, yes. Yes, thank you, sir. But I think that may not mean that. We looked at it.
Is it page 11 of my brief?
Page 11 is where that paragraph is, yeah.
Yeah.
Yes, I'm just trying to find the bit that I, bear with me one moment. Just wanted you to clarify, but suddenly escaped me. Yes, bullet point 5, that list. I think it's, you said, Ms. Pearman says that the route of the public right-of-way would not be affected by the excavation works, and there is no need to change the route of any public right-of-way. Users of footpath number 1 to the east of the site are unlikely to have significantly different experience to what they currently experience, as this is a narrow footpath, etc. And just can you just clarify in your proof what you say about the route of the public right-of-way being significantly influenced? What did you mean by that?
So from my walking of the public right-of-way at present, it is within a defined fence-lined route alongside the Hamble airfield, but it is a peaceful route that presents an attractive route alongside the airfield. What my assertion was, it was in respect of the disturbance and the overall activity, as well as the visual impact that may be possible at certain parts of the route from the quarry workings as they take place, and that's over the lifetime of the quarry and including the restoration.
Thank you. And then finally, as for this particular site and its suitability, in her rebuttal at paragraph 2.24, Ms. Pearman says that many CEMEX sites are close to residential dwellings and schools. Now, obviously, we heard at the beginning that you've got extensive experience of minerals proposals. I mean, how typical is it for a mineral site, to be as close to residents and schools as this site is?
It's not typical at all. In my experience of finding gravel sites, finding sand and gravel site, and also working on reopening old sites and working on new sites and existing sites that want to be extended, this relationship is atypical, as I believe we've stated previously. It's the relationship to the fact that there is Hamble lane access into Hamble Rice and no other alternative routes, whereas the majority of other locations aren't even close to a village that is visible, let alone affects the only route into it. Where I have worked on quarries or rumps that have some relationship to an existing settlement, it has been that the quarry was there long before most of the village and settlement was. And it has been a moderate extension that has been on the other side, located away, and all activity and traffic doesn't go through the village or has any impact on it. Indeed, in terms of my experience in assessing and promoting sites, I've also put forward sites for quarries and seen them being discounted by Cemex, by Tarmac and other producers because they have a relationship too close to a village. And those relationships are normally not as close as this one that we're dealing with.
Thank you. Thank you very much, Ms. Ferman. So those are all the questions I have by way of evidence in chief.
Thanks so much, Mrs. Fulbrook. That's brought us well, slightly beyond, not slightly beyond, slightly before I thought we might be. So that's helpful today. Before we break for lunch, just in terms of the discussion we had this morning about availability, unless Mr. Strone or Mr. Lewis can pull a rabbit out of the hat, it seems we don't have Monday or Friday.
I'm going to pull that rabbit.
You're going to pull that rabbit?
Yes.
All right, I'll leave it at that. I can't. I'm not available the 2 weeks after that.
No, so I'm just. I haven't had a tripartite discussion, but I did have one with Mr. Lewis. One possibility is, it sounds a bit antisocial, but Friday afternoon at about 2 p.m. next week. The reason being that may fit with Mr. Lewis's earlier commitment that day. If not, there's a potential alternative arrangement that he was discussing. It would also potentially fit with my availability. I haven't checked with Mr. Fulbrook yet, so we can continue that. But
right.
But it's what I'm flagging up is that Friday is not necessarily out of the window. That's a sort of rabbit.
All right.
The ears are popping up about the hat.
Okay, we clearly need to have certainty because we have to have certainty on that. So I will say no more until the end of today. In which case, it's now 12:23. We're bang on programme actually. If we break in terms of lunch and resume at 13:15, are people comfortable with that? All right. So at that point, then we will adjourn. The recording can be paused, and we'll see everyone back in this room at 13:15. Thank you. All right, welcome back everyone. It's now 13:15, the inquiry is now resumed. I'm not going to deal with housekeeping matters at this point. As there is another lunch, I'll pick everything up once we've heard from the last witness today and before we adjourn for the evening. Having said that now, then I think we may as well go straight into cross-examination of myself by Mr. Strawn, unless there's something that really I need to be aware of. In which case, please commence cross-examination, Mr. Strawn.
Thank you very much, sir. Good afternoon, Miss Els. Is it Miss Els or Mrs. Els? Which you
Mrs.
prefer?
Els. Mrs.
Mrs. Els, thank you. Mrs. Els, you'll be pleased to know that where you cover matters addressed by other witnesses in your team, I'm not going to cross-examine you about those.
Thank you.
So, for example, the question of hydrogeological impacts or transportation and the detail of that and highways, I understand you're just relying upon their evidence for your assessments.
That is correct.
So I hope that's an acceptable approach. So I'm not going to revisit that. I may come back to some general principles with you, Ms. Els, from a planning perspective, but not the technical details. Can we just therefore agree, because you are, and you tell us, a professional planner, can we agree in principle that whilst often in development control, people can be concerned about development, as a professional planner, it's important to maintain a sense of objectivity and act in accordance with proper assessments?
That is correct, yes.
And although you may not agree with all of the judgments reached by the Mineral Planning Authority, it's fair to say that's precisely the approach that they adopted in assessing this proposal as set out in the very comprehensive committee report.
Yes, that's right.
Yeah.
After their consideration of the application over an extensive period of time, they obviously set that out in the planning committee report, and then through the appeal process they've also had further consideration of other matters.
Yes, but really what I'm getting at, for example, in the discipline of air quality, you would have come across air quality assessments in your work. There are areas of expertise in relation to air quality assessments and methodologies to follow, which can then be reviewed by a planning authority before a conclusion is reached as to whether or not there's an adverse impact.
That's right, and it can be the responsibility of a determining authority to make sure that the surveys, the results submitted are in accordance with a standard practice or do rely on the correct information.
Yes, and that has been the approach of the council in this case on, and I'm just going to give you some examples. Air quality, do you agree?
I believe so, yes.
Noise?
I believe their environmental health officer has advised them accordingly, yeah.
So, just so we can be clear, and you speaking as a professional planner, there is no evidence from the Rule 6 party that seeks to question the noise assessments carried out by the appellant and the conclusions of the planning authority that the impacts of noise have been properly managed and addressed. Is that?
That's right, you've read the statement of case, and
Yes.
it doesn't know.
Well, I know there's reference to concerns of local residents, and obviously residents are concerned, but I'm just trying to draw a distinction between someone saying, well, I'm concerned about noise, I'm a school child doing my exams in the nearby school. That's all been assessed, and there's satisfaction by the authority based on those assessments that there isn't going to be such an adverse impact, isn't there?
I'm not sure in my role for the Rule 6 party and the Rule 6 party's statements that have been submitted for this appeal, that I can absolutely tell you that the council considered the amenity of pupils when they were doing their exams, but they have taken into account the influences of the working quarry.
Well, the levels of noise from the site to the nearest sensitive receptors, which include residents and schools, have all been assessed and deemed to be satisfactory.
Through the planning authority, yes.
Yeah, and you wouldn't urge the inspector to act anything other than on that level of professional assessment by the relevant experts, would you?
Obviously, the inspector's got to take into account the other parties that have presented to him, but on the evidence that I have before me and that I'm aware of, then as a planning authority, you determine it based on the information that you're advised upon.
The objective assessments, which in technical areas such as noise or air quality,
Yes.
you would, yes. And I raise that as an example because we'll come to the question of proximity of a quarry to a school, for example, or residential properties. We can agree, and we can talk about what the distances are, but we can agree, can't we, Miss Els, that the real question, is whether there's any adverse impact on relevant environmental considerations between the operations and the what's called the receptors, but we can call them residents or people in around the area, as measured objectively in that way.
That is the role of the determining authority, and that should have been the function of the environmental impact assessment.
Yes.
And identifying it through the application.
Yes, so merely to say, well, it's, as I think you were saying, close to residential properties or close to a school, doesn't assist in the determination. One needs to look at the objective assessments of the relationship and whether a satisfactory relationship can be provided.
I think I agree with you, yes.
Yes, thank you. And I take it as a planner, and not least because at 2.1.1 of your proof, you refer to this, but you believe in the plan-led approach.
Oh yes, definitely.
I'd say that because the law sets it out in section 38.6, which you've quoted in paragraph 2.1.1. But it's also important, isn't it, because the plan-led approach provides a degree of forward planning for not just the authority, but for local residents.
Yes, it should do, yes.
And in that respect, whilst obviously I know this is an emotive subject for people, the principle allocation, the principle of development of extracting the minerals that are to be found on this site has been in place under the plan-led approach since at least 2013. I say at least because there would have been obviously a process before the plan was adopted, but in the principle of it.
Sorry, what was the question?
Yeah. The principle of extraction of minerals from this site has been part of the plan-led approach since at least 2013.
Yes, subject to the allocation and the requirements of the whole local plan.
Yes.
In terms of policy.
Yeah. So it's subject to satisfying the criteria. There could be no surprise to anyone living in the area as to the local planning authority's approach that this was a site that should be allocated, minerals extracted subject to compliance with the criteria.
I think the local plan sets out the approach, and that's the adopted plan.
Yes, but my question was, it couldn't be any surprise, because the purpose of the plan-led approach is to inform not just the planning authority, but members of the public, hence the public participation.
It is the area's plan, so...
Yes, it couldn't be a surprise, is what I'm saying.
It's dependent on members of the public knowing that plans exist. As to whether it's a surprise to them, I can't answer for every person.
No, I wasn't asking you to answer for every person themselves. That would be an ambitious proposition.
But yes,
I'm just
I
dealing with the
agree
plan. Yeah.
that it is allocated, and if people had looked it up, they would have found out that it would have been a proposed allocation coming forward in accordance with the allocation policy.
Thank you. And then just dealing with the council's determination of the application, Ms Kirby Hawkes gave some evidence about this previously, but I just wanted to see if we can agree what's between us, that's you and the Rule 6 party, as opposed to other people's views. Reading the committee report, which I don't suggest you do right now because it's very long, but it's CDE1, but having read it, if I would put it that way myself, having read it, you can get this from the executive summary, for example. There were 2 reasons for refusal in the executive summary. A third one came about very last minute because of Natural England's point about air quality, which they then clarified and withdrew. But it's fair to say that it's clear that the planning authority were the 2 reasons they're objecting on related to what they call provision of information, namely the restoration plan, and secondly, the mitigation contribution.
I'm sorry, I don't quite get the question.
Which let me try and simplify. There were 2 points raised. One was about the details of the restoration plan, in terms of the local lead flood authority wanting it to mimic the existing situation. Yes?
Sorry, are you referring to the refusal reasons or another paragraph that I've got to look at?
I was trying to short circuit it by looking at the committee report. If you want the reasons for refusal, that's fine. The committee report, CDE1, and there's a executive summary section, paragraph 3 onwards. I didn't want you to have to read it all.
No, I've read it lots of times, don't worry.
Before that, the recommendation above, paragraph 1, were the 2 reasons for refusal. But if you read those with the executive summary, reason for refusal 1 was based on the local lead flood authority's view that the restoration plan that was proposed wasn't mimicking the existing site. You can't see that from 1A, but you can see that when you read it with the rest of the report.
That's why I thought I'm seeing things.
No, that's fair enough. So, but if you want to understand what's behind 1A, then you read it with the rest of the report. It was that specific concern.
Yes, I agree.
Yeah, and 1B, similarly, if you read it, it might be suggesting it's all sorts of transportation issues. In fact, as was being clarified earlier with Ms Kirby Hawkes, it was about the detail breakdown of the £500,000 contribution being necessary.
In terms of delivering those policy requirements that are set out there, I agree that those were the deficiencies that are specified. I must admit I wasn't at the regulatory meeting. I don't know the discussion that also went on, and I haven't watched that. I have just kept it to the report. That's in front of you.
Well, I'm just going to deal with the report. I've also mentioned the third reason that came in, which you'll see from the minutes. So I don't think we need to turn them up, but that was the Natural England air quality issue, which was then resolved. But it's fair to say that so far as the report's concerned, these were not objections in principle to the allocation, but those 2 points of detail that I've just identified.
I don't think the report has any reference at all to the acceptability of the allocation. This is all related to the application and the documents that have been submitted through an environmental statement to demonstrate the working of the allocation will be acceptable. These are 2 areas that have been specifically identified as failing.
Yeah, that's the point I'm making, Ms. Elsby. I'm not sure you've answered my question, but just to be clear, anyone reading this report and understanding the planning authority's position would know these are the 2 issues of detail they were concerned about. if they were resolved, the position is, as I was exploring with Miss Kirby Hawkes, she call it not objecting, but in principle support. There couldn't be any other way of reading this and the report fairly, could there?
In terms of the black and white and the way the Mineral and Planning Authority have represented it in this report, yes.
Yes, that's what that, because it's a short point, but I'm really getting to the notion that somehow when those issues were resolved, the County Highway Authority was commencing some sort of U-turn or change of position. In fact, they were just simply acting in accordance with the logic of this report, that if those points of detail were resolved, then the analysis was supporting the principle of development. That's fair, isn't it, as a summary?
Well, if you answer all of the issues that are wrong, then on any application, the development's going to be acceptable.
Yes,
From the Rule 6 parties' perspective, they have introduced information and other points to the determining authority.
I've got that. That wasn't my question, Ms. Els.
That
I
they,
understand that because we're tackling those in a moment. It's just that it's clear, isn't it, from reading this report, the points that they were raising, if those were resolved, there couldn't be any notion that the council was committing some sort of U-turn or different approach to the principle of the development. On any fair reading of it.
no.
Okay. No, by no, you're agreeing with me rather than disagreeing with me. Okay. Sometimes no's and yeses could be misinterpreted. That's fine. Good. Thank you. And then, can I come back to the next topic I just want to ask you about, which is, again, planning, but the plan-led approach that you've agreed is applicable here. If you want to turn up policy 20, of the local plan, please do, but you may not need to because my question is going to be relatively simple, I hope.
Nearly there? Yep.
In the local plan, which allocates the site for mineral extraction through policy 20, subject to complying with the criteria, there is no requirement for the appellant to demonstrate a need for the mineral in order to obtain planning permission, is there?
No.
And that exercise of looking at need is already inbuilt into the allocation that's in the plan. You do need to satisfy the other criteria, but the plan-led approach is identifying what the area needs, and one of the things it needs is this site to be, the minerals to be extracted, subject to compliance with the criteria. That's a fair summary, isn't it?
Yes, that's one of the functions of this plan, is to identify suitable sites for allocation for quarries, sand and gravel workings, aggregates, in the same way as other local plans identify housing. But I would say that it is the responsibilities of councils to identify a level of supply. This is through allocations, but they also rely heavily upon windfall schemes. So they do not identify every windfall and every possibility. It is just that they have a level of supply there.
Well, yeah, that's certainly true. I don't think you're dissenting from the answer that you gave earlier, but that's also catered for in policy 20, isn't it?
Yes.
paragraph 4, proposals for new sites outside the areas identified in policy 20 will be supported where, and then there's the various criteria, and they are subject to some assessment of need. Windfalls
Yes,
are subject to an assessment of need.
that's right, yes.
Yes.
So I didn't hear the last.
In contrast to this site, there is no requirement to show a need for it because it's already serving a planned need.
That's right.
So we are going to have a discussion about need, but I just want to set it in this context. If the criteria that are expressed in policy 20 are met by the proposal, i.e. addressing the development considerations in Appendix A, site allocations, no requirement to demonstrate need. However, if there is also a demonstrable need, that adds to the positive presumption of granting planning permission first. Do you agree?
No, I
No?
don't know where that's referenced.
No, but it would, wouldn't it, if there's an identified shortfall beyond that which was already planned for.
As an allocated site, I wouldn't say that has much contribution in terms of its determination. I would only say that that has an overwhelming contribution where there are identified harms or impacts.
Right, well, that's the second. Okay, we can disagree on the first, but as to the second, if there is a need, it can potentially outweigh any policy conflicts if they arise.
Well, I think it's about demonstrating a level of need or a level of unmet need.
That's not an answer to my question, myself. Just focus on the
No.
question.
Could you repeat your question, please?
We don't need to demonstrate need if we comply with the policy. If, however, there is a need, and you spent a lot of time talking about need, so it must be relevant, I assume. Need can be relevant if there is identified policy conflict in outweighing that need.
Yes.
Sorry, outweighing that conflict, sorry.
Yes, I agree with that.
Yeah. So just putting that structure together, therefore, the starting point is the allocation in policy 20 and the assumed need for it. If we meet the Appendix A site allocation principles, then permission should be granted unless other material considerations of some other type were relevant, which I don't think you're identifying any.
Sorry, are you asking me if I've identified any?
Just putting the whole thing, the structure together. As a planner,
Yes.
we've got an allocated site for mineral extraction here, Hamble Airfield, yes?
Yes.
The policy says you get planning permission if you meet the site policy, the site allocations and criteria in Appendix A.
That's right.
Yeah.
And the local plan as a whole.
And the local plan as a whole. What other aspects of the local plan as a whole?
Well,
are you
all of the
saying
other policies that identify whether the highways are acceptable, whether the ecology is acceptable.
I see, okay.
All of that's what I mean by the plan as a whole.
Yeah.
And I think in my introduction, I referred you to the paragraph at the start of the plan. That does actually reference that.
Yeah, that's fine.
Yeah.
Fine. So that was the caveat. And then other material considerations, if we meet the allocations in the other policies, you're not identifying any other material considerations as to why this proposal should be refused, are you?
I'm sorry, I didn't quite hear
You're
that.
not identifying any other material considerations as to why this proposal should be refused if it meets the site allocation criteria and the other elements of the local plan policies, are you?
In terms of the case that the Rule 6 party has made, then if the environmental factors that we've identified are overcome and the inspector believes that they don't warrant any detrimental impact, and that the Hamble airfield allocation requirements are satisfied, then yes, I agree, it would be difficult to resist planning permission and it should be granted.
Well, yes, again, there's reluctance. I mean, I know difficult to resist, but it's the other way round, isn't it? Under the National Planning Policy Statement, we should be granting it without delay if it's in accordance with the development plan.
And yes, if it satisfies all of the allocation requirements and all
And
of
the
the
other
policy
policies.
requirements, then yes.
Yes, okay, good. And need in those circumstances, if there's also a need that could be talking about outweigh any identified conflict, either with local policy or whatever it may be. And on the question of need, that is, so far as minerals are concerned, governed by national policy principally, and then the local plan identification of what minimum 7 years supply it's got. Do you agree?
Yes.
Okay. And so far as national policy is concerned, it is fair to say, as Miss Kirby-Hawkes has done in her assessment, that the elements of need are not just simply quantitative for the whole of the authority area, but include locational questions of the type she's identified for South Hampshire.
Do you mean as in from the framework? Or
Yeah, from the framework or the policy. I don't mind wherever you want it, but it's a question of identifying need.
well, if we start from the framework
All right?
and paragraph 226 to 227,
Yeah.
that obviously identifies the minimum 7-year requirements.
Yes.
Criteria F. It also advises against, over relying on large land banks, and identifies that there should be a mix. I don't see anything in here or any policy specifically that identifies that every local area must have a source of sand and gravel or have an aggregate working, because the county authority already acknowledges that in terms of limestone, crushed stone, they have no resources in that.
Well,
And
well, just look at 226C. That's obviously wrong, isn't it, Ms. Hulse?
226,
C.
making provision for the land one and other elements of their local aggregate assessment in their mineral plans, taking account of the advice of aggregate working parties as appropriate. Such provision should take the form of specific sites, preferred areas, and/or areas of search and locational criteria. I see that as being in the mineral plan, rather than producing and also monitoring through the local aggregate assessment, rather than necessitating that every local area has to have a source of aggregates.
Well, I don't know what you mean by every local area, but I didn't put it in that respect. Clearly, one of the important elements of need that's being identified in national policy is location.
In terms of minerals can only be worked where they are found.
Well, that's also true, but that wasn't quite what I was getting at. I.e., as Miss Kirby-Hawkes and this Mineral Planning Authority has done, they've looked at not just what's the geographical incidental area of their boundary, but also where the need for the mineral is going to be particularly required for construction activity, which sites are, in this case, close to that need. And that's entirely in accordance with the national policy, isn't it?
It is in accordance with the policy in terms of delivery of aggregates.
It is, did you say?
Yes.
Yes, right. So,
But I don't believe that. Sorry, can you hear me? Okay.
Sometimes you draw away from the microphone, but I
Sorry.
think I did, yeah.
So, in respect of the justification for the delivery of the Hamble airfield site, in respective of its impacts and justifying it because of the fact that local development will occur and that's why it's relied upon, I don't see that as a justification for not according to the allocation requirements or not sufficiently mitigating its impacts.
Well, that wasn't my question, Miss Ells, was it? What I'm simply getting at, and I'm hoping we can agree, is that when the council have looked at the question of need for this particular quarry to come on stream, they have correctly taken into account its locational qualities and criteria in serving the local aggregate requirements.
I agree, yes, that would have been a consideration at the allocation stage.
And you don't identify any better site than the one they've identified to meet that locational criteria.
It is not my role to identify allocations or identify alternative sites. There are other reserves within Hampshire.
Well, I know that, you say, but that doesn't answer the question. The inspector can see what other reserves they are because they're factored into the plan. But one of the important considerations here is there isn't a better located site to meet the South Hampshire requirements for new construction than this site, is there?
There are other sites.
There isn't. Just stick with we'll be here a long time ourselves. If you don't understand the question, please.
If you're asking me if there are any better sites, then surely I can answer if there are or not.
Well, as long as a better site to meet South Hampshire's particular needs than the one that's been identified. Do you want me to go to the committee report where that's identified, if that helps? Or just answer it if you want. I don't mind which.
I acknowledge that's what it says in the committee report, and that's what the council has identified.
Well, I know you acknowledged that, but that's not really answering the question, is it?
If you're asking me if I believe that that's the only source of minerals,
No, that wasn't my question either.
or the best source of minerals,
You haven't identified any better site than this, locationally, to meet the local requirements that the council...
That's right, I haven't.
No,
No.
okay. I just want to make clear
Sorry,
there
I
isn't a better
misunderstood.
site than this. If there is, I want to know what it is. But there isn't one, is there?
I haven't searched for one.
Thank you. Then we come to on the question of need. I'll come back to the minimum 7-year land bank in a moment, if I may.
Yep.
But can I just ask you about, we can just jump forward, as it were, whether you agree with Miss Perman's analysis and something I was discussing with Miss Kirby-Hawkes. Even the latest local aggregate assessment, I've got it here, but you've probably got it somewhere else, CD K27, sir.
I've got a copy. Is this the February version?
February 2025, revised version.
Yep.
As Miss Kirby-Hawkes was explaining, and we agree, the local plan that we're operating under and the LLA, taking account of the LLA, even when you apply both, there's a need for this site for the reasons she's explained. You may not agree with that, but what I just want to understand is what the LLA is factoring into its quantitative requirements. And it's quite a short point, Ms. Ells, but can we agree it does not factor in the new requirements for housing in Hampshire County Council's area?
No, because it's not approved yet.
Sorry?
No.
Well, it's not approved yet. I mean, the National Planning Policy Framework's been approved, I think.
Yes.
Yeah.
I mean, any commitments to deliver that housing isn't approved yet.
Well, the requirement to meet those needs is already a requirement of national policy, isn't it?
Yes.
And Ms. Pearman has identified in her proof of evidence the scale of that challenge. Paragraph 628.
Yeah, I don't necessarily agree with this, though, in the same way that Ms. Behrman's also said that our quarries won't all come along at the same time. Our housing sites don't all come along at the same time. They take years to get planning permission, yet alone to deliver, in terms of their infrastructure requirements and also their build-out rates. And although we are in a position nationally where there are new housing figures to meet this government boom in housing delivery, it does have to be deliverable. We've had discussion today and yesterday especially about the infrastructure constraints locally to the site along Hamble Lane, and these infrastructure and resource constraints do affect most communities in terms of those that are looking to be expanded by this increased housing numbers. The fact is that we can grant permission for massive housing developments to fulfil these housing requirements, but they still have a delivery timetable. And the delivery timetable is down to resources, delivery of infrastructure, and the ability of house owners to come forward and purchase. So it is also market driven. It is not just specifically driven by the framework, the new housing requirements, and the government objective to deliver. Now, as a private consultant, I'm often arguing that we need to have the permissions in place so that we can deliver and support it. But there also just have to be realisation that they don't all come at once, and there will be time for resources of aggregates to come forward, because it's that market that will allow a lot of the quarries that have been identified in the LLA as not quite coming forward or as being delayed as a result of the COVID lockdowns and still being, selling off stockpiles. It will be those resources and those pressures that will give the impetus for those quarries to be worked. But it will be over a staggered period. It will not happen all at once.
Right.
I wish it would.
Very, very long answer themselves. Not an answer to my question, but thank you for that potted history of the problems of the planning system. But can we just come back to the issue I was raising with you? There is now, right now, because this is national policy, new standard methodology numbers applicable to Hampshire's area.
Yes.
They're in place now.
Yes.
And they have caused a significant, and this isn't unique to Hampshire obviously, but a significant increase in the requirement for new housing now.
Yes, but they still have to be built.
Absolutely, and it's one of the sources of frustration of the government that they're not being built, of course. But we're just dealing with national policy and the principle of planning. Those new requirements are only going to increase the pressure for new minerals in this area, aren't they?
They will put pressure on all sorts of infrastructure,
That's not my question.
But they will increase the market requirement for aggregates. Yes.
Yes, significantly. I'm going to say very significantly. You can get a flavour of it just by what Mr. Spearman's identified in 628 and 629. It's fair, isn't it?
Hold on, let me just check. In the table provided in Emma's proof, there is an uplift from the housing methodology changes that shows increases across the boroughs and districts.
Well, I know
across
that.
Hampshire.
Yeah, that wasn't my question.
In terms of
It's going to, I mean, it's a very short and obvious point. If you want to disagree with it, Ms. Els, that's fine, but you need to explain why. What national policy is anticipating, requiring of provision of just housing, there's also other infrastructure that goes with it, of course, but is a significant increase in the delivery of new housing
yes,
nationally, but also in Hampshire and also in Eastleigh.
it's not everywhere, unfortunately.
No, it's not everywhere.
Not everywhere.
But it's certainly in Eastleigh, and it's certainly in every single one of the authority area, except for Southampton. So it's a marginal decrease from its numbers. There's still a requirement, obviously, for housing there, which has gone from
Southampton's gone down.
1473 to 1214.
I don't dispute that the housing figures will increase housing delivery
Yep.
dramatically, and in some council areas, it's over 100%.
Yeah, well,
That will give rise to pressure on resources.
yep.
That includes aggregates, it includes employment, and it means that there will be a moderation about how fast that delivery is actually brought forward.
Yeah, well, that's fine. The one thing neither the National Planning Policy Framework nor these expectations are anticipating, let alone supporting, is holding up delivery because you haven't got enough minerals.
No.
Okay. To the contrary, National Planning Policy Framework, if it's properly construed as a whole, in the minerals section, deliberately, if you want to turn it up, the MPPF
Yeah.
talks about the minimum or the at least 7 years of land bank supply.
Correct.
Because, again, it would be completely contrary to policy for having a lower than that amount inhibiting the construction of whatever infrastructure and housing is required. That would be completely the opposite of what the government is seeking to achieve.
Yes, that's right.
Yeah.
And, that is, as I said earlier, that is the function of a mineral and waste plan as well, to identify and ensure a delivery and ensure a policy position where schemes can be assessed and brought forward.
Yeah, so we'll come to the detailed criteria, which in a sense is for others, but we are dealing with national policy here. That's 226 F. Sand and gravel,
Yes.
maintaining at
Yeah.
least 7 years. And we're agreed, aren't we, that I'm going to try and take this as quickly as possible, sir, but if we need to go to the documents, we can. We're agreed, because I see it from your proof, that on the local plan requirement, assessed against what's in the land bank, it's below 7 years.
Yes, and I think I've referenced this earlier. Yeah.
Well, you say you referenced it earlier. So under the local plan and its current rates, leave aside what may or may not happen in the future, but under the local plan and its current rates, this county authority area is already under providing, contrary to national policy.
In terms of the provision of 6.94 that was referenced, yes.
Yes, I think we make it slightly lower than that, but it's
I'm just going off the
sufficient for my
publish, because-
purposes to say it's under. That is not a ceiling, of course, for the reasons we discussed. It's a minimum requirement. And that figure assumes the allocation at Hamble Airfield. Put
No.
it in this way, the land bank doesn't, but the plan the strategy assumes that Hamble Airfield is an allocated site that can come forward in order to, with the land bank, make up the mineral supply.
From my experience, the reliance upon an allocation site should only really be coming forward and taken into account in the land bank when it has planning permission. Right now, it doesn't have planning permission, and from
No,
my
I understand that. It's not it's not part of that land bank, if that's your point. But
Yes.
my point is, already we're below the 7-year minimum supply, and the plan includes allocations such as the Hamble Airfield as part of the future supply, and that is, on those figures, a necessary part of the future supply, which has already gone below 7 years in land bank.
the council are maintaining the allocation in their emerging plan. It is
I'm not talking about
an allocated
I'm not
site
talking about the emergency
in their
yourselves.
adopted plan, and it is something that the council would be relying upon for future delivery. But it is not counted in the LLA land bank figures.
No, we agreed that.
So
But we're already with the land bank below the minimum 7 years, and the plan, the adopted plan, includes allocations to provide future supply.
that's right, yes.
Yeah, of which we're one.
Yes.
Yeah. And because we're below the 7-year land bank, that only increases, doesn't it, the weight to be given to the release of the allocation or implementation of the allocation, doesn't it?
Well, we've been reviewing the local aggregate assessments, and I know that there was some discussion through the proofs and the rebuttals on the appropriateness and the most correct version of those. And in the February version, 2025, I would say that that presents a more optimum land bank and reserve position that does not count the allocation site. So at table 3, Hampshire Reserves and Land Bank, it identifies a level of delivery and provision that should be sufficient to satisfy the future requirements over the next 7 years.
Disagree, but Ms. Els, can you just focus on my question? It's just about the
try.
local plan and national policy. Under the local plan, requirement to have a minimum of at least 7 years. Land bank, that doesn't exist. There's an allocation for this site. Putting those two things together, that only increases the weight to be given to release of the allocation, subject to compliance with other considerations, obviously.
I'd say the allocation has weight anyway. In terms of
I know that.
increasing the weight, I don't necessarily agree completely with your approach.
Partially agree with me then.
Partially agree.
Okay,
Yes.
I'm happy with that, partially. Thank you. And then if we could go to the approach required of the national policy, paragraph 222.
It is essential there is sufficient supply of minerals to bring the infrastructure, buildings, energy and goods that the country needs.
And the finite natural resource only work where they're found, best use needs to be made of them. Those are all principles which apply with particular force to Hamble Airfield as a site, subject to compliance with other considerations, but particular force because of its location we were discussing earlier.
I agree that it applies because it is a safeguarded mineral site.
Yeah. Well, I know it applies. This isn't actually limited to safeguarded mineral site, though, is it?
Well, this is a paragraph of the framework identifying for the delivery of infrastructure and
So the answer to my
aggregates.
question is yes, it's not limited to safeguarded mineral site. I mean, this is an allocated mineral site anyway, but I don't know why you put that qualification in. This is a general principle. You can't choose where the minerals are. They happen to be at Hamble airfield, as we know, and best use needs to be made of them. Do you have any difficulty with that?
No, provided the application complies with the allocation.
Yeah, so the site-specific considerations which
Yes.
are in effect for others.
Sorry, I didn't catch that.
There's site-specific considerations. You've raised objection on highways, hydrogeology and recreation, but which are for other people's assessments, as I understand it. But subject to that, you haven't got any difficulty with the application of paragraph 222
No.
to this. Right. And then if we go to paragraph 224, and your assessment of this scheme, when determining planning applications, great weight should be given to the benefits of mineral extraction, including to the economy. Now, for those well versed in planning, as I expect you are, Marcels, this is a particular policy which is prescribing the weight to be given to a material consideration by national policy. So that's right, isn't it?
That's right, yes.
It's unusual in that respect. One of the other examples is heritage harm, for example. But this is a very important factor in the planning balance because it's national policy as to how to deal with mineral extraction, isn't it?
That's right, yes.
Where do you refer to that in your proof?
I don't think I've specifically referred to that. I've read the framework as a whole.
But this is you talk about planning benefits and you went over them again. Where have you given great weight to the benefits of mineral extraction in your planning balance? I was looking, I mean, you agreed it's a very important consideration, but where have you actually referred to it, let alone given that great weight?
I don't believe I have in that sense.
So that's a serious omission, isn't it, Marcels? Because a proper assessment of this scheme should be giving great weight to the fact that it would enable the extraction of a very valuable resource, valuable in the sense of finite resource.
If I could just have a second, please.
Yeah, please, take your time.
So at paragraph 4.6.6,
This is your evidence.
yep,
Yep.
I've gone beyond the paragraph that you've referenced. Sorry for correcting myself here. And identified that paragraph 224.
4.6.6.
So my paragraph 6.6 is page 21 of the document, where there is acknowledgement to the mineral extraction contribution to the economy.
Yeah.
And on the basis of B, the criteria that follow, and it does read A to G in the framework, under B, ensure that there are no unacceptable adverse impacts on the natural and historic environment, human health or aviation safety. Obviously, I'm aware that some of these are not applicable to this site.
Yeah.
And take into account the cumulative effect of multiple impacts from individual sites and or from a number of sites in a locality. And in my section 4.6.6, I just qualified that because the Rule 6 party and the case presented identifies that there are unacceptable adverse impacts, that the support given by paragraph 224 isn't qualified.
Right. So in your planning benefits section, where do you give the great weight to the principle of mineral extraction?
So in relation to that weight being applied, I've read the framework as well as reflecting that the weight has reliance where it doesn't give rise to those adverse or severe impacts.
No, that's all right, Ms. Els, because in your planning benefits section, you were doing it in chief. You were purporting to give different degrees of weight to things. Where do you? I think the simple answer is you don't.
Yeah, I don't.
You don't. Okay, but you should, shouldn't you?
In terms of the interpretation of the impacts arising from the development.
No, in terms of the benefits. I'll come to impacts in a moment, but in terms of the benefits of mineral extraction, you should give great weight to. What?
We'll just say no.
You'll just say no?
Well, you asked me if I've...
if you've done it.
And I've said no.
And you should do that.
In terms of the weight of a allocated site,
Not even allocated, but yes.
I haven't applied it.
No, I know that, but you should do, shouldn't you?
Yes, from what the policy reads there.
Yes, thank you. And then just now that you've lighted on 224B, can we just tackle that? You can go back to the MPPF if it helps, but clearly the policy is recognising that mineral extraction can have adverse impacts.
It does, yes.
But it's a question of whether they're unacceptable. There's a distinction being drawn between, obviously, some people are going to experience lorry movements, possibly disruption, whilst the minerals are being extracted, but they have to reach the threshold of being unacceptable.
And from the Rule 6 party's perspective, and the evidence that's been demonstrated, in my opinion, it has identified an adverse impacts.
So you say you're relying on the evidence of others for that, but I'm just dealing with the policy. There's a distinction between adverse impacts arising from mineral extraction, disruption of various types to local communities, and that being unacceptable, bearing in mind the need for the importance of extracting a finite resource.
I believe that, B says that where there are unacceptable adverse impacts.
Do you want me to give an example? If you're finding this, my question obscure, just look at paragraph 224C.
Yes.
Ensure that any unavoidable noise, dust and particle emissions and blasting vibrations are controlled, mitigated or removed at source. Now, as it happens, sand and gravel extraction is benign in that respect, doesn't have blasting and things of that kind, although some people seem to have a different view of the notion of a quarry.
It certainly has dust.
Well, you say that. We're going to come to dust if you want to. But let's assume that the dust. But this is identifying that there could be unavoidable noise, but it's not saying that's unacceptable. It's just that you have to have appropriate limits to noise-sensitive properties. It's recognising, in short, that there will be some potential effects. It's only if they cross a threshold of being unacceptable that the policy would say, don't do it.
That's right, yes.
Yeah. So it's recognising, because of the importance of mineral extraction, there may well be some noise effects, dust effects, particle emissions effects, even blasting vibrations, not applicable here, I hasten to add, but I'm just reading the policy. Those should be minimised, but it's not saying that they're a reason not to carry out mineral extraction.
Looking at C, that's right.
Yes. I was testing the proposition of what unacceptable means, but it's clear, isn't it?
I suppose if you're saying that every quarry site will have adverse impacts and that they shouldn't be...
I'm not saying that, I'm just saying the policy is recognising that if there are adverse impacts, that doesn't make it unacceptable. it's only if they reach a threshold of becoming unacceptable that then...
That's right.
Yeah.
Yes.
But it's recognising that there will be some impacts that, I was going to say, have to be accepted, but they're tolerable because of the benefits otherwise identified and the fact that minerals only occur where they're found, that need to be accepted.
I don't know, because if they were acceptable, they would be acceptable. So
All right.
I don't quite agree with your questioning there.
Right, let's just then turn... unavoidable noise and dust, because you fasten on dust. I mean, again, dust, so far as the technical assessments have been done and the dust mitigation measures are all subject to environmental controls in this case, aren't they?
They will be subject to conditions and a LEMP and various things through the Section 106, I believe, that will be finalised with the inspector.
Yeah. You're not identifying, because I haven't seen it, any unacceptable dust implications from this proposal, are you?
No, I was simply referencing Factor C.
Sorry?
I was simply referencing criteria
Yes,
C.
so in terms of this quarry operating in this location, notwithstanding what you say about proximity to residents and schools, there isn't any unacceptable, so far as you're aware, impacts on noise, dust, particle emissions.
Yeah, that is not part of our case, no.
And B, historic environment,
I don't think there's anything historic.
human health.
That's not part of our case, no.
Okay. In your proof, and again, if it's, I'm just chasing these points down because there's quite a spread of things you raise in your proof. I mean, you mention heritage in paragraph 3.1.4 to 3.1.7. It's, I don't know, I'm being sympathetic to the inspector because when you raise a point, it's not clear whether or not you're raising a point and the inspector's under a statutory duties.
Not a point.
You're not raising any heritage harm issue arising from this proposal.
No, this is purely a description of the appeal site and the environment. So this is a reference from the committee report and application documents.
All right, because that's all been assessed again, hasn't it? The absence of any...
It's not part of our case. This is just a description of the appeal site.
Yes, but it's been assessed, hasn't it, Ms. Els?
Yes, I believe so.
Yes. Agriculture, paragraph 3.2.1. I mean, the reason I had to tackle this is because there's lots of mention of things, and it's not clear to me why you're mentioning it. But agriculture and the agricultural land classification, there is an agricultural viability report of the site, CDB 86.
There is, yes.
Which demonstrates that not only is it not being used for agriculture, it's not viable or economically to bring it back into use for agriculture.
I don't dispute that.
All right, so there's
Purely
no...
a description.
All right. Tree loss.
Yes.
I think 3 mature trees, I put precise number, 3 mature trees lost, but that's been taken into account. 18,000 trees to be planted. Yes?
Yes.
Biodiversity net gain, but there is a biodiversity net gain, isn't there?
I believe both the planning authority and the appellant believe that they will be able to deliver a net gain through the restoration.
But you've seen the materials. You don't dispute that.
It is not part of our case, no.
But as a planner, bearing in mind the importance given to biodiversity and improving the biodiversity of areas, that is a significant benefit, isn't it?
Given the status of the site as it is a benefit in terms of delivering more trees, hedgerows, the water environments that are being proposed through the remediation scheme. But given the site already has, in my opinion, a high level of biodiversity contribution, then I think the the merit of significance is questionable.
All right, so a benefit, you're just questioning the extent of it.
If the restoration scheme that is agreed finally delivers a benefit, then that will be a benefit. But at this time, I don't believe that it's of any significant above that in terms of merit.
Well, there are ways of calculating biodiversity net gain, aren't there? And it's been done. I'll leave it at that. Okay, let's just then deal with a few other of your points. Can I just set aside those considerations and just focus on what I think your evidence is really raising? And this comes back to this question of current need. I don't want to spend a huge amount of time on it, but see if we can. No, I'll try not to. Let's see if we can just agree a couple of things. We've already talked about locational questions, and I don't need to go back over that with you. What I'm slightly struggling to understand in your evidence is what you're actually saying about need and the land bank and allocations. I think the best way of tackling this is to look at your appendix KE4. So if you've got that, it's quite a long document.
Got it? Don't worry.
So you happy for me to carry on? Yeah. Sorry, yeah, I was just checking. No, it's fine. No, I was just checking. You got it. I'm just trying to work out what you're really saying, Ms. Els. I understand from this document that you are seeking to suggest that because there have been extensions of time to certain quarries, that this somehow affects the need for this sand and gravel in this locality. Is that the point you're making? Just yes or no, because I don't want to.
No.
That's not the point. Okay, what point are you making?
I think what I was illustrating through this, one, that these extensions were happening, and secondly, that the ability to extend existing quarries is a bit of a windfall plus in terms of aggregates coming forward, is a continued provision of aggregates.
Right. So let's just, I'm going to try and tackle it as quickly as possible. I don't want to not do injustice to whatever you're arguing, but let's just see if we can do it in this way. If we go back to the national policy, if you want, but I could just read it out for you. The requirement, so far as minerals is concerned, is in fact to identify a steady and adequate supply of aggregates.
Yes, that's what it says.
And the Minerals Planning Authority seek to do that through their planning process, correct?
Yes.
And their planning process therefore factors in to their supply the land bank in terms of what's already there, and then allocations, and they have to make various assumptions about when sites are going to come on stream in order to ensure a steady and adequate supply.
That's right.
Yeah. And so it's important for any mineral planning authority to ensure that there's robustness in the ability to maintain that steady and adequate supply. You don't, for example, say, well, I'm going to be all right in 15 years' time because I've got a big site coming, or may have one. I can make up the shortfall then, do you?
I can't imagine they would. No.
No, okay, good. And indeed, this authority, both in the current plan and the existing plan, emerging plan, have adopted a policy which is based upon predicting what's necessary for a steady and adequate supply.
Yes.
Yes. And that, of course, means necessarily there may be fluctuations in what comes on stream or delays, or there may be times when one site's operational, not another. But the importance, therefore, is to have that robustness of approach in your supply.
Yes, but looking at the emerging plan in particular, and we've already referenced the much lower level of provision
Yeah.
for sand and gravels, and we'll put that aside. But in terms of the evidence base and the information that's going to inform that local plan examination, they will have accounted for the many windfall sites that have come forward, and that will that will confirm that their approach in allocating and the level of supply is robust. It's only with those qualifications that a robust assessment, in my opinion, is proposed.
Yeah, well, I don't leave aside what you just said, Miss Els. You're overlooking a central proposition. Even with the reduced level of supply in the emerging plan and taking account of windfalls, the emerging plan allocates Hamble again.
Yes, it is. It is allocated again.
So both with the current local plan requirement, where it's allocated, and with the emerging local plan requirement, where the figure's gone down, in order to take account of a steady and adequate supply, the council depends upon this allocation.
Yes, unfortunately, the site has still been made available for consideration and for allocation. I'm sure CEMEX or the landowners have proposed it for another allocation and assured the mineral authority that it will be coming forward. Certainly that's what I would have done if I was the landowner. So there would be no reason for the mineral authority to remove it.
Well, I don't understand your point, Ms. Els. The mineral authority has to make an assessment of whether it's required for the steady and adequate supply, and they have made such an assessment in the emerging plan, which is going to be tested or being tested by the other inspector.
That's right, yes.
Yes. So even with the reduced requirement that's being considered in the emerging supply, Hamble Airfield is an integral part of the future supply for a steady and adequate supply for Hampshire County Council, isn't it?
It is included as an allocation again.
Just answer my question, sir. I know it's included as an allocation, but the reason for that is because it's integral to the delivery of a steady and adequate supply for Hampshire.
I wouldn't agree that it's integral to the steady delivery because it hasn't delivered to date and it's gone through, it's now in a local plan review and it's being proposed again. So it's not been part of a steady delivery because it hasn't delivered so far.
Integral to the planned steady and adequate supply, both for the current plan and now for the emerging plan. It's an integral part of that planned approach, isn't it?
It is part of the plan, I would say.
Yeah, it's an integral part of the plan. I mean, it's an allocation. It was an allocation. We're trying to bring it forward. You're opposing, but it's also gone forward into the emerging plan.
Which I've recognised, yes.
Yeah, okay, good. But the reason why I had to put that to you again is because you seem to be trying to undermine that fact by reference to, well, time extensions, windfalls, etc., the ebb and flow of other sites. There may be some ebb and flow of other sites, but nothing detracts from that current assessment as to the need for this site to be allocated for the steady and adequate supply for Hampshire.
What was the question?
Nothing detract. The ebb and flow of other sites does not detract from the need for this site to be allocated for the adequate and steady supply for Hampshire.
Given the lower level of sand and gravel that is emerging in the local plan, I would disagree.
Well, you're disagreeing, even
Yes.
though it's still allocated with that lower level.
It is an emerging allocation, it's an examination, yes.
Okay, so you're basically disagreeing with the emerging strategy plan.
No, I think I was disagreeing with your wording more.
Okay, let's deal with the emerging plan. The emerging plan is looking forward to the steady and adequate supply for Hampshire, even with a reduced annual rate, correct?
Yes, that's like what we've said.
Doing that, it requires this site to be an allocation.
It has proposed this site to be an allocation, yes.
And therefore it's part of, as an integral part of that steady and adequate supply to secure this as an allocation.
It is an allocation in the plan, yes.
I know that wasn't my question, Ms. Ellis.
I said yes.
Okay, good, thank you. So your Appendix KE4, which we were looking at, was talking about extensions. I'm just going to give you examples, but there are a number of reports attached to this where extensions were sought and obtained. And I just want to understand what you're really saying about these. There are all sorts of references to where extensions were sought and granted by the authority for continuation of minerals. There are a number of site-specific reasons why those extensions were sought. In each case, yeah. If you take, I mean, I don't it'd be tedious to go through them all, but you've referred to Bleak Hill, for example, haven't you?
Yes, it's in the table.
It's in the table. If you want to go to the annex in KE4, page 135, paragraph 35.
Sorry, where are we going?
Your annex KE4, looking at the Bleak Hill report.
Okay. Sorry, I was just looking at the table.
I'm just going to paragraph 35.
Sorry, just let me download that. Thank you, yes, I've got that.
The reason why Bleak Hill explained that it needed an extension was because there had been some delays in completing various legal agreements for the planning and the lease of the land.
That's right.
Yeah. So when you tell the inspector in paragraph 5.3.10 of your proof by reference to this table, these annexes, that the reduced market, as you put it, is likely the cause of this, namely these extensions being sought. This is not a fair portrayal of these decisions, is it?
Okay, so
Do you want to just turn up your proof? I'm reading from your proof, 5.3.10.
So yes, I've got 5.3.10 in front of me. I've got the decision or the report in front of me.
Yeah.
In terms of where I've said that, and referring to the market, I would also refer to failures in the market, or rather where the market has slumped. A clear factor of that is COVID, where actually there was slumps in market requirements, and it has led to quarries needing to extend the time period that they are able to work.
Right, just focus on my question, Tels.
Sorry?
Just focus on my question. You were proffering various extensions being sought and then suggesting to the inspector the fact these extensions are being sought is indicative of a reduced market for sand and gravels. I think the general picture you're trying to convey to the inspector is the market's changed, we don't need all these sites anymore, look how many are applying for extensions. That's just an inaccurate and unfair portrayal of the many various reasons why specific sites might have wanted extensions, isn't it?
Market demands is definitely one of
Well,
the
it's not
requirements.
in the case of Bleak Hill, for example.
Well, it may not be in case of Bleak Hill, but
Well,
there is
let's
a
go-
table of 4, and there are other quarries
Yeah, okay,
that
but
I
I
am referring to. And if I could just answer, obviously there are periods of market demand, and part of the appellant's case is that future market demand to deliver housing will increase the level of working and necessitate this quarry from happening, or necessitate this quarry to happen. My case is that there is also the reverse. So in periods of recession, in periods of no development, such as during the COVID-19 period, but also most recently where recycled materials are being promoted, specifically by developers to reduce their costs and reduce their carbon footprints. It is an ever-going trend, in my opinion, that the level of virgin aggregates is falling.
Right, well, that's a pure assertion we'll come to myself, there isn't any basis for, but I can't deal with everything at the same time. Just dealing with your 5.3.10, you've given the inspector an awful lot to read in support of a contention that there's a reduced market affecting these extensions. I've just looked at Bleak Hill, that's not the case there, is it?
No, that's right.
So that should be struck from the list that you gave. It's just misleading otherwise.
The list is just a list of extensions rather than an absolute
Okay, well then
that everyone
let's
is affected by the market.
Let's try another one then. Brams Hill, earlier on. This is, I think, dates from 2015, so quite, no, maybe it's, no, sorry, it's more recent than that. That's the earlier one. Brams Hill, page 8, COVID-19 as a reason for delay.
Yes, as I
Read
said
what
earlier.
the officer's report say, page 20 of the PDF, paragraph 106.
A shift in demand following COVID-19.
Yeah, local quarries struggling to meet the demand. See, I think it's page 20 of the PDF.
Yes.
Page 30, paragraph 187, page 34. Demand for aggregates is increasing.
So, as I was referring to, especially after periods of no development, such as COVID-19, there is then opportunities to develop an aggregate.
Yeah, but the picture is not one of it's all rosy, Miss Els. It's actually local
recovery.
quarries struggling to meet the demand that exists in the area, which is entirely consistent with the absence of a 7-year land bank, isn't it?
I think where quarries are,
Just is that right or wrong?
it is one interpretation of that, yes.
Well, it's the correct interpretation, which if you're being fair about it when you put these reports in, rather than suggest it's a reduced market demand, it's pointing the opposite direction. They say the quarries are actually struggling to meet the demand, which is part of the reason for the extension.
And
Is that right, yourselves?
in terms of where a quarry's been permitted to only build or only excavate to a degree and they want to meet customer requirements, then they extend.
Sorry, am I right or wrong in that analysis? Because it's not something you put to the inspector.
Yes.
I'm right.
In terms of it does indicate some market requirements, yes.
Yes, which is consistent with what we were identifying against the local plan, an absence of a minimum 7-year land bank. The very problem the government is so keen to avoid is occurring.
I didn't know if you wanted me to answer that.
Well, that's right, isn't it?
Yeah, I said that before, yes.
I didn't think you did, but I was saying this report is identifying local quarries struggling to meet the demand, and you said yes. And then I was putting to you that that's entirely consistent with the picture that the planning authority has identified of a need to meet this steady and adequate supply for release of this site. So all of a consistent picture, isn't it?
That aggregate is still needed, yes.
Well, I know it's still needed. There is a current need because of a lack of supply from the current land bank.
But
is that right or wrong, Miss Elves? I don't mind which, but if you've got to explain it by reference to these reports you put in.
the reports identify the reasonings for extensions, and part of my proposal was that extensions have been provided to meet the supply.
Well, extensions in some cases are just simply because of, as we looked at,
COVID.
delay in, well,
Yeah.
in one case because they didn't get their legal agreements and lease in place. That's a simple factor. But where you're referring to other decisions, they're actually evidencing the very lack of supply that the council has previously identified, aren't they?
And the ability to meet that supply through extensions to existing quarries was my point, and has been accepted by the Mineral Authority.
No, not at all. They still think there's a need for release of this site.
But, okay.
Well, that's true, isn't it? This was an extension which doesn't then suddenly meet all of the supply.
If you're asking me why I've included these reports and things, which you did, and I've just answered why I'd included the references to extensions of existing quarries as a resource to existing quarries. And then the fact that the market and COVID-19 has affected the delivery of those extensions is borne out in those reports that I've appended.
That's not what you've explained in your proof, and if you want to clarify it, but you were suggesting to the inspector a reduced market. It's the cause. And the very opposite picture is actually revealed by the materials that you put in. Isn't it?
That is what I've put, yes.
I know, but the opposite is what's demonstrated by these reports on any fair reading.
There are other reasons as well as market requirements. And I do agree that implications such as legal matters and COVID-19, as well as the ability to expand mineral workings, has been reported in those documents I've appended as reasonings for the extensions.
Yeah, it's a very obvious point, Ms. Ells. The reports you're putting in, if you're reading them fairly, only serve to reinforce the need to release an allocated site for sand and gravel because of the way in which the markets, the quarries are struggling to meet the demand. That's fair, isn't it?
Yes.
Thank you. Can we then just cover a couple of other topics that you raised? The first is a suggestion that marine aggregates will be able to fill that gap. And just a couple of points on this. Marine aggregates, first of all, are already taken into account in the plan, aren't they? There's a separate supply figure for that.
Yes, yes it is.
So, and in fact, if you look back at the records, the marine aggregates don't struggle to get to the anticipated 2 million tonnes per annum.
I believe that there has been some difficulties with working the marine
Sorry?
I believe, can you hear me?
Yeah.
I believe that there has been some difficulties with some of the extraction areas for marine aggregates, but that doesn't mean that can't be resolved going forward.
Well, pure speculation, so I'll come to that, but
I believe marine aggregates are still being put forward in the emerging plan.
yes, of course, there's a separate figure
Yes.
again for it, but it's not solving the separate figure required for land one sand and gravel. Is
No.
it? It's not even meeting.
It's another source of aggregates.
It's another source of aggregate, which, and in the delivery of that, it's not even meeting its identified tonnes per annum, 2 million tonnes per annum under the existing plan. That's correct, isn't it, themselves?
I believe so, yes.
Yes. So the inspector can't take any, leave aside, we'll come to whether it's a suitable substitute. The inspector can't take comfort from what you appear to be suggesting, that the lack of supply 7-year land bank in land one is going to be made up by marine, because marine's not even reaching its own
It
expected.
is another source of aggregates.
I know that.
Yeah.
But difference, also we'll come to the difference, but it's not going to make up the shortfall because it's not even making up the anticipated levels of marine one aggregate.
Is that a question?
Yes.
Based upon that, no.
Oh, okay. And then, of course, Miss Pearman has also identified that marine aggregate has its own particular properties, not least the amount of chlorine and shell content, which make it unsuitable as a pure substitute for land one aggregate. You don't
Yes.
dispute any of that.
Yes.
And lastly, the ability to increase the level of marine aggregate in any event is subject to its own challenges, namely at the existing wharfs. You simply cannot just ramp up indefinitely supply the marine aggregates, even if it were a suitable substitute, because of all of the planning considerations that apply to that.
I know, planning is terrible in terms of delaying things.
Yeah, it is difficult.
It is exactly the same as virgin materials being won from quarries. So.
Yeah, but okay, there are all sorts of difficulties, but I'm just tackling the suggestion you appear to be putting forward to the inspector to say, don't worry, it's going to come from increased supply from wharfs for marine aggregates. They're not even meeting their existing levels. It's not a suitable substitute for all aggregates. And thirdly, you can't just ramp it up in that way for all the various planning considerations we're talking about. That's a fair summary. I mean,
Yes.
why you put it in your proof, I don't know.
Because it is another source, and that's what I was identifying.
But not a source that's going to address this problem, is it? For the reasons, those three compelling reasons I've just put to you.
It may do it over the future plan period, which is also what this site allocation of the Hamble airfield is meant to deliver. There's nothing stopping it from changing and from being increased.
Well, I've just given you three reasons. Why are those three reasons any different in the emerging plan?
Well, I understand that it's a slightly different aggregate from the virgin sand and gravels that we're talking about in Hamble airfield, but the future proposals for marine one aggregate aren't restricted. In the future, there is an ability for them to apply and to work those aggregates as they apply and are approved. If there is an increasing market demand, as you set out, then why wouldn't those marine aggregates also be
Well,
increased?
I've just put to you the three problems. One is they're not meeting the current anticipated levels of supply. Two, they're not suitable substitutes for all aggregates. And three, they face their own planning consideration difficulties, even if you could ramp up them, not least pressures for regeneration. None of those three factors have changed in the emerging plan period, have they? To make it suddenly a suitable source of supply.
I still maintain it is a source
Just
of
focus
supply.
on my question.
It may not be the exact same source of supply, but I've still identified it as a source of supply.
I know you have. That's why I'm challenging you, Miss Els, because
And-
you're not dealing with it
It's not.
logically, Miss Els. It doesn't. You agreed it doesn't work currently as a substitute for the problem. It's not. That's not going to change with the emerging plan either. What's changed? It's the same marine aggregate. Its qualities are the same. High chlorine content, shell content. It's got its own target levels, and it's got its own challenges in delivery.
Yes, I agree with all
Nothing's
of those.
changed.
But it is. I still maintain it is an alternative source of aggregate. It is not the same source of aggregate, but it's still a source of aggregate to the market.
Yes, already factored in both to the existing plan and the
I'm not
emerging
disputing
plan.
that.
Yeah, okay. All right. And then finally, on the supply, then recycling of aggregates. That's already built in to the current plan and the emerging plan.
That's right. Yes.
And both the authority, understandably, imposes exacting targets on recycling aggregates and reuse, and they continue to do so in the emerging plan.
That's right, and that they're aspiring to do bigger and better things with recycling, reducing infill, and striving to do more. So I see the ability of secondary and recycled aggregates as expanding under the next local plan.
Well,
the
you
next
say it's
minister's plan,
expanded.
sorry.
They've already factored it in and presumably done as challenging as target as possible. But notwithstanding that, they still need the Land 1 Hamble airfield allocation,
It is still in the plan, yes.
having factored in the most challenging, optimistic views about recycling.
Whilst also taking into account secondary aggregates, yes.
Well, okay, thank you. And then leave aside source supplied, your other, I think, only other part of your proof on aggregates or the proposal, and that's a suggestion that there may be a lack of inert material to achieve restoration. Just a few questions on that, if I may.
Yes, please.
First of all, I've hunted through your evidence, but I have not identified any empirical basis for suggesting that there is a inadequate supply of inert material to allow the restoration proposed here to take place.
That is right.
Right.
In terms of, let me just have. So in my proof, I've referenced the availability of inert waste as informing the timescales for remediation, but then also how that is being promoted as use in other development and construction industries. In terms of inert waste, a lot of that does come from the development industry through building and construction.
Yeah.
And from my experience, a lot of cost cutting through development is now being highlighted so that as much as inert waste as possible is kept on site.
Right. So, okay, again, just your experience, there is no evidence of a lack of inert material to restore sites. For example, as Ms. Pearman identified, in this locality, Bleak Hill, operated by CIMEX, is receiving inert material, even with your point about people keeping as much as they can, without any issues of sources of supply.
That is one example, yes.
Well, there aren't any other. Well, just if I mean, the inspector would need assistance on this, Ms. Elsie, if you were identifying any examples. But go to paragraph 261 of the committee report. E1, CD E1. Paragraph 261, and it starts, the concern was raised, acknowledged, and the Mineral Planning Authority said there is no evidence presented to the authority which suggests that this will be an issue. Indeed, recent experience with other quarries elsewhere has shown it not to be a significant issue. Have you seen that, Ms. Ells?
261 was it?
Yeah.
Sorry, I've gone by it. Yes, I can read that, yeah.
Right. Can we agree the Minerals Planning Authority are very well placed because they're dealing with all of these minerals and restoration schemes, monitoring them, that if there were an issue in Hampshire about the lack of availability of inert material, they'd know about it?
Probably, yes.
Yes. And therefore, you don't produce any evidence of it. CIMEX produced positive evidence that there isn't a problem for their site, and the Mineral Planning Authority is not aware of any evidence that this is an issue.
I think in my section at 5.4, in my proof, the main point that I was trying to convey is that any delays in the provision of inert waste that would delay the restoration of phases hasn't been appropriately taken into account through the application assessment because...
Well, that's a different question, Ms. Ells. Can you just tackle what I was... there is no evidence, indeed there's positive evidence from the appellant, that there'll be any delay in restoration, is there?
No, but I still believe it's an important factor that should be assessed.
Well, you say that. If it's not, if there's no evidence it's going to be an issue, then I'm not sure why you think it needs to be assessed. But let's just entertain that thought. I just want to understand the facts. You referred to the inspector's decision in a different location, the castle, in considering a proposal for extraction there, where there was considerable debate about whether there was inert material and lots of evidence about that.
That's right, yes.
Yeah, that's a very different situation to the position that pertains in Hampshire.
But potentially that issue could happen, and I believe that in terms of the environmental statement undertaken, that should have been taken as a potential consideration.
Well, not so, Ms. Ells, but I'm just dealing with the facts. We agree it's a different factual situation. There was evidence, the inspector found it difficult to make a conclusion because of the conflicting evidence. Here there is no conflicting evidence.
I agree that the committee report confirms that there is no issue at this time.
And the appellant,
That's right.
as an
yes.
experienced operator operating in this area, has no difficulty finding inert material.
At this time, yeah.
Right. And then as to whether or not one needs to assess something which isn't an issue, or no evidence of an issue, we don't think there is. But can, again, just contrasting it with the Lee Castle decision, if there were any delay in availability of inert restoration material, the issue, so it's ultimately up to you what your decision was about, but I'm just going to suggest to you, Miss Els, that that was a case where there was a particular problem in terms of the impacts of that development on the greenbelt.
A green belt was a consideration.
Well, it
for
was
policy.
the main consideration. It was the reason why it was turned down. Impact on the openness of the greenbelt.
Yes.
Because that's an important policy designation, and the continued operation was considered to have a particular impact in that location. And then the continuation of that activity would extend the impact on the openness of the greenbelt because it would be left unrestored.
So,
Is that right, Miss Els? I mean, the inspector, so I know you know the decision better than else, but I'm just going to put to you that, Miss Els, that's a fair, at least a reasonable summary of the concern that arose in relation to impacts on greenbelt and the potential for inert material to expand the restoration period.
yes, the relevance of the green belt in that appeal decision was concluded as being the main issue, but my reference to it wasn't about the greenbelt harm, it was the fact that there can be quite a long continuation period if the restoration is delayed.
Yeah.
And that was my reference to it, and that's the point.
Well, that
that's
was because it
included.
would, in that case, it would perpetuate the harm to the greenbelt before restoration occurred.
And in the instances
Is
of
that
Hamble,
yes? You said
yes.
and, yeah, okay.
And in the instances of Hamble Quarry, it's relevant because it perpetuates the detriment and the impact that the Rule 6 party have identified.
Right. Well, that's where we part company. So, just to be clear, no evidence that this would occur, and I'm not suggesting it, but I'm just exploring what you're saying. There is no such equivalent designation for Hamble Airfield in terms of greenbelt or any other landscape designation, is there?
No, we're talking about not the impact on Greenbelt, because
Okay. So
the site is not in Greenbelt. It is the impacts that the Rule 6 party have identified in relation to highways, hydrology, hydrogeology, which are our main issues.
right, let's just test those then. So far as highways are concerned, if it takes longer, it's because there'd be fewer lorries coming in with the inert material.
Or if there's a pause during
Yeah,
the quarry.
but then it's not going to result in more HGVs. It just means that they'll be spread out or won't occur for a period of time. So it's not going to increase any concern you have about safety or numbers of vehicles travelling down the Hamble Lane.
It's in relation to the delay in remediation or the delay in, or should we say,
Right,
the
Miss Elshie,
extended time period
I know
over
that's
which
what
the
we're
effects
talking.
take place.
Yes, that's
So
what
if you're speaking specifically about lorries,
well,
and
you
there's
were.
Sorry?
You gave me three things: highways, hydrogeology, and recreation, I think. Or,
Yes,
yes.
they're
So
our main
that's what I'm
points.
testing it.
Yeah.
It wouldn't have any, if this were to occur, I hasten to add, we're not anticipating it to occur, and there's no evidence it would occur. So I'm putting it on that basis, just in case people are listening. Remember, we're not anticipating staying here any longer than we've identified. But if it were to occur, and we were to seek consent for extension or whatever, dealing with those three things, HGV traffic, it would mean the lorries hadn't come in because the material wasn't there. So it's not going to increase the impacts in terms of HGVs usage or numbers of HGVs on the Hamble Lane, is it?
I agree that it could slow the number of trips, the number of movements of HGVs.
So it's not going to have an equivalent additional impact of the of the type
If
that
I
were
could
raised
finish.
in sorry.
It would definitely, it could slow the number of trips, but then it's still the same amount of aggregate to be worked, so it would be over a longer period of time.
Yes, but I'm just seeing whether that has a highways impact in terms of safety or,
From the Rule
or
6
congestion.
parties' perspective, yes, it has a longer risk to the pupils using the road and to the disturbance to Hamble Lane.
All right, well, not a longer risk. It's a different. I mean, because there would be reduced numbers of vehicles. But if the conclusion is that the safety is acceptable and the congestion is acceptable, then there isn't any enhanced or additional harm from extending from that perspective, is there?
I think the Rule 6 parties' case is that
I'm just asking you to tackle the question. I'll try again.
okay.
We're not anticipating any extended duration. There's no evidence that that's going to occur. If it were to occur for any reason whatsoever, it would mean that lorries hadn't come in at the expected number. They would then be coming in for a longer duration, however it was. That is not going to add any additional safety or increase in traffic of the type you're concerned about.
Our case is that
And that's not going to be an answer to my question. I'm not interested in your case.
One of the things you're going to have to do, I think, is give your professional opinion.
yeah,
I know you keep deflecting to the Rule 6 in our case, but you have a professional duty as a professional
know.
planner and your obligations to give your professional opinion. So I'm afraid you can't keep deflecting to our case
Don't
or
worry.
the Rule 6 because it's your professional opinion that you're being asked about.
strictly yes.
Thank you. Hydrogeology. Same point. In fact, the hydrogeology concern, as I've understood it, is about the extraction rather than the restoration.
That's right, yes.
It's not going to affect that, is it?
No, it shouldn't do.
And then recreation, we've already identified, and I know you disagree, but the recreation provision, the alternative permissive path and the extended area will be available during construction. And so the impact, if any extended duration, is that for that part of the site which isn't restored, there's a however longer period it may be before it's restored. That's the extent of it.
So in terms of walking on the area of the site where the eastern side, where the permissive path will be proposed, then yes, I agree.
And in that respect, it's clearly distinct from the situation faced in Lee Castle, where extension of time from
Yes,
restoration meant that you were not going back to a greenbelt scenario.
yes.
Yeah, thank you very much. Thank you very much. Those are all my questions.
Thank you.
Thank you.
Just in terms of timescales, what would you like to do? Would you like to carry on or do you take a break at that point, Mr. Fulbrook?
So I think I don't have a huge number of questions about where it is, if the witness is happy. We prefer to get through that.
Okay?
And then
Are you okay, Ms. Sells? Yeah. In which case then we'll carry on, then take a break when you've completed.
thank you, sir.
Thank you very much, Ms. Fulbrook.
So, Ms. Ells, just a question first of all about 7-year supply. So, if you could turn up a core document K27, which is the LAA,
Yeah,
and go to table 3, which I think is on page 15.
yeah.
So I think just want to understand the position in terms of 7-year supply. So if you look at that table, you can see there's a second column, land bank based upon local requirements in years.
Yeah,
And so the combined soft sand and sharp sand gravel land bank is 6.94 years. But then the sharp sand and gravel above is 7.39 years. And And of course, we know that this site's delivering sharp sand and gravel. So, I mean, it's in terms of understanding the available supply, what's the relevance of there being 7.39 years of sharp sand and gravel based on the local requirement?
Well, in terms of the local requirement, that fulfills the 7 years.
And then just sticking with that table, based on, so again, this gives various different options, but based on, say, the 10-year average sales, you have a total for both soft sand and sharp sand, a total land bank of 12.59 years, and then based on the 2023 sales data, a land bank of 17.18 years. I mean, what in your view do these figures say about the importance of this particular site to delivering a steady and adequate supply of minerals in the local area?
So in terms of delivering a supply that meets those averages, it's not needed at this point because we have 12 to 15 years against sales rates. So I would not contend that it's definitely required to deliver aggregate requirements at this time.
Just sticking in this document then for one more question, if I may. You were taken to the evidence that you'd given on quarry extensions, and it was suggested to you that these applications are evidence of unmet need for aggregates and minerals. If I could just ask you to look at paragraphs 2.10 to 2.12 of the LAA. Do you have that?
Is this regarding Marchwood Quarry?
So this is regarding the 3 sites identified there, Marchwood, Kingsley and Roshot, are sites that are currently inactive or currently not extracting.
Yeah.
See that? So I just want to give you the opportunity to comment on what, if anything at all, this might tell us about the extent of unmet demand for aggregates.
Well, certainly in terms of quarries where they have been consented to extend or to expand, there is some question mark over the level of market requirements. Certainly Kingsley Quarry, my investigations with Tarmac Limited have identified that it is now active. So it is actually working again in its extended area.
Okay, and then finally, if you just turn to your proof of evidence.
Yep.
It was said to you, I think, that you had not, omitted to take account of the weight to be given to mineral supply according to paragraph 224 of the MPPF in your planning balance. And obviously, you rightly pointed out, in fact, that you did mention that particular paragraph and the need to give great weight. You weren't taken, I think, to, and that was at paragraph 4.6.5, 4.6.6 of your proof. You weren't taken to paragraph 4.6.8, where you say it can clearly be identified that the requirement to supply minerals is an important consideration and is given beneficial weight when making mineral local plans and determining applications. Can you just explain what are you doing here in relation to giving weight to the requirement to supply minerals?
As I think I've tried to maintain, is that the delivery of these sites for aggregates and these allocated sites as well is on the basis that they don't have unacceptable adverse impacts, and that informs the whole of the development plan, including the mineral and waste plan, in terms of delivering a sustainable supply of minerals and to meet that 7-year requirement from the framework. Meeting the requirement is a valid material consideration, but above else or above other factors is the fact that it should be done appropriately, and it isn't just a carte blanche to do the quarries or do the excavations without consideration of other impacts.
And can I just to be clear, absolutely clear, when you say the requirement to supply minerals is given beneficial weight, how does that relate to paragraph 224?
Well, that is applying exactly the presumption that I believe the appellant has asked me to take into account in terms of assessing proposals and giving them adequate weight, whilst also taking into account the implications of the application.
Thank you. So those are all the questions I have. Thank you.
Thank you very much, Ms Fulbrook. Thank you for your contribution to the inquiry, Ms Phelps. That concludes your evidence. It's 15:15. That's an excellent time to take a break. We'll take a break for 15 minutes to enable the witness to swap over. We'll resume at 15:30 and we'll start straight away with the evidence of Ms Pearman, evidence in chief. So at that particular point, we can pause the recording and adjourn. Well, welcome back everyone. It's now 15:30. The inquiry is now resumed. We're going to go straight into evidence in chief from Emma Pearman on behalf of the appellant. So, Mr. Strawn, could you please introduce Ms. Pearman to the inquiry?
Thank you, sir. You should have a proof and a rebuttal from Ms. Pearman. We'll also be referring to Ms. Elsa's document and the LAA if necessary, as well as the plan documents, but we'll see how we get on. You're Emma Pearman. You're a chartered member of the Royal Town Planning Institute. You hold a master's degree in spatial planning and a bachelor's degree in human geography.
Yes, that's correct.
You're the principal development planner at CEMEX UK Operations Limited. You've got over 16 years experience as a planner. The last 6 years working in the mineral planning development for mineral planning development at CEMEX. Prior to working there, you were a senior planning officer at both borough and county councils.
That's correct.
Your role at CEMEX as part of the planning team is to prepare and coordinate the production and submission of both planning applications and accompanying environmental statements. And in the Hampshire area, you've been involved in planning applications at Bramshill and Eversley quarries in the northeast of the county. And further afield, you've dealt with the site at Staffordshire, and you've also prepared other applications in various parts of the UK, including Nottinghamshire, Cheshire West and Chester.
That's correct.
You referred paragraph 2.6 to various awards that CEMEX has won in relation to some of its sites and its partnership with RSPB as well as part of your context, your evidence. And you explain that you provide planning evidence in support of the proposal. You're familiar with the site as well as the relevant policy. And you explain the broad context of your evidence relating principally to need, but also the planning issues in relation to, amongst other things, recreation. I'll come back to that if I may. So with your permission, I'll just ask, I think, Ms. Pearman to provide the summary of her evidence from the executive summary, perhaps picking up at 1.3 if that's acceptable.
So starting with 1.3 of my proof, CEMEX currently operate approximately 22 quarries around the UK. The company has many years of experience in managing sand and gravel quarries, ensuring that they are run to high standards of health and safety in accordance and compliance with the relevant planning permissions, imposed conditions and environmental permits as appropriate, and with minimal environmental and amenity impacts. My proof of evidence also addresses the need for the mineral in light of assertions made by the Rule 6 party, the Hamble Peninsula Defence Group, HPDG. It is common ground with the Hampshire Minerals and Waste Planning Authority that there is a need for the minerals and their extraction from the appeal site. It has already been through a process of evaluation by the MWPA in terms of its suitability for aggregate extraction through both its allocation in the adopted Hampshire Minerals and Waste Plan 2013 and its proposed retention as an allocated site in the recent Regulation 22 Partial Update Submission Plan, which I refer to as the Emerging Plan. This was submitted to the Secretary of State in July 2024, with the examination having taken place in February 2025. There is a clear need for this allocated site to supply sand and gravel to this part of South Hampshire. The County of Hampshire currently has a sand and gravel land bank lower than the minimum 7 years predicated in the National Planning Policy Framework of paragraph 226F, based on the local requirement as set out in the Hampshire Minerals and Waste Plan. Although the aggregate provision rate in the Minerals and Waste Planning Authority's latest local aggregate assessment indicates that the land bank is over 12 years based on the APR, that calculation includes sites that are inactive and is not reflective of what the land bank position will be when this appeal site will commence operations, the exporting of minerals being unlikely to commence before the end of 2027. By then, many existing sites will be exhausted of sand and gravel. At that stage, the current APR for sharp sand and gravel will only be able to be met if the currently inactive sites begin exporting sand and gravel. In any event, the 7-year requirement for a land bank is only a minimum and it does not inhibit other sites coming forward. The emerging plan allocates 4 new sites, which includes the appeal site, in addition to existing sites, to provide a total reserve of approximately 11.4 million tonnes of sand and gravel. The Minerals and Waste Planning Authority consider this is only sufficient, however, to last until 2035, along with existing operational sites. As the plan period is to 2040, the plan has to rely on windfall sites to make up the shortfall. It is crucial, therefore, that given this shortfall, the 4 allocated sites in the emerging plan, including this one, come forward. There are no other Land 1 sites close to the appeal site which will be well situated to serve the urban areas of South Hampshire. Most of the sites in the county are concentrated in the New Forest area or in the northeast of the county. The appeal site would supply a sustainable source of sand and gravel to the urban areas of South Hampshire where most of the new development is likely to be located, thereby preventing the need for longer HGV journeys across the county and the associated effects. Hampshire is also significantly constrained by landscape designations, whereas the appeal site at Hamble is free of designations and is able to contribute sustainably to the need for a local supply of sand and gravel. As noted below, there are significant infrastructure projects planned in the local area, and it's clearly important that impacts on climate change are minimised, particularly given that Hampshire County Council declared a climate emergency in 2019. HGV should not have to travel significant distances from other sites to supply local projects. The LAA does not take account of the aggregate which will be required as a result of the significant uplift in housing numbers now required by the revised NPPF and PPG. This would see around a 40% increase in housing numbers in Eastleigh alone and over a 50% increase in the plan area as a whole. It is therefore considered that there is a clear and demonstrable need for the mineral at the appeal site to contribute to the future supply of sharp sand and gravel in this part of Hampshire. HPDG have also raised concerns about the impact of the proposed development on the existing unauthorised recreational use of the appeal site. They have suggested that the appeal site is particularly suited for walking dogs off the lead, and they have claimed that this is not replaceable at other sites in Hamble. They have also claimed that the nearby Royal Victoria Country Park is unsuitable for this due to the high number of children using the park. However, as set out in more detail in this proof, the country park actively welcomes dogs which are under control, with appropriate facilities provided for dog walkers, which is not the case for the unauthorised users of the appeal site. It is certainly not the case that dog walkers currently trespassing on the appeal site would necessarily go to the designated sites instead, as is suggested by HPDG. The park has clear paths from the housing area and the appeal site to reach it, which may be even closer for many people. In any case, the appeal site is private and current recreational use is unauthorised. The appeal site is not suitable alternative natural green space, SANG, and as a private site should not be relied upon as mitigation for the impacts of residential development close to designated sites. In addition, the appeal site owners, Persimmon Homes, could fix existing or erect new fences at the appeal site at any time without planning permission, displacing the recreational use in any case. I understand in any event it is currently the council's responsibility to fix or erect new fences along the southern boundary of the appeal site due to the nature of the lease they have with Persimmon Homes. The proposal includes a new permissive path around the outside of the appeal site, linking the housing areas to the northwest corner where the schools and station are located. This will provide a more suitable and clearer path through the appeal site than currently exists, so as to encourage walkers and sustainable travel. Upon restoration, there will be an additional public recreation space in the northeast corner of the site, as well as the expansion of the permissive path along the western side of the appeal site. This provides a clear benefit in terms of public recreation when compared with the existing position.
Thank you. And so rather than get Ms. Pearman to read her rebuttal proof of evidence to Ms. Else, which you do have at CD 30, is it D? No. Missing the letter on it actually, CDL 30. Which? Oh, I'll find out for CD number. But in any event, I wasn't going to ask Ms. Pearman to read that out, but instead, if you're happy, I'll just deal with some topics with her instead. So, Ms. Pearman, first of all, I think it's now common ground that, as a result of discussion with Ms. Els, that there is no requirement to demonstrate need for this site in light of the allocation in the plan if the other considerations are met. Do you agree? Do you want to comment on that?
Yeah, Policy 20 of the adopted plan supports extraction from the new sites listed, including Hamble, provided that the proposal does address the development considerations in Appendix A. Nothing in the policy or Appendix A require need to be demonstrated at the time of the application submission. Policy 20 only requires need to be demonstrated for sites that are not allocated.
I think you've tackled that in your proof at paragraph 6.5. Can we then just turn to question of supply? The policy 17 in the adopted plan identifies a supply of sand and gravel at a rate of 1.56 metric tons per annum, I believe. And can you just help with how you then have identified and what you say the level is of the land bank by reference to that identified requirement?
Yeah, so I think as we've heard earlier today, the land bank's currently less than 7 years in total based on the requirement in Policy 17. We heard that the land bank was 6.94 years at the end of 2023. That's obviously 18 months ago now. So if we assume depletion at the APR rate, the land bank would now be around 6.3 years, so below the minimum 7 years.
Thank you.
I should have done that. I just missed that last answer you gave there, just in terms of that last little bit, and I do apologise, but could you repeat?
Yeah, what I was saying is in the LAA, it says that the land bank is 6.94 years at the end of 2023, but that's now 18 months ago. So if we assume the land bank has depleted at the rate, the APR rate set out in the LAA, which is the average over the last 10 years, essentially, it would now be around 6.3 years.
I just right quick enough for that last bit.
It's quite a good.
How do I turn this? Have I turned everyone's microphone off? No, yours is still on. Yeah, you've got the overall control, I think. So how do I take control away of? This is not bad actually, Mr. Strawn, to be able to, I didn't realise I'd got one of those.
You discovered it too late in the inquiry, so you could cut everyone off before.
If I'd have got that from day one, I'd have been well away. In fact, we'd have all got home early last night.
Indeed, we would have only been on day one.
You're back on.
Okay. Thank you. And I was just going to say CDD 30 for those who are wanting to follow is the rebuttal proof. But as I said, we're not going to read it out. Sorry, you're happy, so I'll just continue then. Then turning to the land bank as calculated by reference to the APR rate in the LAA, can you just help with what assuming if one were to use that rather than the local plan rate, what the figure would be?
Yeah, based on the APR rate in the LAA, the land bank was 12.16 years at the end of 2023. So again, if we assume depletion at the APR rate, 18 months on it would be around 11.1 years. But just to point out that Policy 17 doesn't have any flexibility to defer to that APR rate. It simply says that provision will be made based on the rate in Policy 17, which is 1.56 million tonnes a year.
Thank you. And then if we take, although I appreciate the caveat you just made, but if you take the APR rate and rely upon the land bank by reference to the APR, can you just help with why you have identified issues with relying upon the existing sources of supply?
Yeah, so as confirmed by the Mineral Planning Authority, the land bank contains sites that are inactive, including 3 million tonnes in one site, which is yet to commence operations, which is almost a third of the land bank. And at the moment, we don't know when they will start exporting. The MPA also says that a large proportion of the reserve is contained in one site that makes the supply vulnerable if issues are encountered with that site.
And so just, if it helps, I think, Ms. Pearman, that's covered in the committee report for this case, isn't it?
Yeah.
Paragraph 244 of CDE1. That's Blashford Quarry, isn't it? Plumley.
Yeah, that's the quarry with the large reserves, yeah.
With the large reserves, yes, thank you. The 3 million tonnes in one site, which is inactive.
Row shot, that one.
Now, can you help? In your view, does the LAA with the APR, look at all these acronyms, but anyway, the local aggregate assessment and the APR rate affect the need, as you've identified it, to bring forward Hamble Airfield now?
No, I mean, notwithstanding what I just said about policy 17 not deferring to that rate, the MPPF says 7 years is a minimum, and planning practice guidance says that where there exists an adequate land bank, applications can still be brought forward for several reasons. Those reasons include known constraints on the availability of consented reserves. In this case, as I just explained, there are sites that are inactive. There's a large proportion of the reserve in one site, and a number of sites will be finished in the next few years, probably before Hamble comes on stream. And another point in the PPG is if the location of the consented reserve is inappropriate relative to the main market areas. So in this case, we've got no other land one sites close to this part of urban South Hampshire.
And Ms. Els agreed that she wasn't identifying any better located site to meet the need. Are you aware of any better located site for sand and gravel extraction to meet the localised needs that reference has been made to?
No, I mean, obviously there are sand and gravel reserves in the ground, but if there were suitable sites, they'd have been brought forward as part of the call for sites, which happened recently, as part of the emerging plan. And all the sites that were brought forward, the Minerals and Waste Planning Authority would have assessed, and no other allocated sites are proposed in this area. The other three allocations are all towards the New Forest.
Thank you. Can we just turn to the emerging plan context, Ms. Pearman? The LAA indicates that sales have been lower than the 1.56 metric tonnes per annum in the local plan in policy 17. And as we've heard, the emerging plan has a new proposed figure, which I think is 0.9. Is that right?
Yep.
Can you just help with, having got that new figure, what the approach is of the emerging plan towards Hamble Airfield and why that is?
Yeah, so the emerging plans we've heard has got a much lower figure of 0.9 million tonnes a year, which is based on the 10-year sales data. It's a similar figure to the last 10-year sales. And despite that far lower figure, Hamble's still required. It's still an allocated site alongside three other sites, again, which I just said, and none of them are close to Hamble.
Can you just help the inspector with the three other sites and where they are?
Yeah, the three others are Midgham Farm, Purple Haze and Ashley Manor Farm, all in the New Forest area.
And do any of those have permission yet?
So none of them have permission. They've all had applications submitted. I think Ashley Manor Farm has a resolution to grant, but the one is still awaiting signing of the 106. Purple Haze has been in for about 4 years now, and as I understand it has an outstanding Natural England objection, which it's not clear whether that will be resolved. Midgham Farm was submitted only about 6 months ago, I think, so we're still at the regulation 25 stage with that one.
Thank you. Then dealing again with the emerging plan, then you cover this in paragraph 6.8 of your proof onwards, but you've identified that the emerging plan with those 4 allocations is actually only identifying a supply up to 2035, I think, although the local plan period is to 2040. Have I got that right?
Yeah, that's correct.
So what's the consequence then of what the emerging plan is relying upon for those future years?
So the emerging plan relies on those 4 allocated sites as well as the existing sites that will still be operational at that time, and it relies on windfalls after 2035 to make up the shortfall that they envisage after that time.
And what do you say is the implication of that for the release of Hamble Airfield now?
So I think it makes Hamble even more important, because if you're experiencing a shortfall, it's even more important that sites you have allocated come forward. There's windfalls, there's no guarantee, and obviously whether that approach is acceptable will be determined through the examination and public process of the emerging plan.
Thank you. Can we just come back to the location of this site? And Ms. Els agreed about the relevance of location from a national policy perspective and the suitability of that, in that sense, of meeting the need. I don't know if you maybe want to illustrate this just by reference to the map. I think there was...
Yeah, I think it's page 27 of my brief, and the
Yes.
same map is page 11 of the LAA.
Just get that up, page 27. That's the plan from the LAA. So you've got that in the LAA as well, but I think you've extracted it, Ms. Pym, haven't you? And can you just explain, or just give some context as to what you're identifying as to why Hamble Airfield is important in the local need context?
Yeah, so as you can see from that plan, most of the sites are concentrated around the New Forest area, with some of them in the east and the northeast of the county. So Hamble is the only Land 1 site that's kind of close to the urban area between Southampton and Portsmouth, which is probably the largest urban area taken together in the county. You can also see on that plan that large proportions of the county are covered by national park and national landscape designations, where there is, it's not a presumption against, but it's both national policy and local planning policy seek to find sites outside of those areas, preferably.
Those are, in my version, covered by different green shades of green,
Yeah.
but I hope you can make them out, sir. But I'm not going to try and distinguish verbally between the shades of green, but they're different. Yeah. Thank you. Now, something you've covered in your proof at 6:28 to 6:30, I've already discussed it with Ms. Kirby-Hawkes and Ms. Elves, but just can you see if you want to add anything to what you've said in those paragraphs? This is about whether the LAA yet takes into account the new housing requirements for Hampshire County Council. And I think it's common ground that it doesn't, but just help us with that, please.
Yeah, so the government have obviously committed to building 1.5 million homes, and as I understand it, it was over the next 5 years from when they said it, which was 2024. We've heard this morning from the Minerals and Waste Planning Authority that although it's mentioned in the LAA doesn't account for the uplift, and I think Lisa Kirby-Hawkes suggested that that would come forward in the next LAA. The 120,000 homes referenced in the LAA, as you can see from the footnote, come from the Strategic Infrastructure Statement 2019. And the growth factors referred to in the LAA also, if you look at the footnotes, none of them are dated from, they're all dated before December 24, which was when the new requirement came in to the MPPF.
Okay. And do you agree with what Ms. Kirby-Hawkes identified, and I think even Ms. Els, that the effect of that, once it's factored into mineral requirements, and sand and gravel in particular, will increase the requirements for sand and gravel in Hampshire?
Yeah, I think that increase will be extremely significant. I mean, as I've said in my brief, the Mineral Products Association say 200 tonnes needed per house. I think we've done some calculations there, but it's in the region of 800 and something thousand a year for Hampshire as a whole, by my calculations.
Thank you. Can we then turn to reference being made to marine sand and gravel? And I had some discussion with Ms. Else about that, but can you just assist insofar as marine one sand and gravel, whether that's already catered for in the plan and emerging plan, and also whether it can serve as a substitute for any shortage in land one sand and gravel.
So marine is needed in addition to land one, which is set out in policy 17 of the existing plan and the emerging plan. The Minerals and Waste Planning Authority make a separate requirement for a marine of 2 million tonnes per year, which I think is the same in both the adopted and the emerging plans. If you look at the 10-year sales data in the LAA, it's never contributed 2 million tonnes a year. The average is 1.4 million tonnes a year. So it's not clear whether it will be able to reach that 2 million tonnes, but last year it did ramp up to 1.9 million tonnes, which was the highest in the last 10 years. Marine is often a substitute for land one, but it can't always be due to the chloride and shell content. So it's not suitable for certain strengths of concrete, which is why you need both. And there's also a finite capacity at existing wharves and other challenges such as traffic generation, size of plant and stocking areas, the size and cost of new ships. It costs about £100 million to build another ship, so it's not that you can easily get another ship to come in. So there's many challenges for existing wharves in terms of increasing supply, and it's definitely not the case that wharves can simply increase to meet demand. There's also pressure on sites from regenerating waterside areas. This is something we've experienced at Leamouth Wharf in Southampton, where the City Council have expressed a desire to regenerate that area. So what that means for the future of that wharf, it's not clear at the moment.
When you say we, that's a Cemex wharf providing a source of marine sand and gravel. Thank you. Thank you very much. So that was quite a few figures that came thick and fast there. But if Ms. Pimmon's going too fast, 2 seconds. Can we then turn to recycled sand and gravel, because that's been raised by Ms. Else as a potential source of supply. Again, can you just help how that's dealt with in the plan and whether there's any scope for that to make up the shortfall in supply of land one sand and gravel?
Yes, again, recycled sand and gravel has been taken into account in terms of the overall supply. Policy 17 of the adopted and emerging plans has a separate requirement for recycled aggregate. So the amount of the contribution has increased significantly in the emerging plan to 1.8 million tonnes from 1 million tonnes in the adopted plan. This is despite the 10-year sales data showing that the average is 0.81 million tonnes, with the highest ever being 1.1. So it's not clear whether they'll be able to reach the 1.8, but obviously it's a good thing to try and recycle waste. It's higher up the waste hierarchy, so no issues with that, but it's an ambition that may not be able to be reached, and if it isn't, that would mean pressure on other sources of supply. Recycled aggregate does have variable properties as well, so it's definitely not a straight swap for land one sand and gravel. It's not generally used in concrete where higher strengths are required. You wouldn't build house foundations out of concrete made from recycled aggregate, for example. And also, just to note, the data on it tends to be unreliable, as noted in the LAA. So it's difficult to plan for supply because of that reason as well.
Thank you. You've referred to the LLA. If the inspector wants to see how that's dealt with in the LAA, I think it's in section 3, isn't it? Pages 16 to 17 and table 13. unless I got that wrong.
Yeah, section 3.
Okay. Thank you. Can we turn then to the topic of inert material coming in for restoration? There was initially a point, I think, being raised as to whether use of inert material for restoration complied with waste policies 25 and 30. I'm not sure if that's still being pursued, but can I just get you to comment on that, please?
Yeah, so policy 25 or the Minerals and Waste Plan says that the long-term aim is to divert 100% of waste from landfill. And they say waste development should encourage waste to be managed at the highest level within the waste hierarchy. So by sending inert waste to restore a mineral site instead, you're diverting it from landfill, and therefore it is in accordance with that policy, which is what the Minerals and Waste Planning Authority also say on it.
Well, I think that's covered again in the officer's report, isn't it? At
Yeah.
paragraph 256 through to 260. So there's no dispute between you and the Minerals Planning Authority on that. I think there's a suggestion that inert material will have recycled material in it. Is that the case, that you receive inert material with yet to be recycled material in it?
No, the inert material we receive to restore our sites has already had that recycled element removed, and I believe that's in the planning conditions for this site as well.
Thank you. So just completing on that point, there was a suggestion, although I've explored this to a degree with Miss Else, that there might be a lack of inert material. We explored whether there was any evidence for that. Can you assist, Ms. Spearman, based on CEMEX's operations in Hampshire, whether there's any lack of supply of inert material to achieve restoration?
Yeah, so we haven't experienced any lack of supply to my knowledge at Hamble Warren, which is a site operating in Hampshire.
Just, you use Hamble Warren as a name, but
It's got many names, Bleak Hills and
okay, just
yeah.
because we've referred to Bleak Hill earlier on, sir. So, but you've got different names, but that's the same site. Yes,
Yeah,
thank you.
yeah.
Sorry, carry on.
And I think, as the Minerals and Waste Planning Authority say, they haven't seen any evidence to say, and they've not experienced any issues with supply. It's also the case that once the inert restoration material comes to our site, the recyclable elements have been removed. So if there was an increase in recycling, it still wouldn't affect us. We don't have a shortage of supply of the residual material that can't be recycled.
Thank you. Is there anything else you want to say about need and aggregates? I'm going to move to
No,
recreational. So on recreation, please, just briefly, you cover this in your evidence. It's also been covered already, I know, by Mr. Delahaye. So I'm not asking you to repeat any of that. But can I just get you to explain your own view as to the notion that what we're proposing in terms of when extraction is taking place with the permissive path and the accompanying areas, the contention being that it will cause people to walk their dogs, etc., in the designated sites. Can you just comment briefly, Ms. Pym, where you think that's realistic?
I don't think that's realistic, because we are providing not just a 3 metre wide footpath, but as we discussed in the inquiry in April, a wider area throughout the time we're operating and on restoration, and that's secured in the legal agreement.
The red, no, there we go, it's come back in.
Okay.
Must be a loose wire.
So we will be providing proper exits as well around the site that don't currently exist. So obviously, while it's easy at the moment to get in, at the southern end of the site, when I've walked around the northwestern side, for example, you have to crawl through a hole in the fence to get out, and we'll be providing proper exits around the site, as shown on our landscape operational plan that we submitted with the application. It's obviously there are designated sites around, but my experience of those sites is that they don't provide a similar experience to walking on Hamble Airfield. They are, the one at the bottom of the Royal Victoria Country Park is a beach which kind of covered with tide half the time. There's the marshes, and when we've walked on there, it's a completely different experience. It's not a kind of an open site. It's very watery, and as you would expect, being right next to the water there. So there's also a huge amount of other recreational routes in Hamble that are not designated. On the appeal site visit with the inspector, we walked some of those routes from the Hamble station all the way down to the Royal Victoria Country Park and around the country park. We saw many dogs off the lead in the country park, and none of those are covered by the European site designations.
Thank you. And then just some miscellaneous topics before I hand you over for questioning. Lorries, I know I'm not asking about transportation evidence, but just in relation to a suggestion as to the way lorries might arrive late to the site and a concern about lorry drivers then parking up elsewhere or sleeping overnight. You recall that there's a question raised.
Yeah.
Can you help so far as, because you're part of CMEX's planning team, whether that is in how CMEX lorries operate for provision of sand and gravel in this area or any area, whether it's that sort of activity?
Yeah, I think as we heard from Ben Howard this morning, our sites tend to operate to deliver construction materials to construction sites, which tend to work from fairly early in the morning and finish fairly early in the afternoon, around kind of 3 or 4 o'clock. So it's not the case that there will be lorries coming to the site. So we're proposing to close at 5 o'clock. Not the case that lorries would be coming to the site at that time to deliver to construction sites, because those sites will have shut down for the day. So I've never heard of a case where lorries are coming to a site out of hours and that's been an issue at any of our sites. It tends to wind down significantly before 5 o'clock, and that closing time of 5 o'clock is to allow for HGVs to come back to the site as necessary and park overnight. So if you've got an HGV coming down Hamble Lane close to closing time and they are stuck, that's going to be a CEMEX truck that's parking overnight at the site. Probably the driver's going to have their car on site, so they're going to call the site manager to wait for them if there's a problem. But I can't see that being a common occurrence, but that would happen in that kind of emergency situation.
Are you aware of that problem occurring at all?
Never, no.
Thank you. Could I then turn to a different topic, which is a recurring theme about quarries next door to schools and residential development, and you've heard that theme a number of occasions. Can you assist Ms. Spearman? I think we're all agreed, or at least the professional witnesses agreed, that it's about assessing impacts in any event. But can you just assist with, for the inspector, whether it's the case that quarries can occur in near residential areas or near the schools, and indeed quarry traffic?
Yeah, there's obviously been a lot of discussion throughout this application about the proximity to the schools, and we heard today some evidence that from Ms. House that she thinks it's unusual for a site to be in an area close to schools and houses like Hamble is. I completely disagree with that. We've had many sites that are close to residential areas and schools in the past and currently. For example, our biggest site in Derbyshire is Doveholes. That's a hard rock quarry, so it blasts every day, which we're not having at Hamble because Hamble's sand and gravel. It's in a much quieter area. It's got a primary school and a nursery about 300 to 400 metres from the site boundary. Last year, 2.4 million tonnes of rock went out by road from that site, so that's 10 times the amount that will be going out of Hamble. The majority of that went north, according to our sales data, along the road where the school is located, so past the school towards Manchester. Not only that, we've got a great relationship with that school. We've sponsored projects with them. We worked with them and the police recently to reduce speed limits on the road, and our quarry staff have done lend a hand days at that school. We've got another site recently operated in Shepperton, which is a kind of suburban area of southwest London. We've got a score about 200 metres from the playing field to the site. We've got no issues there. We've got an asphalt plant in Birmingham where the school playground backs onto the asphalt plant. They objected at the time before we got permission, but as far as I'm aware, there have been no issues since we've started operating. Again, it's not the same as a sand and gravel quarry, but you've got lorries going in and out, you've got potential issues of noise and air quality, and it's all managed without any complaints from the school. We've got more examples here. In Thorpe, we've got a site that finished around 15 years ago. It's about 20 metres from the site boundary to the school playground, 80 metres to the school building. Again, no issues with that school. I've asked people who were there at the time and they don't recall any issues. Again, they may have objected prior, but once we're operating, there's not any issues.
Thank you very much. Well, I'm sure you can give more examples, but I'm going to cut off there and people can ask you about those if necessary. So finally then, Ms. Perman, just in relation to the planning balance that Ms. Els was seeking to strike and the question of planning balance, you've been referred to the planning statement, or references made to the planning statement that you submitted. Can you just briefly summarise how you see the factors in the planning balance and benefits?
Yeah, so in terms of the overall balance, obviously it's recognised that we will have some minor temporary adverse impacts on the landscape. In terms of noise for only the short-term noisier operations like bond construction, we've got a small amount of...
Just dealing with that, that is what's explained as to when the bunds are then initially constructed.
Yeah.
And when would that take place, as it were, just because I know that people are concerned about noise?
Yeah, so that takes place it would take place at the beginning of the development when we remove the soils from phase 1. In the planning conditions, we have said that we would construct the bunds at the northern end of the site closest to the school outside of term time. So although we're well within the limits allowed for that louder temporary operations, we would do that out of term time anyway, and then we'd be into the normal operational noise, which we've demonstrated will be well within the required limits.
Okay.
So just going through the adverse impacts, have obviously got 3 mature trees being lost at the boundary, and we're putting additional traffic on the road, but none of those impacts have been identified as unacceptable by the Mineral Planning Authority. And that's got to be weighed against the positive benefits, and the MPPF says great weight needs to be given to the benefits of mineral extraction to the economy. We'll be providing a steady source of supply in a sustainable location close to where the mineral is required, preventing journeys from further afield, and that's against the backdrop of under 7-year land bank for both the total and the shop sand and gravel at this point, based on policy 17 in the plan. In terms of the economy, we're also... Sorry.
I'm just getting a little bit of noise that we can hear at the front from conversations at the back. If you do need to speak, I'm afraid you'll probably need to leave the room to do that. Otherwise, unfortunately, I have to ask you to remain quiet while the witness is presenting evidence. Thank you.
In terms of the economy, we're also adding jobs to the local economy, as well as providing work for temporary contractors, paying aggregate levy and business rates. We're also providing biodiversity net gain and over 18,000 trees and shrubs. As noted in the officer's report, the site will be of substantially greater value to wintering birds once restored, as well as substantially improved habitat connectivity. We're also providing the permissive footpath and wider recreation area during working, with proper exits around the site to provide connectivity to the local area. And on restoration, there'll also be the large public access area in the northeast of the site.
You might need to just go a little bit slower, but yeah.
Sorry.
Yeah, I think you might be almost there.
My view, therefore, the substantial benefits we're providing and the great weight that the MPPF says has to be given to the benefits of mineral extraction outweigh the limited temporary adverse impacts during working.
Thank you very much, Ms. Penman. Unless there's anything else you want to add at this stage?
No, thanks.
So that's it for Examination Chief.
Thank you very much, Mr. Strong. Just before I invite the all six parties just to advocate a cross-examination, if you can just speak a little bit slower.
Yeah.
I managed to keep up, but I'm not going to be able to keep that pace up for the rest of the afternoon, I'm afraid. So just be mindful that when you address Mr. Fulbrook, if you can just be a little bit slower, if it's figures particularly, because I just can't get there quick enough. But I will try, and I know it's how you do speak, but if you can just think about when it's something that's important with figures, and I need to get those figures.
Okay.
Mr. Fulbrook.
Yes, thank you.
Cross-examination.
Good afternoon, Ms. Pearman. Just as Mr. Strawn did with Ms. Elson, I'm not intending to put matters to you on the sort of technical questions that we've already been through in relation to the ecology and the highways points. We've already been through those, so I hope everyone's content with me taking that approach. Now, I just want to understand, most of my questions for you will be on the issue of need, but there's just a few points about sort of planning balance and specific factual points I want to go through first. And in terms of understanding how need fits into the equation here, I just wanted to test a couple of points with you. I mean, so obviously the first issue that my clients raise with the development is that you can't rule out an adverse effect on the integrity of European sites. We heard the evidence about that about 3 months ago. Now, you obviously disagree with that, but if the inspector were to agree with us in relation to that, he would have to refuse planning permission, wouldn't he?
I believe that's, the requirement if he identifies that,
Yeah. So regardless of whatever level of need there were for this development, he would have no choice but to refuse planning permission.
Yeah.
Yeah, thank you. Now, just in relation to highways, again, it's our case that there will be a severe impact on the highway network and/or an unacceptable impact on highway safety as a result of this development. Now, again, you will disagree with that, but if the inspector were to agree with us on those points, would you accept again that he would have to refuse planning permission in these circumstances?
I'm just going to go up the MPPF if that's okay.
Yeah. So paragraph 116.
Paragraph what, sorry?
116.
Yeah, paragraph 116 says it should only be prevented or refused on highway grounds if there would be an unacceptable impact on highway safety or the residual cumulative impacts following mitigation would be severe. So obviously if the inspector thought that was the case, he should be refusing it.
Okay, thanks. So again, need doesn't really come into it in those circumstances either.
I guess needs part of the overall balance.
Yeah, so I just want to be clear though, if the inspector is finding a severe impact on highway safety or severe impact on the highway network or an unacceptable impact on highway safety, if he finds that, what's your professional view on the planning balance? Do you think he should still grant permission, or do you think he would have to refuse permission if he reaches a finding that there is a severe impact or unacceptable impact on public safety?
It says prevented or refused on highway grounds if there would be an unacceptable impact. I think it's still part of the balance, but he might find that that outweighs the need.
But what's your view?
My view, it's part of the balance.
So you're not willing to offer a view as to whether, in your opinion, there were a severe impact on the highway network that would not be outweighed or would be outweighed by the need?
I think that's for the inspector to make that judgment.
And so I suppose we're in similar territory if there is some kind of other impact, some other contravention of policy, perhaps highways impacts that are less than severe, for example, or some of the other site-specific requirements in Policy 20. Those are circumstances where you would certainly be weighing the planning harm against the need, and that's where need would perhaps become most acutely into focus. Do you agree with that?
Yeah, again, with the environmental and amenity impacts, that would be part of the planning balance to be weighed against the need. Yeah.
Thank you. All right, to come to need in a minute, I just want to deal with some of the other benefits being asserted here. I'm not going to take you through all of them, but in terms of employment, so I think you're proposing the employment of 7 members of staff in site and then lorry drivers who'd be contracted to make deliveries. I mean, Miss Else is right. That's not a level of employment that will substantially benefit the local community, is it? That's a very low figure.
This is one of the benefits. I think I'm talking about the benefits overall. I'm not suggesting the level of employment is a huge benefit that needs to be taken into account. I'm suggesting it's one of the benefits. It's not just the number of staff that we're employing at the quarry, though. It is a substantial amount of drivers, contractors for all the landscaping work, all the restoration work. I mean, I think we've said 7 permanent members of staff, but there would be a huge amount of other staff involved at that quarry. And probably sourced from the local area as well.
So, I mean, were you saying all the lorry drivers would be sourced from a local area, would they?
I'm not saying all of them, I don't know, but I would imagine if you're driving every day at Hamble, you're not going to live far away.
In terms of, well, I mean, obviously they drive to Hamble, then they drive to other sites, don't they? So they're not just going to Hamble. But in terms of the weight then that you give to that benefit, you said it's just one of many. You say limited weight to that benefit?
I don't really want to put a weight on one benefit on their own. I think that the idea with planning balance is you weigh up a number of benefits against the disbenefits and you come to a conclusion.
So you're not willing to assign a benefit?
I don't see a need to go through every tiny thing and put a weight on it, no.
Okay, so but you accept it's a tiny thing?
It's not, as I just explained, it's one of the many benefits, and it's not just the staff at the site, it's other staff that would be involved in driving and contracting.
Okay.
So lots of jobs.
Okay, the aggregate levy, as Ms Else explained, she's right. I mean, that's dependent on the amount of aggregate that's won from this site.
Yeah.
So if you're not winning aggregate from this site, but there's a need for it somewhere else, you'll be getting the levy elsewhere. So it's not a benefit that's particularly unique to this site. If there's the demand for aggregate and there's a supply, you'll get the levy wherever it is.
Yeah, aggregate levy is payable wherever the site is, that's right.
In relation to, I mean, a similar point in relation to business rates, as Ms L said, business rates are effectively there to make up for the use of the land by the development, aren't they? They're sort of compensation for the use of facilities, local facilities. So that's not a benefit of the scheme. That's just netting things off, is it not?
It's an economic benefit because you're giving money to the local authority as a result of you being there, which they wouldn't get otherwise.
But you're also using local authority services, are you not? That wouldn't otherwise be used if you didn't have something on the site.
Sorry?
You're also using local authority services that would not be used at all if there was nothing on the site.
Yes, we're using the highway and there may be things like rubbish collection, yeah. So, yeah.
And that's what the business rates are for, aren't they?
If you say so.
Well, I'm not giving evidence that you're giving evidence. That I'll put that to you. I think that's what the business rates are there to cover, is it not?
I don't know what business rates are to cover, to be honest.
Okay, so you can't say that actually it's a benefit of the scheme because you don't know what they cover.
It is a benefit, isn't it? It's money going to local authority that wouldn't otherwise be going. I don't know about the level of rate we pay versus what we would take.
Yeah, but how can it be a benefit if you're only giving what you're taking?
Well, I don't know that, do we?
Exactly,
Don't know.
you don't know, so you can't tell the inspector it's a benefit, can you?
It's still money going to local authority. It's one of the benefits that I've written.
No, sorry, you don't know how much money you're taking from the local authority. You don't know whether you'll be giving more than you're taking.
That's correct.
Yeah, so if you're not, then it is not a benefit because net, the local authority is not getting any extra money, is it?
I don't believe we'd be taking much from the local authority, though. Right. I don't believe we'd be using lots of different services that, say, a resident might or another business might use.
But you've just said you don't know.
Yes, I don't know the exact amount of rates versus what we would take. No, that's correct.
Okay. All right. In relation to the footpath, I mean, as a matter of fact, people are already accessing the site, aren't they?
Yeah.
And we'll come back to the survey in due course. But generally, it's valued for its sort of openness and the ability to roam around the site, isn't it?
I think that's what has come out of the surveys that the HPDs have done, yeah.
Yeah. And so that will be, that won't be the same where there's a permissive path provided.
So when I've been on the site, the open parts of the site, certainly the whole site is not open. A lot of it is thickly covered with kind of scrub, and there are kind of narrow paths through it, particularly on the western side. It's kind of the eastern side that's the more open part of the site, and that would be where we've got our permissive area. So that part of the site would still be open. It would still be a wide open space for people to walk.
For people who are walking along that path, and I went through this to some extent with Mrs. Delahaye, so I'm not going to go through it in detail with you, but they will, on the one side, they'll have a bund, I think it's 3 to 5 metres in height, and then on the other they will have a fence. So it will not be the same, there will not be the same extent of openness enjoyed by people walking through the site as there currently is, will there?
I mean, I think as we've talked about, I'm just trying to find if I bring up the plan.
Which plan are you referring to?
It's B61. Have you found it? So B61 has got the measurements of the edge of the site to the bund, and they're quite wide in places, as you can see, 70 metres at the bottom, 40 metres, 66 metres at the corner, 56. So most of the way up the eastern side, it's kind of between 36 at the narrowest point to 70 metres wide. So just to be clear, we're not talking about a 3 metre wide path with a fence on one side and a bund on the other. It's much wider than that.
But it's not as open as it currently is.
No, that's true, yeah.
And I mean, just to be clear, obviously you are providing a permissive path, so a formal right of way, but that is secured, I think, for up to 30 years. It's not sort of a permanent right of way.
Yeah, it's secured for up to 30 years in the 106, and then the restoration plan up following that still allows that permissive area, and that's again in the 106. But so any loss of that would have to be through a further planning application to either, change the use of the site or vary that plan, which obviously the council are able to resist if they want to.
And then finally, flood storage capacity. And just to be clear, as I understand it, what's being done here is that you're saying you won't increase off-site flood risk as a result of your development, not saying you'll reduce off-site flood risk from what it currently is. Is that right?
I think we are saying we will reduce it during the operational phase at least, and I believe there's a benefit on restoration as well in terms of the off-site flood risk.
Okay, bear with me one moment. So I just want to pick up on that, just to clarify. So I don't know if you could help me turning to it's the planning statement. It's core document B something. Bear with me.
B60.
B60, yeah, and page 33. Do you have that, Miss?
Yeah.
Yeah, it's just the last sentence, because this is what I understand with restoration. It just says, once the site is restored, drainage features, including shallow ponds and ditches, would ensure that the off-site flood risk does not increase from pre-development levels. So that's not saying it will be better, it's just saying it won't be worse than pre-development.
I think that was written in November 23. I don't have the reference to hand, but the inspector can refer to the documents. But I think because the restored site allows for the increase in climate change as well, I believe there's a slight betterment once it's restored. And that paragraph does say, during the course of the extraction and restoration periods, off-site flood risk would be reduced, given that large voids within the quarry would retain any excess surface water. So that's a reduction in flood risk while we're operational.
Okay. All right, so I just want to pick up a couple of factual points before I think hopefully turning towards supply and need. So if I could just take you to your, I think it's your rebuttal, please. And to paragraph 2.10. Do you see that? Yes, you take issue there with something Ms. Elsa said. You say the fourth bullet point in her proof states that other areas are not secured by fencing or boundaries. This is simply not true, as seen by the inspector on the site visit. Whilst there are large sections of the southern and eastern boundaries missing, the fences have been removed. Much of the western boundary is in fact secured by fence, as well as southern and eastern boundaries. But I mean, you accept that some of the boundaries don't have fences, particularly southern and eastern. And Ms. Elsa is not actually saying that all of the other areas are not secured, is she?
Well, that's what I read it to be, because she says other areas are not secured by fencing or boundaries to prohibit public access. So it's not true, because most of the site has a fence. It's just the southern boundary it's missing in places.
Well, she's just effectively saying that some areas are not secured by fencing and boundaries, isn't she?
Well, she says other areas are not secured, not some. She says other.
Just bear with me one moment. Well, the inspector can make his own mind about that. But as Ms. Else is happy to accept that there are some fences, but there, as you agree, there are areas that are not secured by fences.
Yeah.
And then 2.15 of your proof, you talk about the 2022 survey submitted by the Rule 6 party, and then the second survey submitted, I think, at the beginning of this year, in relation to the use of the site. Do you have that?
Sorry, 2.15 of the rebuttal. Or
Your rebuttal, I'm sorry, yeah.
Yeah.
You say that this of the second survey, you say it's extremely biased, as many of the local residents opposed the appeal and will have answered accordingly. Just to understand what you're alleging there, really, are you alleging that local residents have acted in bad faith when they're replying to that survey?
I think that they will have known the purpose of the survey is to resist the quarry development, and they would have answered accordingly.
So I get, just to be clear, you're saying they gave inaccurate or untruthful answers simply to oppose the quarry?
I think they would have had in their mind when they answered the fact that this was being used to resist the Hamble development, and therefore that's a level of bias when they're answering. I can't say whether each person was untruthful or not, but I'm just saying there would have been bias because they know the reason why they're being asked the question. It's not a completely objective survey.
Well, I mean, I just want to be clear that you're not putting forward any evidence to suggest anybody untruthfully responded to that survey, are you?
No.
No. And, it's true that local residents might have had more reason to respond to the survey because clearly it's something that directly affects them, but it doesn't follow that at all that they'd answer questions falsely, does it?
It does, because they would have, many of the residents, obviously, as we know, don't want this development to go ahead. So they would have answered that questions in the survey with that in mind.
So I'm just trying to be clear, are you accusing local residents of lying on the survey or are you not?
I don't know individually. I'm saying they would have been affected by bias answering the questions.
Okay, well, I mean, it's obvious, isn't it, that the site is well used by members of the public. You're aware of that, aren't you?
I'm aware people walk on it, yeah.
Okay, so it's not really surprising, is it, that members of the public do value it as an open space and would have perfectly properly expressed those views in a survey?
No, it's not surprising that they would say they value it as an open space.
All right. And of course, as we established, Mr. Delhay, no other survey has been carried out by your client or anybody else?
No.
No. Okay, then moving on to just a couple of points about the site's allocation and then to supply and to need. Policy 20 is where obviously the allocation policy, and that says that an adequate and steady locally extracted sand and gravel will be provided by maintaining a land bank of permitted sand and gravel reserves for at least 7 years. In fact, it might be helpful to turn to that. That's called document H8.
Okay.
And it's page 77.
Policy 20 or policy 17, sorry.
Policy 20.
Yeah.
Yeah. So obviously, the overarching aim of the policy is to provide an adequate and steady supply, and you see that obviously at the introduction to the paragraph. And how that's going to be done is by extracting remaining reserves at permitted sites. That's point 1. Extensions to certain sites. That's point 2. And then new sand and gravel extensions, provided the proposals address the development considerations outlined in Appendix A. And those allocations include Hamble, Airfield, and we see the development considerations, obviously, in Appendix A. We don't need to go through those in detail.
No.
It's better to be familiar with those. And then, of course, so the inclusion of those sites in the plan is obviously subject to those development considerations being met. It's not a given that those sites will be able to come forward, is it?
No, they have to comply with the development considerations.
Thank you. And then criteria 4, obviously, it's identified that there will be some new sites outside of the areas, and they'll be supported to the extent they meet the criteria set out in paragraph 4 of that policy. Yes?
Yes.
Yeah. And then just to sort of finish off that point, if you could turn over a couple of pages to paragraph 6.81.
Yeah.
So, I mean, there is an acceptance there. Delivery of the sites identified within the plan may be impacted by issues including land ownership or other unenvisaged environmental impacts at the time of the plan preparation. And so, again, that's an acceptance that delivery of these allocated sites might in fact not be possible.
Yes, that's true, yeah.
Yeah.
You would have to demonstrate it's acceptable to work the site.
Yeah. Okay, thank you. And then, as for this particular site's suitability, obviously, given some evidence of sites today, I think, is it right? I mean, of the ones you gave, only Shepperton is a sand and gravel extraction site. The rest different types of material.
The Thorpe one I gave was a sand and gravel site. Let me just find the list. There are others that I didn't give, which are sand and gravel sites. But Doveholes, for example, is a hard rock site, so the impact's potentially higher because they're blasting every single day, which is not something you have at sand and gravel sites.
Okay, I mean, just in terms of understanding how typical this site is for a quarry, could I ask you to turn to the committee report? So that's core document E1. And to paragraph 640, which if you're looking at it electronically, that's page 194 of the PDF.
Which paragraph, sorry?
Paragraph 640. So it's just the last. This is summarising consultation response from the UK Health and Health Security Agency, I think. And it's the final paragraph. They say that they consider that the number of sensitive receptors located between 60 and 200 metres from the site boundary makes this site somewhat atypical. So, I mean, that's their considered view, and they're right about that, aren't they?
I think that I've never heard of the UK Health and Security Agency responding to minerals planning applications in all my time dealing with minerals applications. I'm not sure whether in this case they were consulted by the Minerals Planning Authority or whether there's another reason that they replied, but I don't think they're an expert necessarily in what makes a mineral site typical or not in terms of its location.
Well, I mean, they are obviously an expert national body on health security, and they have expressed a clear view that this site is atypical. They haven't said, "Oh, we don't know." They, as far as we can tell from here, they say we judge that this site is atypical. That's their judgment, isn't it?
That's their judgment, but I don't think they're an expert in making that judgment.
And they recommend a number of planning conditions, and then what they say in the end of paragraph 641, they say much of what is being requested by the UK HSA, I think this is in terms of data on air quality, including monitoring data from other comparable sites, is not available due to there not being a requirement to carry out this work at sand and gravel sites. So does that not indicate again that this is an unusual site?
Sorry, I'm not. Can you repeat the question?
Yeah, okay. So last sentence of paragraph 641, this is what the UK HSA say. They say similarly, much of what we are requesting is not available. That's the data, including monitoring data from other comparable sites, is not available due to there not being a requirement to carry out this work at sand and gravel sites. So does that not suggest again that this is an unusual, atypical site?
I think it suggests that it's unusual that the UK Health and Security Agency are replying to a minerals application. They've asked for data that's not available. Obviously, they don't know. It seems that they've asked for data that's not available, and it seems that they wouldn't have known that that's not available, otherwise they wouldn't have asked for it. And they've also pointed out, due to there not being a requirement to carry out this work, because that indicates, which is the case, we don't carry out the kind of qualitative assessments that they'd asked for as a matter of course, which if they were a normal standard consultee to the process, they would have known that.
Right. Now, just addressing the question of supply, then, just want to be clear what data the inspector is supposed to use here for understanding what the level of supply is. So I think we've been through a lot of this, but the requirement in the 2013 Minerals and Waste Plan is for a minimum of 7 years.
Yeah.
That's right, land bank, if you like. And that's mirrored, in fact, in the emerging plan as well.
Yeah.
Yeah. And that, of course, itself mirrors the NPPF requirement of at least 7 years in paragraph 226F.
Yes. Yeah.
Now, just turning then to the NPPF, if you have it in front of you.
Yeah.
So I think paragraph 22A explains how one is to measure a steady and adequate supply of minerals, and it says that minerals planning authorities are to prepare an annual local aggregate assessment, either individually or jointly, to forecast future demand based on a rolling average of 10 years sales data and other relevant local information, and an assessment of all supply options. You see that?
Yes.
Yeah, so effectively, when you're deciding whether there's a 7-year supply here, the source material that you're asked to use by the NPPF is a local aggregate assessment, which is produced annually and has, I think, at the very least, a forecast of future demand based on a rolling average of 10 years sales data. Is that correct?
I think the purpose of the local aggregate assessment is to monitor the supply to see if there's any issues with it and to help forecast, but it doesn't replace a policy requirement for a certain amount. A local aggregate assessment is used by minerals planning authorities to decide whether there's a need to review the plan. And in this case, obviously, Hampshire are reviewing their plan based on the information in their LAA.
Okay. And in reviewing their plan, of course, and we'll come to this, but they are reducing their local requirement, aren't they?
Yes, they are, yeah.
Okay, and then obviously it's common ground that the NPPF says that great weight needs to be given to the benefit of mineral extraction to the economy. That's paragraph 224. But the extent of the benefits of mineral extraction will obviously depend on what the need is for those minerals. If you have an abundant supply of minerals, there's little benefit to be derived from extracting more of them. Does that make sense?
I think what you're saying is the level of extraction will depend partly on the market demand.
No, what I'm saying is when you're looking at the need for minerals, so you have to give great weight to the need for minerals.
Yes.
The question is, what are you giving great weight to? What is the need for minerals?
Yes.
So,
Yeah.
Whether if there's a high need, you're giving great weight to a high need. If there's a low need, then clearly it's not something that is as significant, is it? Does that make sense?
You give great weight to the need.
Yeah, exactly, to the need. So we're focusing here on what is the actual need.
Yeah.
Okay. Now, I don't think we need to turn to it because we've set this out already, but the current plan sets out a local requirement in policy 17 of 1.5, I think that's million tonnes per annum, is that right?
Sorry, policy 17 of the existing plan.
Yeah. That sets out the local requirement. If you want to turn to, I think it's page 66 of the core document H8.
Yeah.
Yeah. So 1.5 million tonnes per annum, of which 0.28 will be soft sand. So that's the local requirement based on the 2013 plan. And then if I could ask you to turn now to the LAA itself, which is core document K27.
Yeah.
So just so we've obviously looked at this document before, but just to be absolutely clear what it is, paragraph 1.4, it sets out effectively why it's being produced by reference to the requirement to produce it in the NPPF. So this is the document the NPPF says the Minerals Planning Authority should produce, isn't it?
Yeah, it's the document they say you should produce, yeah.
Yeah. Okay, and then just taking you through a few bits of this document then. If you turn to page 12,
paper, sorry, or 12?
Internal page 12. In fact, if you start at page 11, do you have that?
I think so.
Yeah. So what this part of the LAA is doing is setting out or explaining where are the permitted sites producing sand and gravel in Hampshire. So those are the already permitted sites. And then there is a list of those on table 1 of the LAA at page 12. Do you see that?
Yeah.
And obviously that list does not include this site because it's not yet permitted, not consented. Yeah. Okay, thank you. And so then, if you look at table 2,
yeah,
what table 2 is setting out are effectively annual sales figures think basically over the last 10 years. And all of those are well below the current local requirement, aren't they? Well below.
Yeah, which is why the plan's been reviewed and that lower requirement has been taken into account, but Hamble's still required to meet that lower need.
Okay, and then if I can then take you to table 3. Okay, what this is doing is it's effectively applying those sales figures to the permitted reserve. And that permitted reserve, to be clear, I think you accept, that permitted reserve is based on the estimated reserves in the permitted sites.
Yes.
Correct? Yeah, so not including the Hamble site
No.
as we established. Okay, and so this is then used to work out the land bank based on various scenarios. And if we start with the land bank based on the local requirement, that's the second column of the table. Do you see that?
Sorry, which table?
Table 3,
Table 3.
page 15.
Yeah.
Okay. So the second column of that, land bank based on local requirement, the overall, as you've been keen to point out, the overall combined soft sand and gravel and, sharp sand and gravel and soft sand land bank is 6.94 years, so just marginally short of the 7-year minimum requirement, yes?
As of December 2023, but not as of today.
Yeah, we'll come to your maths in a moment on that, but if you're just looking at sharp sand and gravel, which is the only minerals that will be worked on this particular site, you do in fact have 7.39 years supply, don't you?
As of December 2023, but not anymore.
Okay, but the figures that we have got based on the LAA, which is what the NPPF at least requires us to look at, demonstrate that 7.39 years or maybe slightly less based on sharp sand and gravel. And the reality is that's the figure that the inspector's got to be concerned about. It's artificial, to say the least, to simply say, well, there's overall slightly less than 7 years based on the local requirement because there's a particular deficit in soft sand, and this site isn't going to produce any soft sand, is it?
The site's not producing soft sand, but it's not wrong to consider the land bank at this time. If I was inspector, I would be looking at the current land bank as of, 2025, not as of December 2023.
Well, let's just check what you said. Well, okay, let's check. So basically you're saying is the inspector pragmatically should look at the up-to-date position.
Yeah.
Yeah, okay, well, that's helpful. So I just want to then take you back. I think you said that if you apply the current APR rate to the 6.94 land bank, you are left with a land bank of 6.3. So that's
my calculation. It's around 6.3 overall, based on kind of 18 months after December 2023.
Yeah, but I just want... Sorry, carry on.
I mean, if you want a sort of explanation about how I've done that, it says the overall total of mineral is 10.82 million tonnes as of end of 2023. So if you assume it's reducing based on the APR rate, which was 0.89 million tonnes, so you subtract 0.89 million tonnes for 2024 and half of that again for 2025, the overall total is 9.48 million tonnes now. There was also, I believe, 80,000 tonnes granted at Frith Hill for soft sand since the end of 2023. So that adds, by my calculations, you end up with 9.88 million tonnes as of now. And then if you divide that by the plan rate, you end up with 6.3 year land bank.
Okay, yeah. So I just want to understand your starting point here, because the 6.94 that they've got there, that has been calculated by applying the local requirement APR to the permitted reserve, hasn't it? That's how they've reached that figure.
The 6.94.
The 6.94 at the bottom of that second column, the way that that's been worked out, that's your starting point, I think, as I understand it, for your calculations. That's the starting point, and that's been worked out by applying a local requirement, APR, to the 10.82 reserve, isn't it?
I think you're getting muddled up with the local requirement APR. So the local requirement is different to the APR.
Well, I understand that, but I'm just trying to understand, work out if you understand that properly, because your starting point is a 6.94, and that has been calculated on the assumption that every year you have to meet the local requirement, or you have to of whatever that is, 1.56. That's how you get to 6.94.
Yes.
And then you're taking that and you're adding the APR to that.
No, I'm just reducing the amount of the available mineral by the average amount that the mineral depletes per year. So I'm not using the APR rate. I'm just saying that on average we lose 0.89 million tonnes a year of mineral. So if that's the case, you'd end up with a land bank of 6.3 at the moment.
But you wouldn't, because Table 2 has already done that calculation. Okay, so it's done that calculation, say based on the 10-year average APR rate. It's done that calculation, and of course, because you have to apply that calculation to all of the years, not just the 1 year that you're applying it to, it gets 12.59. So actually your starting point is completely wrong, because you're starting at 6.94, but that doesn't make any sense. You're comparing apples with pears, aren't you?
No.
Well, explain it to me, because I don't understand what you've done.
Okay, well, I can provide a note to the inspector if it might be easier than to go through all the maths now.
We probably just need to explain your basic principles of how you've done it.
Yeah, that's all I need. Yeah.
It's too late for the note.
Okay.
Just explain the principles of the steps you went through to say how you got there.
Okay, the steps I went through, so let me just find it.
So it's what did you start with?
So
What do you take into account? What do you take off?
So in that table 3, it says there's 10.82 million tonnes a year.
Yep.
So on average in the LAA, the total land bank is reducing by 0.89 million tonnes a year.
Yep.
Correct?
That is so 0.89 is based on which APR figure are you using for that?
Let me just find the relevant bit in the LAA.
I think it's the one in the second column, I think, isn't it? So if you just look at the
The total
2023
sale.
APR rate. Yeah.
Yeah.
Okay.
So if on average you're losing 0.89 million tonnes a year, then for 2024, I've assumed that the land bank will have gone down by 0.89 million tonnes because that is the average.
Yeah, but you can see the table has already done this calculation. So the table assumes the author of the LAA, they, like you said, there's 10.82 million tonnes of land bank.
They haven't done this calculation, sorry, because
well,
it says as of December 2023. I'm doing a calculation since then.
I know, but look, just bear with me one moment. If you assume that the land bank depletes by 0.89 million tonnes per year, as you are assuming,
Yeah.
then you will have a land bank, a starting point, as of 2023, when this was carried out, of 12.16.
No.
You do. That's what it says in the table.
Yeah, but that's a different calculation to what I'm doing. What my calculation is trying to work out what the land bank is since that point.
But you're assuming that there's been depletion at the rate of the local requirement, which is patently not the case, because the 10-year average sales are even less.
No, I'm not assuming depletion. I'm assuming we've lost 0.89 million tonnes, not 1.56. I'm assuming we've lost the amount of mineral in that year, which is the average that you'd lose any year based on the LAA.
Yes, but you're applying that to the 6.94 figure, and that is the wrong starting point.
No, it's not.
Well,
I don't think you understand mine.
well,
Yeah.
the inspector will be able to take that away, but I suggest you have fundamentally misunderstood that.
No, I
You're
don't
going to
agree.
have to put that to her because
Well, I have
I
spent
don't,
quite a
I
lot of
don't
time-
understand what you're saying. So underneath the table, this should be common ground. There's a local requirement, which is the local plan requirement of 1.56. So that's just a notional requirement. But there's an APR rate, which is reflecting effectively sales, just below it, which is 0.89. And so as at 2023, the permitted reserve is 10.82. And if you want to work out what the position is in 2025, you take away whatever the sales rate suggests as occurring, which is 0.89,
Yeah.
and you then add in anything else that's been added to the permitted reserve. My learned friend is keep on referring to the local requirement figure, which isn't part of this calculation, because we're just trying to work out what is the extent of the permitted reserve as at 2025, assuming the 10-year sales rates have depleted that permitted reserve and then adding in any permissions.
Yeah.
So my learned friend is confusing two things in then going on to the local requirement figure.
Well, if given it's my witness, I might be able to just come back in. I'm not bringing the local requirement figure into this calculation. Ms. Pearman is, because she is starting with the 6.94 land bank figure.
No,
That's what you've started. That's
I'm
how you
starting with
started
the
to explain it.
reserve. No, I started by saying the overall reserve is 10.82 million tonnes.
Yeah.
Then you have to assume how much has been depleted, how much that has depleted in 2024. So what would you, I mean, I'm not meant to ask you a question, but I don't know what other number you would use to do that calculation other than what the average depletion is, has been over the last 10 years, which is 0.89 million tonnes a year.
Yeah, but but that's precisely the exercise that's carried out in this table, and you get 12.16 because that is, it's very clear.
No.
There are two asterisks. If you look at the third column on that table, land bank based on 2023 APR rate, two asterisks, it explains what that APR rate is, 0.89 million tonnes per annum.
Can I just try and help my friend? Because
Well,
if it's unhelpful, then I will.
I'm finding it unhelpful at the moment. If I just finish my point, that APR being used is 0.89 million tonnes per annum. It is applying that to the land bank, as you rightly say it should do, 10.82, and it is arriving at a figure of 12.16. So that's your starting point. And if you want to then work out, well, what's left, then you will subtract another 0.89 or whatever from that.
No, you wouldn't, because, yeah.
There are two figures in this table. There's a figure calculated, or the two relevant figures. There's a figure calculated based on local requirement, which is the 6.94. And then there's a figure calculated on an APR rate, which is at 12.16. And Ms. Pearman gave you updated figures for both. If you looked at it by reference to the local requirement, you get a 6.3 figure. And if you look at it by reference to the APR rate, you get an 11.1 figure. So if you want to apply the local plan figure, the local requirement, as at 2025, you've got to work out what is your current permitted reserve. So what you have to change is the 10.82 figure, rate of depletion plus any gain, and then you apply the local requirement of 1.56 to understand what the local requirement figure is. If you want to know the same calculation for the APR figure, then you apply the APR rate to your permitted reserve to get to your third column, which goes from 12.16 down to 11. There are two different calculations. One gives you the local plan requirement land bank, and one gives you the APR rate land bank.
Yeah.
I hope that helps.
Well, I don't agree. I don't agree because you have to. I mean, obviously, this is something maybe so it will help for you just to take away and think about in your own time because I'm not making much.
It might be helpful if we just ask what is the witness's understanding of column 3?
Yes. Okay.
What's column 3 showing?
Yeah.
And why is that different to the calculation that you've done.
So column 3 is showing what the total reserve is as of December 2023 divided by the APR rate of 0.89. So you come out with 12.16. So the difference is, what I've done is I've worked out since that position what the current land bank is in June 2025. So to do that, you have to start with the permitted reserve. You then subtract what you think you've lost in 2024 and the start of 2025. And I think that's where we have the issue, because I'm saying I have to think of a realistic figure to subtract from that permitted reserve. So what I based my figure on is the 10-year average sales. So on average, sand and gravel quarries in Hampshire lose 0.89 million tonnes a year. So I think that's a fair, if you think of a better sum to use, then, but that's, as far as I can see it, the fairest way, the most accurate way of doing it is subtracting what the average has been for the last 10 years, 0.89 for 2024, and then half that for 2025. So you reduce that permitted reserve to, I think it was 9.48. Then I've added half of 80,000 tonnes because that was at Frith Hill, which is a silica sand and soft sand quarry. I mean, whether I should have added the 80 or the 40, I've made a guess there. It doesn't make a huge difference. I've added in that small amount that's been permitted. Then I end up with what I think is the total permitted reserve in June 2025. And then once you've got that figure, you divide that by either the local requirement or the APR rate to work out the land bank. And based on that, the local requirement is you're at 6.3, and based on the APR, you're at 11.1 years.
But what's artificial about that is that you are accepting that the 10-year sales rate is 0.89. That's what you've accepted.
Well, that's what it says in the LAA.
That's what it says in the LAA. But then you're then bringing back in the local requirement, even though you know that doesn't match the reality of what has been sold. I'm not
bringing back in the local requirement at all. I'm subtracting the amount based on that 10-year average. I'm not subtracting 1.56. I'm not assuming 1.56 million tonnes a year has gone out, because I agree that would be unrealistic, because that's not shown by the LAA. What I'm subtracting is the smaller amount as shown by the 10-year sales data, and then the 1.56 only comes into it at the end when you've got your permitted reserve, and you divide it by that rate to find the plan rate, and you can also divide it by the APR rate to find the land bank.
But that's my point. We are reintroducing it at the end when you know for a fact that that is not the amount that has been extracted.
You have to work it out based on the plan rate, don't you? You have to divide your permitted reserve by 1.56 to work out the plan rate.
Perhaps another way of doing this, can my learning friend give his updated 2025 figures for column 2 and column 3?
Well, it would be 12...
Because it must be different now that it's 2025. These are figures calculated 2023. So column 2, well, and perhaps column 1 as well. Perhaps if he's got different figures for column 1, column 2 and column 3, different from Miss Pearman's, not put by Miss Els, I hasten to add, but if he's got some different figures, tell us what they are and how they're calculated.
The point is that the figure in... the point is that if you're actually trying to work out what the land bank currently is, then you have to be realistic, look at what column 3 is, because that is the actual amount that's been depleted every year. I think that's my point. That's my key point, and that's what I understood. That's what I don't understand, is that you accept that that is correct, but then it's just totally... I think that ultimately, the point I'm making is it's totally artificial to look at the land bank based on the local requirement on the way that you've done it.
It's not.
The LAA does this calculation, and she just updated it. So what are your figures?
All right. Well, we'll move on from there and just put the.
It might be helpful to me if you can just explain what is a calculation then that she should have done, and the witness can then explain the reasons why she didn't do it.
Well, I think I now understand what the witness has done. But the point I'm going to make, the point I want you to take away from this, sir, is effectively what this table shows in reality is that there is a 12.16. So based on the current APR, 12.16, and if you adjust that, I think you get being told something like 10.6. So in reality, you have a 10.6 land bank, year land bank. In reality, that's what you have.
Well, I got more than that, but if you want 10.6,
Well,
it's fine.
yeah, considerably more than the 7-year minimum that the NPPF requires you to have.
But not based on the policy 17, which doesn't defer to an LAA rate. It says 1.56 million tonnes.
No, but based on what the NPPF requires you to do, which look at the up-to-date figures, you said you should use the up-to-date figures, you accepted that. So we use the up-to-date figures, we get
I think
well
I said
over 7 years.
I said that LAA is used as a monitoring tool to see whether the plan should be reviewed, and in this case the plan has been reviewed with a lower figure used and Hamble still required to meet that lower figure.
Just help me, have I got this wrong? Whether we use your figure or the witness figure, we still end up with a figure that's above the 7 years.
Yeah, that's my point, yes.
But and yeah, I don't think you're arguing that, are you?
No, you end up with a figure below 7 years based on the plan rate.
Based on the plan rate, but in terms of column 3, the land bank based on the 2023 APR rate, that the last figure at the bottom, which I think is the one that you've been raising, the 12.18, what is the figure that you get?
I've got 11.1 for June 25.
And what have you got?
10.6,
I was
I think.
10.6, but I'll take 11.1. But I mean, the point is well in excess of 7 years. That's the point I'm making. Yeah.
All right. I've got the point.
Okay, thank you, sir. And then just finally, obviously, we recognise that the emerging local plan has a reduced rate. I think it's 0.9, 0.74 for sharp channel and gravel. So I believe if you apply that to the current reserve, you have something like 12.6 years supply.
But it's going to be similar to the LAA rate, isn't it?
Yeah, it's similar. I think it's slightly. Yeah, it's exactly. Yeah, very similar. Okay, but so the point I put is that in fact, on the basis of the up-to-date figures, and in reality, there is in fact an abundant land bank of minerals in Hampshire. There's something like 10, 11 years at least.
I think we've been through this. Based on the APR rate there is, but policy 17 says should use a plan rate. There's no, I think we heard from Ms Kirby-Hawkes this morning that the emerging plan is going to have a section in policy 17 that can defer to the APR rate in the LAA, but the current policy 17 doesn't have that.
All right, and the current APR rate though is basically the same as the rate in the emerging plan, isn't it? As you just said.
The APR rate is similar to the rate in the emerging plan.
All right. But you have made a number of other points, I think. So that I just want to finally take you through. So you have said that, for example, unless currently inactive sites come on stream, there will be a shortfall after 2028. That's, I think, your evidence. And I just want to take that up, if I may. So I think your evidence is that the land bank will have decreased by 2027 when this site comes online. But of course, we don't have any actual data. We don't know that, do we? I mean, that's speculation.
I don't think I've said the land bank will have decreased by 2027. I think I've said it will have, the existing sites will have depleted, but obviously we don't know at this point what the land bank will be in 2027 because there may be other sites that are permitted. But the sites I know about are the current planning applications are Purple Haze, a soft sand site in the New Forest, Ashley Manor Farm, a sand and gravel site in the New Forest area, Midgham Farm in the New Forest. They're the 3 other allocations. And then there's another planning application at the moment, Warren Heath, which is not allocated, which is mostly soft sand in the far northeast of the county. So those might be permitted. None of them are near Hamble. but the land bank may have gone up or down. Yeah.
So we don't in fact
Yeah.
know. And this comes back to my point that we really have to base our decision on the data that we currently have, don't we?
Well, I think you need to consider what the future supply will be, but yeah, you don't know what the exact land bank will be.
Yeah.
But you do know, as my table 1 in my brief, when the end dates of some of the current sites are, and it looks like quite a few of them, based on their current plan questions, will have gone by the time Hamble starts operating.
But on the other hand, other sites could find additional reserves, couldn't they? And update their position. You could get more applications granted within that period. All of that could happen. We don't know. It could be more positive. Could be a more positive outlook. Could be a more negative outlook. But we don't know.
We don't
Is that
know.
fair to say? Yeah. And I think also you'd have to assume that currently inactive quarries don't also come online and start producing again. But that's perfectly possible that will happen.
So
isn't it?
there's 2 inactive quarries at the moment. There's Kingsley, which is a soft sand silica sand site in the kind of northeast of the county, and there's Rowshot near the New Forest, which has got a huge amount of the land bank, 3 million tonnes in it at the moment, which is inactive. Obviously, either of them could come on stream, but their permitted reserves already counted in that land bank. So if they did, obviously it would be the land bank would deplete at a faster rate because they'd be exporting. So you'd be seeking to replenish it sooner because it's going to deplete quicker if there are more sites operating.
But you have significantly more supply coming on stream. So if you're talking, for example, about meeting unmet need, you'd have significantly more supply could come on stream if those inactive sites start operating again.
So I don't know what the output of those sites, so I can't say if it's significant, but neither of them are near Hamble, and if they come on stream, the land bank's going to deplete much quicker.
Okay. And also, I mean, I think you accept, I know that they have different qualities, but that Marine One aggregates can contribute to the supply of aggregates. Now, I accept there are different requirements in policy, etc. But if you're building something and you need some aggregates, in some cases, maybe not all, but in some cases, you could use Marine One aggregates, you could use Land One aggregates, couldn't you?
Yeah.
Yeah. So they could contribute to the supply potentially, at least to some extent.
They do, and they've got a separate requirement in those policies, 2 million tonnes a year, separate to the land one. And as I think we've heard, they've never met that 2 million tonnes so far, based on the last 10-year sales data.
Okay. And then I just want to ask you about future demand. So I think, first of all, you point to an increase in sales in 2023, paragraph 6.26 of your evidence. But I mean, the LAA, I think, addresses this. So I think it's paragraph 6.3 of the LAA.
I don't, 6.3.
It's just section 6 is an overview of aggregate sales. Section 6.3 talks about the increase in sales being more pronounced for some aggregates than others, effectively, and the biggest increases from Marine One and sand and gravel sites, and crushed rock sites also increased significantly in 2023. But then, as to Land One and sand and aggregates, they showed the smallest change in sales, but those two signalled an increase in sales. Yes, that's what the LAA is recording.
Sorry, I'm still having trouble finding it. Sorry.
Fine. It's page 25 of the LAA.
Sorry, can you repeat the question?
Yeah, of course. Yeah. Just in terms of the increase in sales of aggregates, the increase in sales is most pronounced for Marine One, sand and gravel, isn't it? That's what the LAA is saying, paragraph 6.3.
Yeah, that's what it shows, probably based on availability of marine.
Okay. Well, it certainly says that Land One, sand and gravel sites showed the smallest change in sales. Do you accept that?
Yeah, but the overall requirement for sand and gravel has gone up significantly in 2023.
Okay. But that's not being matched by sales of Land 1 sand and gravel, is it?
No, but for the most part, they can be used. We've heard that there are some differences, and for some applications, you can't use marine as a substitute, but for a lot of applications, you can.
Yeah, so people are
So
basically...
it shows an overall increase in the need.
And much of that increase is being met by Marine 1 aggregates rather than
Yes.
Land 1 ones.
It was in 2023.
Yeah, okay. And then paragraph 6.5 talks about the effect of recent uncertainty on sales of aggregates. But it says that there are signs of recovery in the 2023 sales. So none of that is certain. Signs of recovery, but we're not in a position as far as the LAA is concerned that there's going to be a massive uptick in demand for aggregates.
No, but I think we've discussed this earlier about the housing figures, and that there will be, based on that, coming through quite a significant increase in demand.
Well, the housing figures are also dealt with in the LAA. So if you turn to 6.28, sorry, not 6.28, forgive me, 7.17. So that relates to the short-term future, but then does acknowledge that a revised housing method has been proposed, and obviously now that proposal has been accepted. The final sentence, it says, having demonstrated a correlation between aggregate demand and housing completions, a significant increase in delivery could signal a need to increase demand, but it is not yet clear when the demand will be established through updated local plans or planning applications. So there's no suggestion here that there will necessarily be an immediate increase in demand as a result of changes to housing method.
I don't think anyone's saying it's immediate, but the MPPF has already brought in those housing figures, so they're already current planning policies in the way that they should be calculated. As far as I understand it, local plans that have an up-to-date plan will still be using their up-to-date plan, but the majority of local authorities don't have an up-to-date plan, so would immediately have to be planning for the higher numbers.
But to the extent that those higher proposed numbers actually translate into real demand for aggregates on the ground in this area in particular, obviously you have to also bear in mind that there are delivery constraints to housing in the local area, for example, that might ultimately temper that growth.
I mean, as far as I understand it, those local housing, the new housing numbers are a starting point, and local authorities would have to justify where they differ from that, but that's what they should be aiming for, which signals there'll be a huge increase in demand.
Unless, for example, you're in an area where, due to highway constraints, the local planning authority says there should be no new development, for example, which is where, I mean, at least the position in terms of Eastleigh Borough Council is at.
I mean, the local planning authority, as far as I understand, would have to justify whether that approach is acceptable, but that's going to be different in each case. I can't imagine they're going to get away with not providing any additional housing just because of highway constraints. But
so to the extent that there is going to be any additional demand, first of all, we don't know exactly the timing of that. That's obviously going to be spread across a long period of time, isn't it?
I mean, yeah, but I mean, if Hamble got permission, as I think I've said, it takes a long time to discharge any planning conditions, get the site set up. So by the time you start exporting, we're not talking about till kind of another 2 to 3 years anyway. So by that time, it may well be seeing the effects of the new housing figures.
Okay, yes, some effects, but potentially not all. When you're proposing a large housing scheme, you've got to get that through the development management system, discharge all the conditions, get spades in the ground. It's actually going to be quite some time before you see completions too, isn't it? And it's all spread throughout the period.
It'd be spread throughout the period that Hamble could be operating.
But I mean, at the moment, it's also right to say that there is potentially capacity in other sites to increase production. So I think the LAA talks about sites operating at about 60% capacity at the moment, so they could increase capacity to meet demand, couldn't they?
Yeah, it does say that, and I think, as I said, if you're going to massively increase capacity, 40% of the sites are going to deplete at 40% faster rate, so your land bank's going to deplete much quicker, and therefore you've still got a need to replenish that depletion quicker.
And you've got sites that could obviously extend operation as well if they have not extracted all of their sand and gravel. They could extend operating times, and the number of extension applications have been granted, as Ms. Els said.
They could extend operating times, and then but then the output would be lower, wouldn't it? So it's either one or the other.
Well, that would contribute more supply to the market, wouldn't it?
What if they extend their time?
Because if they extend operating time, so say they've reached the end of their period for operations, they can't extract any more gravel, they extend their time, so they can extract more gravel and therefore supply more to the market, can't they?
Oh, sorry, I'm confused with the question.
But if existing quarries, so some of the need could be met by, for example, existing quarries deciding to seek permission to operate beyond their current limits, couldn't it?
If they've got sand and gravel left, but that would mean their output is lower in the meantime, because obviously there's a finite amount in the ground. So if you extend the time, it's going to be a lower amount going out until that point.
But that, as Ms. Els said, a number of quarries have had a lower output due to, for example, COVID. So they have got, if you like, more reserves than they would otherwise have.
More reserves, but the reserves are extracted over a longer period.
And at the end of the day, obviously, the plan in this case does contemplate windfall sites coming in to meet demand as well, and that's obviously entirely possible.
It's possible, but it's not a way that you would plan to meet a steady and adequate supply by thinking, well, windfall sites might come forward. I mean, they've just had a call for sites. They've been through all the sites that have been submitted to them. They've only allocated 4 sites that they think are deliverable. I think they've said that they couldn't allocate any more because there were no deliverable sites. So you'd think if there were these windfall sites coming forward, they'd have come forward at that point already.
Okay, and I just want to take you through some just locational factors. So obviously a point being made by you is that the location of this quarry is a particular benefit, and I think Ms. Els accepted to some extent it is, but it's also right, isn't it, that the Southwest Hampshire already supplies, so I mean, I think the LAA says this at paragraph 2.7, but that Southwest Hampshire already supplies to Hampshire, Bournemouth and other areas, and that the influence demand, it's not based on just immediately local markets. I mean, at the end of the day, quarries are supplying aggregates to development quite far afield, aren't they?
Obviously they can, but that's not ideal in an environment where you're trying to reduce carbon emissions. You've got a state of a climate emergency in Hampshire. Obviously, if you can supply locally, it reduces the HGV miles and therefore carbon emissions. So while obviously you can drive sand and gravel from the New Forest to Hamble, if you've got a local supply, it massively reduces those miles and the associated carbon impacts.
Okay. Obviously, I think, just to be clear, I think yesterday in response to a question from an interested party, Mr. Howard said, just in terms of working out when HGVs would be arriving at the site, he said, well, it's quite hard to work that out because HGVs are arriving from across the whole region. So, I mean, is that not envisaging that, in fact, the aggregates produced by this quarry will supply the whole region? It's not just going to be supplying local.
I don't think that's what he meant. I think lorries can arrive at Hamble from anywhere, but you'd expect where you've got a local source of sand and gravel, you're going to supply the local area and you're going to prevent it coming from further afield.
Okay. Finally, just a couple of questions about inert materials. I think a degree of common ground was reached in between Mr. Strawn and Ms. Els on this. But, I mean, clearly the remediation strategy for this development is reliant on the sufficient availability of inert waste to fill the void, to keep up with the remediation strategy. That's right.
It is, yeah.
Yeah. So, I mean, as far as the inspector's concerned, if there are concerns about the availability of infill, that could exacerbate some of the adverse effects of the development, couldn't it?
It won't exacerbate them. I mean, if there was a lack of inert material, we would have to apply for a time extension at that point, which obviously the Minerals Planning Authority has got the ability to refuse if they wanted to. it wouldn't exacerbate and wouldn't make them worse. But obviously, if you're extending the time period, any effects will continue for a longer time period. But the point is, we have established that all those adverse effects are within the acceptable limits.
Okay, yeah, and obviously there's disagreement between your client, my client on that, and also
Yeah.
interested parties on that, so that's fine. But it would, but even on your own case, some of the benefits that you assert, like the restoration, the public access, the biodiversity net gain, all of that would be delayed if there were delays in restoration, wouldn't it?
The restoration, the site being restored would obviously be slightly delayed. If it had to operate for a longer time period. But I think the EMMP in the 106 is really detailed in terms of kind of what would happen at each stage. So I presume if we were applying for an extension of time at that stage, it would be subject to probably, a reconsideration of those ecological impacts, and probably I would imagine the planning authority would require some kind of benefit in that regard at that point.
Okay, but I mean, if you simply cannot get the infill, then you're going to have to, it's inevitably going to take longer to fill it in to restore the site, isn't it?
Yeah, but we don't anticipate any issue with getting the infill material. I mean, the location of Hamble, close to a huge urban area of South Hampshire, where a lot of the development is going to be taking place, that's where the construction waste is going to be arising. So it's going to be attractive to waste suppliers to come to our site because we're much closer than taking it much further away. And as we said, in our other site in Hampshire, we haven't experienced any supply, and the Minerals Planning Authority haven't either. So we don't anticipate any issue with restoring the site within the timescales that we've said in the application.
But if, for example, it's correct and the new standard method leads to sort of flourish in house building, for example, that is going to lead to a potentially, as on your case, an increased demand for aggregates, land on aggregates, if you like. But there's also, because there's a drive to use more recycled aggregates in the development, it's going to result in an increased demand for that infill material, that inert waste material, to be used in building as well. So there's going to be more coming out and less available to go in, isn't there?
I don't follow that, sorry.
Well, if there is an increase in house building, for example, and there is, as I think Ms. Ellis said, there is, and the policy reflects the push to use more recycled aggregates, the same type of inert material, if you like, that you might be relying on to fill up your site, to reuse it for the purposes of building work, for example.
I think I said in my evidence in chief that recycled aggregate's not really used for the same purpose, so you wouldn't be using recycled aggregate for building houses as far as I'm aware. It's kind of a low strength concrete. You might use it for driveways and things like that, but you're not going to be using it for things like foundations like you would land one sand and gravel.
But you would be using it for development that, for example, is associated with the delivery of housing or other infrastructure.
Using recycled aggregate for that?
Yeah.
Potentially.
Yeah, so there would be, if there was more of that, there would be less recycled aggregate available to fill up your site.
We're not using recycled aggregate to fill our site. We're using the residual material that can't be recycled. So if there was an increase in recycling and making recycled aggregate, it doesn't affect our ability to source inert waste because we're not using those bits that can be recycled. They're going to be taken out before it comes to our site, and that's in the planning conditions.
All right. Thank you. I mean, Miss Pearman, I don't have any further questions for you, so thank you, sir. Those are all the questions.
Thanks ever so much, Mr. Fulwood. Thank you, Mr. Fulbrook. I did say earlier that, as we did yesterday, if people want to speak, and I put my glasses on today, I've got 2 hands up, 3 hands up, who want 4 hands up. Same people as yesterday. All right, we'll work from right to left. So I've got 4 people, so the lady at the back, yeah, you, and then we'll go Mr. Walton, Mr. Trimble, and then I can't remember your name, but I can remember your face. It's And it's same procedures and so on. So when you're ready to ask the question, if you can put your microphone on, be mindful of questions that's already been asked, so we don't have repetition.
Thanks. Hi, I've just got a few questions. You made several references to sustainability in your proof of evidence. How did you arrive at the conclusion that the application is sustainable? Are you including grounds such as biodiversity, air quality, noise, etc.? In a similar vein to the question Mr. Strachan posed to Miss Else, did you make your assessment on sustainability of those sites and their suitability in the context of need, or on the basis of information that was provided by relevant experts and authorities?
I think in terms of when I talked about sustainability, it's mostly to do with the location of the site, close to the urban areas of Hampshire, South Hampshire, and preventing HGV journeys from further afield by providing a local source of sand and gravel. In terms of biodiversity, we're obviously providing a gain overall and massively improving the site for wintering birds.
So in terms of site's proximity to where it's needed, are your considerations there on environmental concerns, including matters such as air quality?
Yeah, I mean, we've done a huge amount of work on air quality throughout the application, as I'm sure you're aware, and demonstrated that the impacts will be within the acceptable levels. I think it's negligible impact that we have.
So the work that you've done and you've relied upon with regards to air quality, I assume that that is on the basis then that you have assumed that those experts have followed recommended protocol, and that those experts, such as the statutory consultees who would have then reviewed that those submissions, they have reviewed those on the basis that they've been put together following protocol and they've taken it as read.
No, because so obviously we employ an independent air quality consultant to carry out the work. In this case, the Minerals and Waste Planning Authority employed their own independent consultant to review the work that had been done by our air quality consultant, and that included him sending all the modelling that he'd done to do his assessment to these independent consultants, and they came back and said that it was the way he'd carried out his assessment was accurate, and therefore the conclusions are reliable. So they haven't taken it as read, they've assessed all the models that he's done.
Okay, but do you think it's possible that they have assessed the models and said, yes, this is an acceptable model that is normally used in these circumstances, they've used that model, therefore it's fine, rather than delving into it?
I don't know. I mean, I would assume because they're professional air quality consultants, they would have looked at it properly. They've certainly asked for the data behind the assessments as part of their review, not just what's written in the chapters and things. They've asked for the modelling work behind that. We provided that to them and they've reviewed that.
Okay. So are you aware, there were some comments that I made yesterday about the, it's stated in the air quality appendix that traffic approaching junctions was modelled in a particular way. And that modelling in turn appears to have informed the emissions calculations. There's no evidence in any of the documents submitted that show the extent of emissions from traffic sitting in kilometres of congestion along Hamble Lane. Therefore, could you offer any opinion of why the relevant statutory consultee may have failed to identify this in the context of traffic on Hamble Lane? So they have passed through the air quality assessment based on junction modelling that doesn't capture the congestion on Hamble Lane.
I think
Before you answer that, one thing that I have to be careful of is that the witness is not an air quality witness.
No, I appreciate that.
I can't rely on an opinion of an uninformed witness, if you see what I mean. That's not me being awkward, it's just being careful about
I understand that.
The witness can only use what's given to them from a planning perspective. So I'll have to pull back from details of air quality when it's not an air quality witness.
Okay.
You can ask it in a different way, you know, or some other things, but when you start to get into detail, I can't let that witness deal with it because she's not an air quality expert.
Okay, if I rephrase it then, do you think it's possible that your conclusions and other statutory consultees' decisions may have been informed on incorrect information if aspects such as modelling haven't been questioned in the right way?
But the modelling's been reviewed by an independent expert and they've said it's okay.
Okay, I'll have to beg to differ on that, and I'll ask my next question. Regarding the available sites in the New Forest, you stated that these are generally not acceptable because of their distance from South Hampshire urban areas where building may occur. Do you know how long the journey time is from, say, the Hammer Warren site in the New Forest to Southampton Airport compared with, say, Hamble to Southampton Airport, for example?
No, I don't know.
So if I take an example from this morning, at 8 a.m, the journey time from Hamble to the airport was 32 minutes. That's for 9.5 miles, compared with 36 minutes from the Hammer Warren site, which is 27 miles away. And dare I say it, Hamble Lane was quieter than normal this morning. Do you think, based on these journey times, it's reasonable to state that sites in the New Forest are not suitable? And do you understand that it could be quicker to travel 3 times the distance in more or less the same time? And how do you stack that up against the argument around sustainability?
I think that obviously journey times are going to vary from any site to any point, and you know.
What if I was to say that they were typical journey times?
Just like the witness
Sorry.
to answer your question.
Yeah, they're going to vary from any site on any given day. You know, sometimes going to be quicker. The fact is, Hamble is a lot closer to those urban areas of South Hampshire where it's going to be serving minimal. I mean, you said Southampton Airport, but you know, if you picked a site to the east of Hamble, which is where we're sort of talking about, where there's a lack of sites between that Southampton-Portsmouth corridor, it might be a different result from Hamble Warren, and it's certainly much further. And as I understand it, carbon emissions, you know, based on kilometres rather than.
It is much further, but although if we break down that 32 minutes from Hamble to the airport, around 22 minutes of that is simply to get along the stretch of Hamble Lane. So you're minus 22 minutes before you've gone anywhere by taking materials out of Hamble. Do you appreciate that that's the scenario?
I appreciate that journey times are going to vary, yeah, and if it's busy on Hamble Lane, it's going to take longer. It's still a shorter distance to supply.
And have you assessed the attractiveness of different gravel pit locations based on realistic journey times and not just road distance, or do you just use road distances when you're making those assessments?
I think there's a huge amount of detail that goes into assessing whether a site is a suitable sand and gravel quarry. There's so many factors to consider, which is why it's so difficult to bring sites forward, because there's so many variables, there's so many things that could prevent a site coming forward. We look at a whole range of issues when deciding. Obviously, the Minerals Planning Authority's recently had a call for sites, and they've only managed to allocate in the whole county 4 sites that they think is deliverable, which shows how difficult it is to come up with sites.
I appreciate that there's a whole range of issues, but I'm talking specifically about access to sites here, because you specifically referred to those sites being too far from potential building sites to the east of the county. So that's the point I'm getting at here. So specifically with regards to distances, are you simply basing your assessments when it comes to sustainability on the basis of distance, or do you look at journey times as well?
I think we look at everything together, yeah. I mean, we haven't done a specific assessment of journey times, I don't think, unless it's in the highway work, but not that I'm aware of.
Okay, so it is possible that it's been overlooked, that it can take take more time to get out of Hamble than it could to bring the materials from existing sites in the New Forest.
I don't think the time is the issue, though. No one's worried about how long it takes. It's the distance travelled that is the...
But there's a connection here between the fact that it takes so long to travel that time out of Hamble and the fact that Hamble Lane is heavily congested. And that is directly linked with the emissions that are produced from the vehicles that travel down that road. Because as I have stressed before, there's a disproportionate, vehicles emit a disproportionately higher level of noxious fumes and gases when they're idling and travelling at slow speeds than they do when they're travelling at speed. Therefore, it is important that those journey times are taken into effect, particularly when you're talking about sustainability. Would you not agree that that's something to take into account?
The air quality work is taken into account. I mean, as we said, I'm not an expert, but in their assessment of air quality, they've taken into account the relevant legislation in terms of how they work out those idling, and that's been assessed by an independent expert from the Minerals and Waste.
But that's the problem, though. They haven't, and it does appear to have been overlooked.
That's a statement.
Okay, I'll move on. I've made my point. I have two more questions. In terms of the loss of the site from recreation and site access perspective, you mentioned that you had to crawl through a hole. Whereabouts on the site was this? Because I use the site regularly and I've never had to resort to my hands and knees to access it. And you suggested that dog walkers can just go to the marshes or to Victoria Park, but not all dogs can be walked next to water for various health reasons, and many can't be exercised in the park as well. So they may be reactive, or they might be bitches in season, for example. So where do these owners go?
So the first question, where I'm talking about having to, I don't think I said hands and knees, but that it's the north-western side of the site. So there's a gap in the chain link fencing there where you have to, when I went there, there was a big dip in the mud. Then you had to kind of crawl through, well, not crawl, but duck through a gap in the chain link fence, which is not going to be suitable for lots of people. So what we're providing is a proper exit on that side of the site, close to the station and the footpaths and the school.
Yeah, I think most people in Hamble would be quite happy to take that over the proposals. You brought up the fact that Hamble is in the middle of a climate emergency. Can you? I've alluded to it already. Can you comment on the fact that this proposal is going to be adding to the pollution burden on Hamble Lane, which goes through an existing aquifer?
I think the air quality management area, it's been assessed as part of our air quality work, and it's that, again, the impacts are found to be acceptable.
Do you not think that there is some divergence here from your statements around sustainability, whereby how much is what is the straw that breaks the camel's back? So there's already an aquifer that exists. That's not up for debate. It is there, and we are going to be adding to that with this proposal.
I mean, off the top of my head, without going back to the documents, so I'm not saying it's 100% accurate because the inspector would have to refer back, but from what I remember of our assessment of the air quality management area, the current background levels were well below the target, and we wouldn't be adding to that barely at all. So it would still be well below that target, even with us operating.
And can I ask, do you think the targets that were used in this application are still appropriate, given that there seems to be a willingness to pick and choose which current policy can be applied to this application? So there's been plenty of discussion today around the updated planning policy, but none of this application, as far as I can see, has been put forward in the context of the updated Environment Act, the new biodiversity net gain. It would seem that there's been potentially some cherry picking around which of the policies or legal frameworks going to be used in order to assess the outcome.
It's not possible to cherry pick because the inspector will be making a decision based on the up-to-date policy. So this application will be determined based on the adopted plan. We have been talking about the emerging plan because of the rate is lower, but that emerging plan is not the determinative plan. It's going to be determined in accordance with the adopted plan. In terms of biodiversity net gain, that applies to any applications submitted after the 12th of February 2024. So we've been in since end of 21, and that's why the statutory net gain doesn't apply to our application. Notwithstanding that, we are providing a biodiversity net gain of almost 10% anyway. We've also got the 30-year management of that gain, which is the same as would be required under the net gain regulations anyway. In terms of the air quality regulations, as far as I remember, they did change during the application, but we've addressed that in the application, and the effects of that are in, I think off the top of my head, it's B92. It's the big document where we've addressed lots of residents' concerns, and there's an air quality appendix on that.
Okay, I'm not sure I'd agree with that, but I'll just ask my final question. So you talked about comparable sites where CEMEX have experience. You mentioned Dove Holes and Shepperton. As far as I can see, neither of these sites have schools that actually border the extraction sites. And then they're not as close as the two Hamble schools, especially the senior schools. And there seems to be some separation on the map by wooded areas and roads. It also doesn't look like the entrance to these sites is immediately next to, say, a primary school, which is the scenario that we're being faced with. From an overall comparison perspective, do you also take into account here things like background air quality and traffic issues that surround the sites? And would you still maintain that those sites are comparable on that basis?
Yeah, I mean, obviously I don't have the background air quality and traffic based on those sites, but we are next to schools in a whole range of locations. So I think Dove Holes was one of them I mentioned. That's not a standard gravel quarry, you're right, it's a hard rock quarry. It has blasting, like I said, every single day. There's vibration impacts. It has 10 times the amount of hard rock goes out by road right past a primary school. And as I said, we've got a good relationship with that school. We've got a good relationship with many schools. We do lots of things about going into schools with careers, road safety, lend a hand days. I've done that myself over the last year. Also mentioned Shepperton, that's got a school about 200 metres away, a secondary school. We've got an asphalt plant in Birmingham, which borders, the asphalt plant boundary borders the school playground. I mentioned a site in
That's very different, though, to sand and gravel extraction.
It's still got impact. It's still got the HGVs, though. It's still got potential noise and air quality issues. I don't know if it's the impacts would be less or more potentially than a sand and gravel quarry. We've got in Thorpe. This site's closed now. It finished around 15 years ago, but I've measured it was about 20 metres from the site boundary was a school playground, 80 metres to the building itself. So there's so many occasions where we've had sand and gravel quarries and other sites in close proximity to schools and residents where we've operated without any issues at all. And that would be the case here, in my view, that once we're established, there wouldn't be any issues. And in the planning conditions, we've got a requirement to put the site manager's details on the front of the site, on a website. So if there's anything, residents can contact us as soon as possible. We're going to have a site liaison group in the legal agreement. So that's another way in which we can speak to residents regularly, and if they've got any concerns, they can be brought up and dealt with like that. So that's how we operate at all our sites.
So with regards to Dove Holes, are you aware that the of all of the sites that CEMEX manage in England, it sits within the lowest background air pollution category of all of the sites by some margin? So certainly on that level and the surrounding roads and traffic network, it is not comparable at all.
I mean, every single site we operate is going to have a different background noise and background air quality. It's probably much quieter as well. It is a rural area in Dove Holes, and therefore any impacts we have are going to have more of an effect potentially on the noise, because if you've got lower background noise, you've got to be quieter. So I'm not saying there's a site that's directly comparable with the exact same background noise and air quality, because that's not possible. They're all going to have different background noise, air quality, other impacts. But the distance in that case is a factor, but that the determining factor is whether the impacts are acceptable. So you can talk about distances, but because each site is different in terms of background noise, background air quality, the issue is the impact you're having acceptable in terms of noise and air quality? And in this case, we've demonstrated that it is.
Okay, I don't want to take up any more of your time. Yeah. Okay, thank you.
Yes, it will. Yes. I'm sure the two gentlemen will
Thank you.
just a reminder that this is a planning witness.
Yep,
So
I have questions.
expertise is planning witness.
Yep,
With that in mind, off you go.
perfect, thank you. So we've ascertained sustainable development part of policy considerations, don't need to go into that anymore. But what was ascertained earlier was that no significant weight has been applied to this to allocating the site in the plan. So we shouldn't take this as given that this site actually fulfills the test of sustainable development. So adding to the point on economic contribution, you've said that jobs are likely to come from the local area. Have you assessed unemployment in the village and the need for local jobs?
No, we've not assessed employment, but if people are working at Hamble, Quarry, it's likely that they're going to come from a local area because they're not going to want to travel huge distances. That's all we've said about employment. And we're anticipating around 7 full-time jobs and additional jobs for contractors, drivers at the site.
So we ascertained yesterday that your group weren't aware of why people travel up and down the Hamble Lane, but a significant proportion of people are coming in for work. It's demonstrated, you can see that in the peak traffic times. That coincides with GE and Cooper Vision's shift timings. And they provide jobs, just the two of those organisations, for over 2,000 individuals. So do you recognise actually in that your contribution in employment is actually likely to be secured outside the area and not locally?
No, I still don't see why it wouldn't be local.
Because there is no local unemployment.
Not a single person in Hamble's unemployed.
Do you know that?
I don't, do you?
I haven't assessed that, I'm asking you.
No,
so you can't make the point is, I think, isn't it, is that you can't make the assessment that those jobs are going to be.
No, I've not said
locally.
definitely. I've said likely to come from the local area.
Okay. In terms of recreational impact, so would you agree that regardless of whether recreation is allowed or not on the site, the development is going to displace the current recreational activity?
The unauthorised trespassing, yeah.
Okay.
But it won't, because we're providing, I mean, it might not completely displace it, because obviously we're providing a large permissive recreational area throughout the entire thing, which will be set up before we start operating as an alternative to going on other sites.
We've also ascertained, haven't we, that you haven't done your own survey and you've dismissed the survey that was done. So it'd be fair to assess actually that you've got no idea where people might go.
I mean, I think we've been through that today, and I don't think there's any. There's the Royal Victoria Country Park where they might go, which is a similar comparable site to Hamble, but they also might stay and walk on the new permissive recreational area that we'll be providing.
And that's largely to the north of the site, which is actually away from. It's quite a walk. I've put that in my earlier submission, so we don't need to go into there. So if people move their recreation to the coastal sites, and I might have misheard this, to the river marshes and Netley Country Park in particular, these are adjacent to the European marine sites and SSSI, as you know that.
The country park has got the SPA at the bottom of the park, the very bottom strip.
Yeah, along the coastal strip.
Along the coastal strip.
Yeah, so most people would head to the coast, you head to the water, it's just a
But
natural...
when I've been in the country park, most of the country, well, the vast majority, and we went there on the appeal site visit, is outside that designated area. That designated strip, as far as I can see, is the kind of beach area on the very edge of it, which is tidal. So, and it's at kind of at a lower level, so I don't accept people are going to automatically go and walk on that thin strip. They're going to use the country park as a whole. Yeah,
I agree, they use the country park as a whole, but there may be additional pressure down there on the water side, of which is adjacent to a protected area, the SPA designation protected birds who aren't actually aware of high tide lines or boundaries either.
I think we've heard that evidence from the ecology witness about pressures on the SPA and why that's not.
But if you don't know and you haven't assessed how people might be displaced, would it be correct to assume that you've also not assessed the potential impact of the added recreation on those European sites and the SSSI?
I think, again, we've heard all this in the ecology evidence if you go back, and I think he explained why it's not an issue if there's
I'm going to pull you
additional
away
pressure.
from that because I need to make that judgment. I know the point you're making.
Okay, fine.
But
Made.
if we
Move on.
go into that,
I've got one more point on, because I find it quite misleading. You saying you crawled through a fence. The fence is actually in disrepair and hasn't been maintained since 2002. And there are plenty of access points around, not near the station, I take that, but that's because no one actually accesses the site from that point that you've been talking about. So I recognise that's a point. You mentioned the climate emergency, you've mentioned net zero targets, and you've mentioned the importance of being close to the sites because of travel and transport, and that's a key part of your sustainability assessments. Have you considered, or would you consider it to be effective for HGVs actually to use lower carbon fuels like HVO, recycled vegetable oils, as drop-in fuels, often used in travel and transport? To reduce transport emissions, they can reduce the transport emissions by 70 to 90%. And wouldn't that be a far easier low-carbon solution?
I think CEMEX are looking at sustainability is really important. We're looking at a huge range of initiatives to reduce our carbon impact, and I believe one of those is looking at alternative fuels. I think in the application as well, we talk about the training that drivers have to reduce their fuel consumption while they're driving to reduce carbon emissions. So there's a whole range of sustainability measures that CEMEX are looking at.
Yeah, so that's good to hear, but you've put quite a lot of weight on the sustainability and the need to have a site around the Hamble area because of the transport and the proximity of the transport, but actually you could use other solutions that are probably more effective to mitigate the transport emissions.
But if we weren't in Hamble, then the material could be coming from all sorts of sites that CEMEX don't have any control over. So it's not going to be that it's supplied from another CEMEX site. So we don't.
But a lot of the need hasn't been just around CEMEX sites; it's been around Hamble, hasn't it?
Yeah. So if CEMEX if CEMEX isn't operating in Hamble, then the sand and gravel could come from all sorts of different sites.
It could do, and it could be transported using HVO and low carbon fuels.
Yeah, but CEMEX don't have any control over that because it could come from anyone's site.
I think that's not so relevant, though, is it, to the point? In your calculations or any calculations of land banks, do you know if there's any assessment made of the land bank of recycled aggregate that's currently held within existing buildings or infrastructure that's due for demolition?
I don't think any assessment's made while it's an existing building. No, I mean the LAA makes an assessment of the amount of aggregate that's being recycled and provision for that in the future in the LAA and the plan.
Yeah. Okay.
As we've heard, that they've upped their target from 1 million tonnes a year to 1.8 in the forthcoming plan. So they're envisaging more recycling.
Okay. And I was also interested in, you made a statement, which I think you might have corrected, about recycled aggregate can't be used in house construction. I was slightly interested in that, but I did look up the Minerals Products Organisation Guidance, MPA Fact Sheet 6, on the use of recycled aggregates in concrete and a British standard around using that and how that could be used in housing. So do you actually agree that?
As I understand it,
it's used for
it can be used for lower strength concrete, as I said, I think in things like driveway construction, but it's not used for things like foundations because you need a higher strength of concrete.
And it's the construction industry has actually done quite a lot of work in recycled aggregates and improving the quality of the use of recycled aggregates.
Yeah, and that's in a separate land bank in the plan.
Okay. Just moving on to better sites, and I was interested in this because the issue's been raised as to whether better located sites have been identified, specifically in this area. We had a lot of conversations about this. There are sites that might have been removed from the plan considerations because landowners might have removed them. What would happen if this site got turned down for all the reasons that we've been discussing, and there's actually a better located site away from villages and congesting roads, but the landowners had pulled out from putting the site forward? Should the planning authority actually look to take some of these sites forward if it was in the national interest? When I specifically refer to Chilling and Bronwich, which is an estimated 8 million tonnes of sand and gravel just over on the Warsash, opposite Hamble, on the Warsash side of the river, between Southampton and Portsmouth. It was originally discussed in the 2008-2009 application, but because of local opposition, and you can discuss why local opposition had such sway over on that side, it was actually pulled down. But it's much easier access from the N27. It's not adjacent to villages.
I mean, if that site had come forward as part of the recent call for sites and was a deliverable site, and the MPA thought it was an acceptable site, I would imagine they would have allocated it in the emergent plan. They haven't, so I assume it either didn't come forward or they didn't think it was deliverable.
So that's the landowner bringing it forward, isn't it? So there are sites available. So when we talk about need and national interest.
So land.
I think we need to be careful here about straining to the planning authority's role in plan making and what its responsibilities are. I think it's probably unfair of the witness to give a view as to what information did the planning authority have at the plan making stage and the assessment it went through as to what it should allocate. Because some of that information will not be in the domain of the witness.
I accept that, but there was a question asked earlier of Ms. Else around had she assessed better sites. And so I guess I am also asking you, have you assessed better sites, not just in the plan, but better sites? And are you aware of better sites that could be available locally?
I mean, if we had a better site, we'd have brought that forward. Obviously, we don't have any better sites, and the Minerals and Waste Planning Authority don't either, because they've just had a call for sites. They've allocated 4 of them, and they've said there's no more deliverable sites.
Yeah, which could be argued. Anyway, that's all I have.
Thank you very much
Thank you
indeed.
very much.
Thank you. Mr. Walton, and then Mr. Trimble, and then that's it. Just usual reminders, Mr. Walton, just be careful about the nature of the witness.
Yep.
Just be careful about personal questions.
Yep.
We had that discussion yesterday.
That's okay.
And just be mindful about what's already been asked so we avoid repetition.
Yeah.
With that in mind, off you go.
Okay, my name's Christian Walton, Vice Chair of Governors at the Primary School. Thank you again for the opportunity to speak. I'd like to start off with, as a school governor in a position of responsibility, I'm disappointed that Ms Pearman has inferred on the public record that I and other upstanding members of the community have been deliberately misleading.
It's questions.
Would you like to withdraw this allegation? That's a question. I'm allowed to ask questions because she's made a serious allegation.
That's
on
fine.
the
You're
public
making
record.
a question, but you're putting things on the record.
I'm paraphrasing it to get to a question, so please be patient.
Sorry, what was the serious allegation?
You accused the community of being misleading in their responses to the survey of the airfield use.
I said they'd be affected by bias because they knew why it was being carried out. I said I wouldn't know if any individual had been untruthful. All I said was I think they'd been affected by bias because they know. We've already heard that evidence in the ecology. That same point has already been made in the ecology evidence about the reliability of the surveys and people being affected by bias.
Okay, I just think you're misaligning the community, but that shows that. Yeah, okay. I'd like to ask some specific questions about the proposed site operation. What time will the site start?
I think I'd have to refer to plan conditions, but I think it's 7 o'clock, but I think it might be later for the actual extraction.
Okay. Will the site entrance be gated?
Yes.
Will that gate be locked?
It will be locked overnight, yeah.
Will there be a night watchman on site?
I'm not sure, I'd have to find out. But
Okay. What time do you envisage the first person arriving on site to unlock the gates? From experience of other quarries.
prior to 7 o'clock.
So prior to 7 o'clock, so 1:45, 5:45?
I wouldn't know that detail.
Okay. So our teachers start to arrive at school from 7:30 a.m. to unlock and prepare for the day. What happens if your early morning HGVs are stuck in traffic and can't get into the site because the person who is there to unlock the gate hasn't arrived? Where will these HGVs wait? What process do you have in place for managing a late arrival of the person who is there to open the gate? Given that Mr. Howard alluded yesterday that you don't have a great deal of control of where your HGVs are coming from.
I don't know of this being an issue anywhere. That's like if the site manager is going to be late, there'll be a deputy manager, there'll be multiple other staff on the site who could open up. So I don't believe it's reliant on one person turning up.
Okay, so have you actually experienced traffic congestion on Hamble Lane?
I've been down Hamble Lane quite a few times. I think the time when we experienced the most congestion was on the appeal site visit at the northern end.
Are you aware that Hamble Lane and the village have been gridlocked on numerous occasions as per our previous submissions that mean that no traffic gets in and out of Hamble?
I have heard that said, yeah.
So how do you think that will affect your statement of it not being an issue that the key holders can get to open the gate?
I think the site manager will obviously have to get to know the nature of the traffic in Hamble Lane. We'll have to plan the journey accordingly. If that means leaving a lot earlier than they normally would, that's what they will do. They have a duty to open that site at 7 o'clock.
So what happens if they can't get there?
Somebody else will have to open it.
Who?
Another member of staff at the site.
So how many key holders will you have?
I'm not sure. We'll have to make sure it's multiple people.
You need to be careful because the planning, this is planning. It was not involved in operational.
No, but it's material to the safety on the
highway. What you're saying, but there's a limit, I think, as to how far in a planning witness can answer operational aspects of a quarry on a day-to-day basis.
We're just concerned because
I
it has an
understand your
impact
concerns,
on
but I think
the operation of our school and the
I
safety
don't
of
think
our
the witness can
teachers.
answer you to give you the actual what happens from an operational perspective. From a planning perspective, if you see what I mean.
We're just concerned that it's not going to be adequately
I
considered.
understand exactly what you're saying.
Okay.
I assume that any traffic that's centering any site would experience the same issues if there's gridlock down Hamble Lane. But just be careful that detailed operational matters might not be in the gift of the knowledge of the witness.
Okay.
And that's not me trying to be...
No, I understand. I just don't think that people understand the real situation on Hamble Lane. So you've just mentioned that the air quality modelling is robust and that Hampshire County Council have undertaken their own review and therefore everything must be okay. That was what you said, wasn't it?
I mean, I'm not an air quality expert, but we employ an independent expert to carry out our air quality work, and that's been reviewed by a separate independent expert that the Minerals and Waste Planning Authority, and they've concluded that our work was appropriate.
Okay, thank you. So, despite the proximity of the proposed site to our school, just 120 metres, Hampshire County Council's own consultants, RSK, in their June 2024 technical review of air quality, didn't even include our school as a sensitive receptor. This was highlighted in my speech on the opening day of the inquiry. On the basis of this information, given that the key sensitive receptor has been overlooked, do you still believe that the modelling is robust?
I think this issue with sensitive receptors is, I don't know if it has been explained before, but certainly with the noise, and I can't picture air quality off the top of my head, but you look at the closest sensitive receptors to the site, and because Hamble Primary School is across the other side of Hamble Lane, what they've done is taken a residential property that's closer, and that has been used as a sensitive receptor in that direction. And it's not that Hamble Primary School's been missed. Hamble School is one of the sensitive receptors. It's just that they've used closer receptors to the site than the primary school is. So if the impacts are acceptable at a closer receptor to our site, they're obviously going to be acceptable at a receptor that's further away in the same direction.
Are you aware in their report that they have the distance of the school from the site incorrect?
I wasn't aware of that, but if our air quality modelling is showing that the impacts are acceptable on all the sensitive receptors surrounding, and they're concluding that our work has been done correctly, then I think the conclusions are still reliable.
Okay, thank you. Are you aware that Hamble and the wider area already suffers from children engaging in antisocial behaviour, notably during the warm summer months, with the police on occasion having to issue dispersal orders? And are you aware that Hampshire Police have been involved in tackling antisocial behaviour of youths on motorbikes on the airfield?
I wasn't aware of that specifically, but yeah, I'm sure Hampshire Police are involved in tackling antisocial behaviour.
So the Minerals Products Association guidelines, number 22 for new quarries, states that with new quarries, operators should seek to ensure that hazards associated with public trespass are considered. What work have you done in your planning to consider that?
So the quarry regulations ensure that sites are appropriately fenced and signed. So we are going to have fencing all the way around the site as shown on our landscape operational plan. So that's at the foot of the bonds. The whole site will be fenced. There'll be gates, as we just said, on the main entrance. The fencing will be secure. So and regularly checked by the quarry managers. So, you know, any defects would be quickly repaired. And we'll have signs warning people of the quarry, the water and those kind of things. So that's all in accordance with the quarry regulations.
Could you remind me what height your fence will be around the site, please?
Let me just get the plan and see if it's on there.
Thank you.
I'm not sure that we said on this plan what the height will be, but it will be in accordance with the quarry regulations.
Okay, so is that
I'm not sure off the top of my head, I don't know.
The reason I'm asking is that I believe that there's a duty on quarry operators to safeguard the site allurements from children, and having seen what children get up to in Hamble, and it's not necessarily children from Hamble, children come from all over the Southampton area, we're particularly concerned that children will trespass and that this hasn't been appropriately considered.
I mean, health and safety is an extremely high priority for CEMEX, and there are these quarry regulations in place, as I said, to make sure that sites are appropriately fenced and signed to prevent trespass. But in terms of it being a hazard, it's the same as any other hazard, like a building site or, you know, roads, other bodies of water, in that children, you know, caregivers will have to advise children on where they can and can't go, and we will secure it as far as possible in terms of fencing and signs in accordance with those regulations. Obviously, you can't prevent every instance of somebody, if they're determined enough, to climb over those fences, but that's the same with any other hazard in the local area.
Okay, so in part 6 of the guidelines, it says that members should use the criteria to consider the risk to public safety. And it says the nature of the hazards, the proximity to the public urban dwellings and schools. This is right next to a number of schools. So are you confident that you have done the assessments using the bullet points set out in part 6 of the guidelines?
I don't know what guidelines, sorry.
So this is the Mineral Products Association Guidelines for the Management of Public Safety, published in July 2022. Under item 6, it says, members should use the criteria below to help determine the level of risk to public safety at a site and what barriers, fencing, warning signs and other actions are appropriate. The nature of the hazards on the site, e.g. deep water, face heights and lagoons, the proximity to the public, e.g. urban dwellings, schools, rights of way, proximity to a public highway, the history of trespass and vandalism, hence why I raised the point about the motorbikes, the period or length of time during which the site is unmanned, whether it's in a rural or urban setting, and I believe you've clarified that we are in an urban setting, and the appropriateness of existing barriers and warning signs. So those are the criteria. And my question is, have all of those points been considered?
I mean, I think, as the inspector said, I'm not part of the operational team, so it's not, I'm not aware of exactly what happens, but I know that health and safety is our absolute #1 priority, and we are members of the Mineral Products Association, so I've absolutely no doubt that we will be securing and taking all those factors you just listed into account and securing the site appropriately, because we absolutely, obviously, do not want any incidents on any of our sites, so we will be taking the utmost care to secure it appropriately.
So I can take your assurance back to parents at our school that their children won't be at risk from this quarry?
That's probably an unfair question, Mr. Walton, I think. Because
I don't think it is, because
excuse
there's no
me,
risk.
I think it is, to be honest, because you're putting the witness in an untenable position to make an assessment about what might happen on health and safety when the witness is not responsible for health and safety. There is national legislation that requires health and safety at quarries. And every operator has to abide by that. But what I don't want you to do is to put the witness to give a personal opinion about whether there's a risk. I can't let you
Okay.
do that.
Okay.
I'm sorry.
No, that's okay. It's worth a try. On which date do you plan to start operating this quarry, should you be successful?
Not possible to know the exact date at the moment, but I think
Just rough.
as I said earlier, if the appeal was allowed, obviously it depends when we would get that decision. After that, there'd be a long period of discharging any pre-commencement planning conditions, which I think there's quite a lot in this case. There's the ecological management plan in 106, so that could potentially take up to a year. We've got to put in a section 278 for the access to be approved, so it depends how long that takes. So you're talking about potentially end of 2027,
Okay.
as a guess.
Yeah, okay, that's a fair assumption. So in Mr. Strawn's cross-examination of Mrs. Els, it was alluded to several times that there could be the prospect of delays and by implication extensions to the life of the quarry. As a community, this is really concerning for us. And how can you be sure that the quarry will be excavated and restored within the current 15-year period that you've applied for planning application? The reason we're concerned is our children start their education at aged 5, and our child joining our school in September 2027, which was roughly when you say the quarry could be starting, will be 20 years old if all this goes to plan. What assurances do we have as a community that this won't go on into their 30s and 40s?
So obviously during my evidence today, we've talked about the location of Hamble. So we believe there's a need in this area for this site, otherwise we wouldn't be here. And because it's so close to the urban areas, we think that there will be a big demand for the material from this site, and therefore there shouldn't be any reason for it to take longer to extract the sand and gravel. We've also talked about today the huge increase in housing numbers that are coming forward, which is going to increase the demand for aggregate. We've also talked about inert waste, there not being any issues with the supply of that. So we could foresee a big demand for the material, which means there shouldn't be any need to extend the time period to extract that material. We also don't envisage any issues with the inert waste coming into the site, so it should be able to be restored in a timely manner. If it's any comfort to you, a lot of times when sites apply for extensions of time, that's for a physical extension to the site. So there might be a huge amount of land next door which can also be used for mineral extraction. In this case, there's clearly nothing else next to the site where we could go. There's no other huge areas of, land next door that we can apply for a further physical extension. So that won't be happening in this case. So we don't think there'll be a reason to extend the time for any reason as far as we can see at this point.
So based on what you can see at this moment,
yeah.
you're confident that by 2042 this quarry will be completely restored?
Yeah, by the time period we've said, yeah.
Okay, thank you. You mentioned that you've had many sites in the past close to schools. I'm curious to understand how a quarry that closed 15 years ago that may have been operating in a different environmental and regulatory time period can be relevant to the conversation.
It's probably, the standards may have been lower in the past than they are now. I think, in this site we've said we're going to undertake continuous air quality monitoring. That's not something we've done before. So if anything, I think the restrictions and the standards are getting more and more stringent than they would have been in the past. So if we've operated a site in the past next to the school, I think you can be reassured that we're taking even more care, even more monitoring now than we would have done previously.
So you mentioned that you're going to undertake air quality monitoring, which you've never done before. I'm a little bit confused because all along you've, in all the correspondence we've seen, there's been this alluding to you have experience of operating sites like this. So do you have experience of sites that have operational procedures that deal with air quality changes if you've never used air quality monitors before?
I think what I meant is, as far as I know, we've never used these continuous air quality monitors that we are proposing at this site, which we may have used kind of the sticky pad dust monitors as part of the dust management plan, but we've not used continuous air quality monitoring that we're proposing here to make sure that the levels are constantly monitored.
Okay, thank you. The live quarries that you considered, by your own admission, are 200 to 300 metres away. How close is the Hamble school to the site?
I think, as I said earlier, it's not the distance in metres that matters, it's what the impacts are, because every site is going to be different in terms of the background noise, the air quality, the vehicle numbers, those kind of things. So what's relevant isn't, in my opinion, is not the metres, it's whether the impacts are acceptable at that distance. And we've demonstrated that they are in this case.
So are you aware that the Hamble school have raised significant concerns that their exam hall, which has to have open doors and windows, is only 50 metres away from your site?
I am aware, yeah, I went to the school and I've seen them.
Do you not think that that is a concern?
I completely understand why they would be concerned, but I would ask anyone who's concerned to look at the actual evidence. So Hamble School was one of the sensitive receptors we've considered in the noise monitoring, and we've shown that for the normal operational period, so how we work it out is we do background noise measurements. So we've done those twice, I think, in 2022, and I think it was 2018 the first time. So we've done 2 sets of background noise measurements at all those sensitive receptors, including Hamble School. Then the noise consultant determines what the appropriate upper limit is for operational, for the normal operations of the site based on the guidance in the national guidance, and then he will work out what the noise limits are from our site based on an absolute worst case scenario of like all the machinery operating at one time. And based on that scenario at the Hamble School, the noise levels are well within those limits, well within. So that means it will be a good standard of amenity. So, and the limits are set nationally by government. So if you've got a result that's well within those limits, you can be reassured that there won't be any adverse impacts on amenity. And the noisiest part of our operations is constructing the bunds. And so there's a higher noise limit for those temporary operations of up to 70 decibels for 8 weeks in a year. So we've said that we will be constructing the bund along that northern section outside of term time. So that noisiest operation will happen when the children are not at school. And the rest of the time, it will be well within those normal operational limits. So I think they should be reassured by that, because that's the assessment work that's been carried out. And as I say, we've measured those background noise levels on 2 occasions.
So does that noise assessment that you've done, does that indicate that the noise will be louder than it is currently at the Hamble School?
I'd have to go back
for the children sitting.
I'd have to go back and check it. I know it's well within the maximum limits.
I appreciate it's well within the limits. The question is it louder?
I can't remember off the top of my head. I'd have to check.
It would be good. Maybe it's a consideration for you, sir, in your analysis. You've also mentioned a number of, in these live quarries that we talked about, what size are they? How many pupils go to the schools by these live quarries that you referred to, particularly the blasting one?
The blasting one, it's a primary school in a village, so I'd imagine it's a small school, but I don't know the number of pupils.
Okay, because that would be quite a useful thing to understand if the comparison is like for like, because the Hamble School are you aware that the Hamble School is a large school, and that both schools in the village and the preschool that are very close have over 1,500 children in them?
I mean, I think one of the other sites I mentioned, Shepperton, is near a secondary school, which I would imagine would be more comparable to Hamble School, but I don't know the exact numbers of people.
Would there not also be a much higher level of ambient noise and pollution in a built-up area like Shepperton compared to an area like Hamble?
I don't know off the top of my head, but it would have been assessed in the same way. It's measuring the existing background noise, measuring our limits, and making sure we're within those maximum limits.
For the quarry that does the blasting, do the children walk right past the quarry entrance?
I don't know where they walk. They're primary school children, so I'd imagine they probably wouldn't be walking by themselves.
It doesn't matter, does it, if they're walking by themselves or not? They're still exposed. So I'm just trying to understand the uniqueness of our situation in that children are walking past the quarry entrance, which I believe is what's been asserted all throughout. So I'm curious to understand the comparison between these other quarries that you say are comparable, if children actually pass the site or whether the site is just in the background?
I mean, I know that 10 times the amount of HGVs went out of that site last year, as will go out of Hamble. And according to our sales data, a lot of those went past the school. So that's a huge amount of HGVs. So it's not comparable in that regard because there's a huge amount more HGVs going past that school. I don't know exactly where the children walk to get to school.
Okay, my question was more about the crossing of the junction, because if you've read our submissions, we have great concerns about the safety of that junction.
Yeah.
Okay, thank you. You mentioned to Mr. Fulbrook that you will have a huge amount of other staff in addition to the HGV drivers. So it isn't just the extra 7 vehicles for the site employees mentioned in your application. How many people is this huge amount of other staff?
I think
how many additional vehicles will that be?
I think that's all been assessed in our, it's not going to be a lot of staff in one go. This is over a long period of time. So you'd have contractors at the start, setting up and constructing the bunds. Then you'd have contractors later on in the restoration period doing the landscaping and the planting, and in between you'd have the drivers. So we've given all those figures to our to be included in our transport assessment from the beginning.
So your transport assessment includes this huge amount of extra staff and the miscellaneous vehicles.
It includes additional staff other than the 7. Whatever, I can't remember the exact figures, but they were certainly included in the transport assessment.
Okay, thank you. You've talked a little bit about the infill, and as a school we're concerned about the impact of the infill of the environment that our children will grow up in, given the proximity of the river and the fact that we're an outdoor school. You mentioned that you will use non-recyclable building waste to fill the quarry. What will this be, please?
It's a lot. It's mostly things like clays and soils that can't be recycled. There may be bits of stone in there, that sort of thing, that can't be removed, but it's generally things like clays and soils.
And how will you ensure that that is inert? What processes do you typically have in place in other quarries that you do this to ensure that that
I've got this
material
written
is
down
inert?
if you give me a second, because I don't have this on top of my head.
Yeah, I'm nearly there. Nearly there. Yeah. It's okay, I think there's some important points. I'm nearly there. No. Thank you.
Okay, so this is information I've got from other staff in anticipation of questions. So when we need to source the inert waste, we'd go out to the market and get a contract for that waste. We'd get a specification from them as to where the waste is coming from, called a waste investigation form. So we would also need an environmental permit from the Environment Agency, and that has a huge amount of checks in it as well. And obviously they can turn up on site at any point to check what our waste is. So when we get the waste investigation form and the information about where the waste is coming from, that would be checked against the permit as to ensure that it complies with what we're allowed to bring into the site.
Who will do that checking?
It will be CEMEX staff that are trained in that particular area of the infilling.
Okay, so that happens off-site.
Yeah, I think there's a particular qualification that they would have. I think it happens on site. We also quarantine loads on site and be able to check those. There's a huge amount of information that we get before anything arrives on our site as to where it's coming from and what the nature of that is. If necessary, we can go and visit the site and determine whether it's suitable or not. And again, the Environment Agency can make their own checks. I'm not an expert in that area, but that's, as I understand it, there are a number of
If it helps, there is another regime that will kick in for waste management, monitored and enforced by the Environment Agency.
Yeah.
And that includes transfer notes that are required to be provided and maintained.
I would expect that.
And the Environment Agency do check.
Yeah. Okay.
So I appreciate why you're asking the planning witness, but what I have to say is, well, there is another regime outside of planning that manages waste.
Yeah.
Notwithstanding the fact they've got a duty, I accept that. But there is another regulatory control that goes beyond planning.
Thank you. So with all this waste, will it be Cemex or someone else bringing it to site? Will it be Cemex vehicles?
I don't believe so.
Typically.
I don't believe so, but I'm not 100% sure on that point.
Okay, so it would typically be another
Yeah.
supplier or
Yeah,
subcontractor.
I think so.
Will the vehicles typically use the one main entrance, or is there a need at some point because of the vehicles going out that you would need to create a second entrance?
No, they would definitely just use that one entrance. No need to create any others.
So they would all be managed on site by the
But
site,
through that one entrance.
through
Yeah,
that
that's
one
right.
entrance.
Yeah.
Okay, thank you. You've repeatedly mentioned unauthorised trespass. Many people like myself that are reasonably new to the village are unaware, or have been unaware until this time, that this is private land. Can you enlighten me as to what you believe the landowner has done to deter trespass, given that our survey that you misaligned earlier indicated that people have been freely using the site for many years, at least since 2002, as mentioned by our last witness?
As far as I understand it from them, they've tried to secure this site several times in the past. The way they've described it to me is the fences get ripped down almost immediately after they secure it. So I'm not sure how long they've been up for, but as far as I understand it from the landowners, they have tried many occasions to. Well, I don't know how many occasions, but they have tried on occasion to restore the fences, but they've essentially given up because they keep being ripped down. We also understand that they had a lease, which I believe is with the Borough Council, and it's currently their responsibility to fence that southern boundary, as far as I know.
On the site visit, you mentioned that there was a hole in the fence that you literally had to almost crawl through on your hands and knees. How old did that section of fence look? Did it look like it's been maintained?
I mean, the section of the fence I'm thinking of in that northwestern kind of corner on Hamble Lane, most of it's intact. There are places where it isn't, but I think that was the only kind of exit that I could see in that at that point.
Okay, thank you. I just wanted to quickly take a more global view. In Cemex's 2023 integrated report titled Setting the Pace, it stated, and I quote, "With transparency, accountability and dedication, we work in partnership with the communities where we operate to foster diversity and inclusion and champion innovation for social good." Can you please provide me with an example of how you have done this so far and how you intend to do this going forward with the 5,000 plus members of the Hamble community, many of which who have objected, and the circa 200 businesses in Hamble who have been through this long process?
Yeah, so Cemex have a social impact strategy. We do lots and lots of work with local communities and schools. I think I gave a few examples earlier. So I know at the primary school in Doveholes, we've been involved in Lend a Hand Days. I've certainly done a Lend a Hand Day in a school in the last year near Coventry. We do things like the operational staff will go in and do talks to schools, which we would be more than happy to do in Hamble if that was something that they wanted. Talks about careers, talks about the Quarry, talks about health and safety, those kind of things. I've been in the last year, we've done a marine open day at our Leamouth Wharf in Southampton, where we had multiple schools coming to the open day. That was to talk about marine careers particularly. They had a tour of our ship. I've also done Upper Shirley High School, did like a career speed dating event where we talked about careers at Cemex and that kind of thing. So we do get involved in a huge amount of initiatives with the community. We also are able sometimes to sponsor local events, that kind of thing. That's not something that we offer before any application is permitted because we have a global anti-bribery policy. So it could be seen as, bribing people to support applications. So, but after applications are permitted, we've certainly got a way of local businesses and schools applying for grants and that sort of thing where we can try and support them if we can. So we'd also have the liaison group, just to mention, which is would be attended by members of the community, potentially the parish and those kind of things, where any issues can be addressed, and that's where we kind of try and maintain a good relationship with the community via that group.
Okay. So throughout the planning process so far, do you think you've engaged with the community with transparency and accountability?
I think it's been a different situation here because I think, as we've said in the application, we submitted the application when there were COVID restrictions. So it was just before Christmas in 2021. Our normal approach would be to have a public exhibition in person over 1 or 2 days. And then we put all the kind of boards up, all the information. We have people there to speak to the community, and people can come and see and talk to us. And that is the approach we do at all our brand new sites and most of our extensions to sites. And that unfortunately couldn't happen just because of that timing. We didn't want to be responsible right before Christmas 2021, inviting lots of the community where potentially COVID could have been spread. And obviously, you know, we didn't want to be responsible for that right before Christmas or at any point. So we didn't have that public exhibition that we normally have. So instead we had the 2-week virtual exhibition, which we thought was good in some respects because obviously it gives people longer to respond rather than the kind of 1 or 2 days, gives people longer to look at it. We also did contact the primary school and Hamble school on 2 occasions before we submitted the application. I understand we got a response from primary school saying they didn't want to engage due to relationship with the local education authority. That's what I've been told by our PR consultant, but I appreciate that was a long time ago before we submitted the application. But we have said to the Hamble school contact recently we would be more than happy to meet them and talk to them, and that's what we would normally do. And we did have some meetings with stakeholders before we submitted the application, but obviously we can only have meetings with those people that kind of get back to us and accept our offer.
Did you not consider post-COVID doing more to engage with the community, given the impact that this application would have?
Well, we absolutely did consider it, and CEMEX unfortunately so we're affected in the UK by CEMEX's kind of global restrictions, and a long time after the kind of general restrictions in this country were lifted, CEMEX still had health and safety being one of their top priorities. We were not allowed to meet in groups of more than 6 for a much longer period into 2022. And by the time that was lifted, the first round of consultation had happened, that it was well underway, all the objections had come in, and at that point we didn't think that it was going to be a worthwhile exercise in trying to engage the public.
Okay, yeah, that's fine. So you don't believe it would have been worthwhile to engage with the community?
Well, no, that's not what I said. I said
that's what
at that point.
But that's what I heard. Those were the words that came out of your mouth.
But I was talking about at the point in time.
So I think I hear the point you're making. I think there's a limit as to what I can take on board in terms of my reporting on that matter.
Yeah.
I hear what you're saying.
Yeah, that's my final question.
It's absolutely worthwhile, obviously, to engage the community, and that's always what we would do. But I think what my point was, at that point in time, that the purpose of engaging with the community is to talk to them and make them aware of our proposals and give them a chance to respond on those at an early stage. At the point where that would have been possible, we were so far into the application that the community were clearly aware of the proposals. They'd already responded. And at that point, there's no point having an exhibition telling everyone about it when they're already aware and have made their views known on it. Okay,
thank you. I'm just, finally, are you aware of your company's social impact vision?
Yeah, I think that's what I was just talking about.
So that states that our social impact strategy focuses on enhancing the quality of life, well-being and resilience of communities worldwide.
Yeah, I think that's what I was talking about earlier in terms of our engagement with schools and some of the things we do, like lend a hand days and talks and that sort of thing. That's all part of our social impact strategy.
So do you think you've got off to a good start?
I think it could have obviously been better at Hamble, and we have absolutely taken learning points from that. And I'm talking to our communications, our social impact department at the moment about improvements we can make in the future, about going into schools and talking more in advance about what we do, because obviously we don't want people to be concerned when they don't need to be, and we would much rather have gone in at an early stage to talk to people and reassure them and explain what we do. And I completely understand the level of concern, but I think that could have been alleviated, or could be alleviated in another situation, by us going in at an earlier point and reassuring the community about what we're going to do.
Okay, thank you. No further questions. Thank you.
Mr. Walton, thank you for your contribution to the inquiry. Mr. Trimble's the last person. As you're walking up, Mr. Trimble, just bearing in mind the things I mentioned to Mr. Walton as well, about personal questions, about not being repetitive, about things that we've already heard and dealt with. So with that in mind,
Thank you.
get straight on with it because time's ticking by.
Yes. I'll be as quick as I can, and hopefully my voice is better than yesterday. I live within 100 yards of the proposed entrance, and so I'm very aware of, as are my neighbours, getting into the traffic northbound. Often during the day, there is a queue of traffic at a standstill outside our houses, waiting to do just that, to move northwards out of the river. In such circumstances, we've essentially three options. We can stay at home, we can start our journey to the south and try and join the north somewhere else, or force our way across the flow of traffic to the south to join the flow to the north. Generally speaking, in a small car, you can eye up someone and perhaps do that. So my question is, given all the data that was talked about, movements that you're planning, and also the entrance, how have CMEX got confidence that HGVs will be able to exit the site safely without dedicated traffic controls being installed?
I think they'll just have to wait for a gap in the traffic like anyone else pulling out of any exit onto Hamble Lane. They have to wait for a safe point to exit.
I think everybody heard that, and I suggest that that's not a very economical.
Careful.
I'll leave it there, thank you. The second thing is that, following on from your answers to the school aspect, our houses are actually nearer the schools, and the bund at that stage is to be 5 metres tall. And you have said that you are thinking of mitigating the circumstances for schools by doing the noisy construction work during 8 weeks of their vacation. So we are sitting ducks potentially. We're there 24 hours a day, 7 days a week, and unless we go foreign or something for 8 weeks, have you a view on the impact on us?
Yeah, so the impact of bund construction has been taken into account in our noise assessment. So the national guidance says for 8 weeks out of every year, you're allowed to, or any construction sites and minimal sites are allowed to have this higher level of noise, and it's for a short period because it is a higher level of noise. We've demonstrated in our noise assessment that we would be well within that upper limit. In terms of, it's not going to be 8 weeks of higher noise for one house particularly, because it will only be the short period where the bund is being constructed behind your house. And obviously, Hamble Airfield's a large site, so when we're constructing a bund at the other end, it's unlikely that it's going to be high noise for you. So I appreciate it will be noisier for a temporary period, but that's a one-time thing at the beginning of the site. Once the bund's constructed, that's there to protect you from the noise of the operational site.
And then there will be the stage of deconstructing and returning.
There will be a stage of deconstructing years later, yeah.
Okay. And finally, because someone had to leave, Chair, a bit early, I've been left a bit of paper which says there was a reference earlier on to Dovehole's Quarry, and it was cited as being near schools and in a village. Also, an example against our local schools. But the point that I've been drawn attention to is that it was actually started in 1796 before the schools and villages existed. Also that it was a limestone quarry, so it's not comparable. And also that I believe it has a railway access. How does that square with what you feel is a comparable site?
I think I've given a number of comparable sites, well, the nearest sites that are comparable today. I've already said Doveholes is different in that it's a hard rock site that has blasting. It does have a rail-fed terminal as well, so about half of the material goes out by rail, but the numbers I've been quoting are the amount that's been going out by road. I've got those figures from the site itself from the last year. It's comparable in that it's a school in close proximity to the site that we have a good relationship with, and then many, about, you know, up to 10 times the amount of vehicles go past that school as would at Hamble.
So just to observe then, it was built or started 250 years before your current planning application and current standards.
I don't know when it's been there decades. I doubt it's been 250 years, but...
Well, 1796, quite a while ago.
I'm not sure about that.
If it helps, Mr. Trimble, I know the weight that I will attach to those comparables in terms of whether they are being important comparables for the nature of my decision.
Thank you,
and
Chair.
You can take as what you want from that.
Yes. As I say, it was left by someone who had to
No,
leave.
it's not a problem.
So,
Lots of people raised it.
thank you.
There is an issue about how much weight I attach to comparables of that nature. It's used to exemplify something, but not necessarily have a high degree of weight in my decision.
Thank you very much.
Thank you very much for your contribution, Mr. Trimble. Would you mind just turning your microphone off? Thanks ever so much. Re-examination.
Thank you.
Unless you want to come back tomorrow.
No, I'm happy to express Ms. Penman, if you could just cast your mind back to earlier this afternoon. You were asked about the second residential survey, do you recall that? And the potential for people to be subject to bias in their approach. Yeah. Can you just turn that up, CDL 34, if you can find it, on page 46 of 53, the survey you were referring to.
L34, did you say?
CDL 34. This relates to another question that Mr. Fulbrook asked you as well. Let me know when you're there. Have you found it?
It's just downloading.
Okay, sorry.
Okay.
Page 46 of 53. If my PDF is correct. Page number? 46 of 53.
That's a PDF page number, isn't it?
Yes.
Yeah.
Have you got that?
Yeah.
What? You should be on a question that was asked of residents.
I don't think I have got it in.
Maybe scan up or down.
Yeah. Is it question 11?
Yes.
Yeah.
What was the question?
If access to the airfield was reduced to a single 2 to 3 metre wide footpath with a 5 metre high mound of earth on one side and a fence on the other, would you still use it for the purposes outlined above?
Yeah. Was that question an accurate portrayal of what the position would be during construction with the permissive path and the area around it?
No, not at all, because I think, as we talked about earlier, and I think off the top of my head it's B61, is the plan that shows the width of the recreational area between the fence and the fence around the edge of the site and the fence at the bottom of the bunds, and it's obviously a lot wider than 2 to 3 metres with a bund of earth on one side. So I think people could have potentially been affected by the way that question was phrased when they gave their answers.
Thank you. Can you then just go to the question of need? Hesitate to go back to that table, but we were looking at the table in the LAA document. Have you got that?
Which table? Is it table 3?
Table 3.
Yeah.
So have you got that? Sorry,
yeah.
I lost and you were identifying, there were 3 figures identified: the permitted reserves, the calculation of the land bank by reference to the local requirement, and then calculation by reference to the APR.
Yeah.
And there you gave recalculated figures for all 3, and you were asked about that, do you recall?
Yeah.
And as the inspector pointed out, that if you're looking at the APR rate, whether it's Mr. Fulbrook's 10.6 or 11.1, you're above 7 years.
Yeah.
Can I just go back to the figure, the other figure that the LLA has included in this report? Can you just explain in policy terms what that other figure, the 6.3, why that figure is included in the LLA and why you've updated it? What's the relevance of it?
So the second column in that table 3 is the land bank worked out based on the local requirement, and that's that requirement in policy 17 of 1.56 million tonnes. So when I've updated the figures, I've updated both the current land bank as of now based on the local requirement and based on the APR rate. So I've got 2 new figures as of June 2025. So I've got a figure of 6.3 for the current land bank based on the local requirement, and I think it was 11.1 based on the APR rate.
Yeah, that's what you've got. What is the significance of the second figure in terms of policy? I mean, you talked about the third figure being a monitoring figure.
Yeah.
But what's the significance of the second figure in your...
So policy 17 of the Minerals and Waste Plan says they will provide a supply of sand and gravel at that rate of 1.56 million tonnes a year. There's no provision in that policy to defer to the LAA rate. So that, to my mind, is the policy that's applicable to this, and therefore the land bank should be determined based on that policy, which is below 7 years.
Thank you. You've also gone on to look at the land bank position with the APR rate, which is 10.6 or 11.1, whichever you think it is. And can you just help the inspector of using, if one uses that, does that affect the need for Hamble Airfield in policy terms?
No, obviously Hamble Airfield is allocating the existing plan, which has that higher requirement of need based on policy 17. The LAA has been used to determine that there is a need to review the plan, and obviously the Minerals and Waste Planning Authority are doing that, and in that new plan they've reduced the requirement to 0.9, but Hamble is still an allocated site, so it's clearly still a need for Hamble based on that lower requirement.
Thank you. And then just final question. You were asked about two questions. Sustainability of the locality to meet local needs versus other sites. And you were asked some questions about that recently, about journey times versus journey miles. I don't know what time the journey times were given. It may well have been in the peak hour rather than during the day, who knows. But can I just get you to help in terms of sustainability and climate change, which is what you were talking about, which is the relevant figure, the time it takes for vehicles to travel, the distance it takes, the distance that it travels?
I think that the distance is the relative, is the issue we should be looking at. I mean, I think as we explored earlier, the Minerals and Waste Planning Authority has to take into account locational aspects in terms of where it delivers sites. That can only be because, you know, you want to reduce the amount of miles that minerals spend on the road, and obviously journey times are going to differ in different locations, and it's, in terms of sustainability, I think it's the area and the distance from where it's going to be needed that's the relevant consideration.
Thank you very much. No further questions.
Thank you very much, Mr. Strauss. Just bear 1 second while I just finish this note. Right. Can I thank you for your contribution, Ms. Pearman, to this inquiry? That's the last witness we will hear from in the inquiry. A couple of housekeeping things before I kind of do the last little bit that I need to do. Simple housekeeping things. We've received the note from Councillor Pratt-Baines, which will be, bear me a second. It'll be ID 71. Just the matter that we raised about the cost of shared servicing pursuant to ponds. Where are we with that? If you're struggling, I can wait. You can send me it electronically.
Yeah, we don't have it yet. I mean, I've been in touch with Mr. Whittingham and he's trying to get in touch with Mr. Howard. I don't know if there has been any progress on that. I have chased this afternoon, so I can't update you. There's nothing to give you today.
Okay, in
so
which
we'll
case,
need to take more time.
before we have the closing submissions,
Yeah,
I need
of
to see
course,
that. So
yeah.
I can take it as ready. It's being dealt with.
It is being dealt with, and I've already chased Mr. Whittingham, and I know he's aware of the need to deal with it. So I will inform him that it must be in before closing.
But
Thanks.
But that's fine. I mean, just to be clear, Mr. Howard has sent a sponge costing to Mr. Whittingham.
Okay.
But Mr. Whittingham, I think, is planning to do something more detailed, which I'm not. Wait to see what it is, but I'm maybe that's not what you're asking.
As long as there will be dialogue occurring tomorrow, probably Thursday and probably Friday. As long as I've got something, and I'll put a deadline on for close of play Friday. That will be helpful.
Right.
That brings us on to the section 106 and the sole compliance statement. Where are we with that?
So, so the position, as I understand it, is that I have just reviewed on the County Council's behalf a unilateral undertaking that the appellant is now proposing. There are some pretty straightforward issues, I think, that need to be looked at again by the appellant in the context of it now being a unilateral undertaking as opposed to an agreement. I think it's just a matter of them having the time to look at those, and it then can be with you pretty swiftly. But we've gone back within the last 10 minutes or so, as I understand it, with our comments on the undertaking. We've not had much time to consider it in the form of an undertaking as opposed to an agreement. But we understand the appellant will be in a position to review those promptly.
Right, we've kind of changed the ground rules without me knowing here, and without what's been put in the public domain and considered in the roundtable discussion. Why have you moved from a section 106 in the terms that it was to now a unilateral undertaking?
So,
to what extent is a difference that I need to say, hang on a minute, we ain't considered this?
So the agreement, the substance of the agreement is the same in the sense that it's been converted from an agreement into a unilateral undertaking. The reason for that, as I understand it, is the council are not prepared to sign an agreement with a term in it which relates to the landowner wanting to identify what would happen to the obligation in the event of a subsequent planning permission being granted. And therefore, the council don't want that term to be in the agreement, so it has to be in a unilateral form. And that's as I understand it, apart from the addition of the community, I forget what it's called now, community liaison provision, which has also gone in. So in essence, you had an agreement with all sorts of obligations in. There have been further discussions as to what the landowner wanted in relation to this provision about if planning permission was subsequently granted, which the council doesn't want in a signed agreement that they're signatory to. So it's been converted into unilateral, but with all the same obligations in it. So, and I'm grateful to Mr. Lewis for saying he's sent back. I'm not aware of that. So, I'm pleased to say. Right. So for what you're concerned about is it substantively different? My understanding is no, but it's in a different form. The obligations still have the same legal effect. It's just that the council won't be the signatory to it, but the binding effect of the same obligations will be the same on the person, the landowner and the operator.
Okay, I've not seen it. Therefore, until I've seen a draft, I'm not going to accept it. I also would like the Rule 6 parties' comments on that, as we did before. It's only fair that they have an opportunity to see it and to make comment as they did before. So I'm not looking for a signed version of that by Monday, or whatever date it is you might tell me in a few minutes, because what I'd like to see is evidence that you've seen it, that you've commented on it, and that people have responded to those comments before the actual final version is put in. And I know that you could do that anyway, but I think in the spirit of being fairness in the way that we've conducted this inquiry, I think it's only fair that the Rule 6 party at least reassures itself that the obligations in there are indeed the same. And there's no ambiguity or change.
I absolutely agree with that, sir. I've got no difficulty. I think we can go a little bit further and just flag up to the, save for the sort of mechanics being slightly different in terms of not having the same signatory, we can just flag up those two differences in it, namely the community liaison bit and the clause that the landowner wants in, which the council doesn't want in, because that will assist them just. They can review the whole thing, of course. But I'm just trying to assist the.
I think to be fair to myself, so I'm not going to reopen the Pandora's box of comments again because we've been through that. I just want your confirmation that those changes are indeed legitimate changes, but the spirit of what's in there in terms of the comments you've already made doesn't change. I'm not going to be prescriptive how you do that. That's something you've been doing that engagement outside of my involvement anyway, so you can sort that out.
It just if it helps, because they'll see it in the landowner provision that they want is to, if planning permission were granted for a subsequent use, the relevant part of the land affected by that grant of planning permission would no longer be subject to the obligations which would otherwise apply effectively. Particularly regarding environmental management. And there's a debate between the parties as the council doesn't think that's necessary, the landowner does think it's necessary. There's a debate to be had about that. That's the clause. So I'm just flagging up. So I'm not trying to stop anyone looking at it, just to help.
I'm not. I'll touch back on this again then before the closings in housekeeping, and then we'll have another chat after closings as to the outstanding information that might need to be submitted.
Yeah.
But I think it's fair that I'm not going to ask for a copy of that now because I ain't going to do anything with it. What I'd like to have is a copy that the Rule 6 party has seen, and then I'm sure that you've seen it. And then I can see it in draft form, or it might have gone beyond draft form after that. I'm not so sure, but I'll leave that to yourself. But I need that reassurance that you've seen it.
Fine. I think we can send a copy to them. Sort of. Well, perhaps we'll just check whether Mr. Lewis's comments mean that it's better to make his amendments before we send it to the. You've apparently sent us some comments. You were just saying which require adjustment. So we'll have a look at those, and then if they require any change, we'll then maybe.
You're off duty now. You can put your computer down if you wish. Right, all right. So, elephant in the room time. Closing submissions.
Yes.
Where are we?
Well,
so one update, sir, that I've not had a chance to discuss with Mr. Strawn yet is that I'm definitely out for all of Friday last week, as the inspectors just circulated the timetable for my virtual hearing next Friday.
What was the inspector? I'm only kidding. I'm only kidding.
Full conversations. But our offer still holds, sir, which is that we accept that in terms of closing submissions, we are the closing submissions of the two other parties are likely to be more substantial than ours because of the role that we have played at the inquiry. So as far as we're concerned, we are content that, I will certainly draft the closing. Ms. Kirby-Hawkes, I think, is content to deliver it on behalf of the council. So we're not going to insist that it needs to be arranged around my convenience. The only caveat to that would be if there's any other consequential matter, costs, for example, then of course the council would want me to be there for that. But at the moment, we haven't had any indication that there is going to be such a matter.
Right. That has to be one of my questions at the end, and clearly that will have an influence as to your attendance. and that will indeed have an influence on the extent to which I can close. I wouldn't normally ask this at this stage, but at this stage, bear in mind things can change because we've not formally had that discussion. Is there an indication from your client that an application for order of costs might be sought, Mr. Strong?
So subject to that usual caveat, at the moment we are not likely to be making such an application, and I'll explain that in due course. But so if for any reason that were to change, I appreciate we would then need to think about how to factor that in, and I'd obviously notify you and Mr. Lewis in particular.
We'll all be in a different
but then
game.
we would have to then make, if I thought that is a very likely possibility, I wouldn't be saying it now. So subject to that caveat, if I can have that caveat, I think we could plan for Friday next week.
Okay.
I'd hesitate to say this because for Friday, I'm doing an examination on the Monday. The Friday is a reserve day with nothing scheduled for it.
Was the inspector there?
I will. So even if it is used as a reserve day, I was not anticipating that we would be sitting at 2:00. If any issue arose, I would know that on Monday, this coming Monday, and I'm not anticipating it being a problem.
We need, all right, a couple of things there. Then I'll come back to it. Costs. I'd be amazed if you said yes.
No, sir.
But I just need to ask you, and I take it as read that you ain't applying for costs. You've created it. You're not applying for costs. All right, okay. Just coming back to that, we have to be firm about Friday. If we're not firm about Friday, we're here tomorrow afternoon. I can't let this drift because I'm not here 2 weeks after that. It's not fair in the community that we don't close this on time. So I'm going to have to say to you, it's got to be Friday. There's no get out here.
But that's fine. So I think if that extreme event arose of me not being available, I would simply get someone else, another barrister, to come and represent me to read it out.
Right, I'm issuing a direction. You have to be here on Friday. You have to be here on Friday. Otherwise, we are really nepical. And I'll kick myself for not bringing you back tomorrow afternoon. And you'll forever be in my debt for that, Mr. Strong. You don't want to be in my debt. I don't want to kid you, but you know what I mean. It's absolutely crucial we're here on Friday. So wherever it is, we need to be firm. If not, I've got to be firm with the programme. So you're okay with Friday afternoon?
Yes, when you say I have to be, I mean, all I was saying was that if I couldn't read our submissions out, we would have another barrister reading them out on my behalf, who's properly briefed to answer any questions.
It would be preferable if you were there.
Absolutely.
If I've got questions in about costs, the barrister might not be able to answer those questions because, of course, you've been involved in all the queries. You can deal with it.
Yeah.
Whereas the other person might not be able to deal with it. So I need to have some degree of certainty.
If I could put it in this way, sir, you can have certainty that I will be there, and if I'm not there, whoever is there will be fully briefed and able to deal with any questions that you have asked. Right. You may have. The only reason I say that is that I think technically I'd be in breach of having a reserve day if I then said absolutely categorically I can't do it, because that might depends on your other inspectors how amenable they might be. But I think probably I'm going to unnecessary detail. Friday, 2 p.m. next week, we will be there.
Mr. Fulbrook?
I'm grateful to both my other friends for their flexibility. That is fine for me. I can make Friday at 2 p.m. next week.
Friday this week?
Next week.
Next week?
Next week, yes. Is that not?
You said this week.
I said this week.
Yeah.
No, I'm sorry. It's obviously 7:15. Next week.
I'm not here on Friday. That's the reason.
Friday next week.
Friday next week. All right. Yeah, 2 p.m. will be all right. I'm just thinking of timescales and in terms of the council's not going to be more than an hour.
You've set a limit.
set an hour.
You set a limit of an hour on us already.
I set a limit of an hour and a half to a colleague of yours, and 6 hours later I was still sat there, Mr. Strawn, and you probably know the one I'm thinking
I
about.
can probably guess.
Okay, that just brings us then to confirmation of that, how we can do that in publicity terms from the council perspective. I understand the system can live stream those closing submissions. I understand that I will need a Teams invite, as will others who are on that call. Members of the community won't need a Teams invite because they can watch directly online. Is that my understanding?
That's correct. It will run similar to what we did with the examination of the Minerals and Waste Plan.
So therefore, we need to publicise the next day, probably by close tomorrow, the arrangements that the community can take to observe those closing submissions, which will be on the website a week on Friday. And I said earlier, nobody's prejudiced on that because I can't ask questions, you can't ask questions. We're observing somebody reading from their notes effectively. But it does have a degree of what's the word I'm looking for? Authority comments to it, because it is a final part of the inquiry, and therefore it has to be done with that spirit in mind, that we've had a lot of evidence that is pulled together in those comments. And they're very important comments from my perspective, they're very important comments from your perspective. So I don't want to, I'm not trying to kind of push this to one side. It's absolutely crucial part of this inquiry, is the finality of this inquiry, and therefore it has to be dealt with in those terms and in that tone. So you'll be observers like I will. You'll see my face because I'm going to be asking some questions on housekeeping matters, as I always will be. And I'll be going back to costs again at the end. What happens from now is that, other than the documents that I've asked for, which is the draft obligation, eventually there'll be a final version of that, the submissions, whether it be 1 or 2, regarding the costings, there's no further submission of information other than the closing submissions that I can now accept. So we are closed, not formally, but we are intermittently closed to submission of any further oral submissions other than things I might ask for, or closing submissions, and no further written submissions other than those documents that I've asked for.
I think another document you may have mentioned is a SIL compliance.
Yeah, I took that as being,
sorry, sir. Thank you.
Took it as being read. So that's where we are. So we're going to finish and adjourn in a minute. We haven't finished because I will formally close in writing, and you'll see that on the website that's it, done. You're probably wondering what happens next, and I can't give you timescales. We're officially not told to give you timescales, but you're not going to see a decision until the autumn, sometime in the autumn, when I don't know. There are internal checks and balances in this case that I will need to go through as well, so you're not going to see that until the autumn. So you will know quickly when it's out there, because you will know quickly. Everybody will be knowing about it anyway when it's out there. All that remains for me to say, while you're here in person, is thank you for your understanding on what's been a very emotive and technical inquiry. You've listened diligently without interruption, which I asked for on the day one, and you didn't do that. Yeah, I had the drums and everything outside, but that didn't affect us in here. So thank you for that. Thank you for the efficiency of the site visit as well. That were invaluable. But the manner in which you organised it from the appellant's perspective and the community, thank you for that. It worked very, very well. I was blooming tired when I got home, but it worked well. And thank you for your perseverance again tonight on what is the last late night, but it's the last time we'll be together. Thanks to the council for their organisational ability, second to none. There's none there and you come second. I'm only kidding. No, it's been absolutely brilliant, and I appreciate that. So that's it. We've not completely finished, but in terms of my presence, in your presence, that is it. And thank you very much, and have a lovely evening. A little bit more left than there was last night, and a little bit less pressure from some of us than there were last night. So it might be a different evening for me, and I'm sure it'll be a different evening for you. Who I passed in a restaurant, but we went last night. So, but thank you for that. Thanks for your perseverance. Last question. No, I hope it's not a. Yep. There isn't a format for me. If you have a complaint about my conduct, there's a complaints procedure in the Planning Inspectorate. If your complaint is about the evidence presented, that's not something I can deal with. I've heard what expert witnesses and what advocates have put towards me, and I've read what concerns have been raised during the course of leading up to the inquiry, and where relevant during the inquiry. And some questions have been raised at the end of some witnesses, and some statements have been made at the beginning of the inquiry. So there is no further provision now for me to open that up again. That's just, I can't do that. I'm bound by the rules that I have to follow, and the rules don't permit to do that. So if you've got some issues about my conduct, you can deal with that through the Planning Inspectorate. If you've got issues about the evidence presented, that's it. That's the last chance. I'm sure your advocate will advise you what else might happen after my decision, and that's not a matter for me to comment on. But I can't deal with it. I hear what you're saying, but unfortunately I can't deal with it. All right, that's it. So thank you for your attendance. We're now adjourned until Friday at 2 o'clock, when the order will be Council Rule 6, Appellant, I think. Yes. All right. Thank you very much indeed.
Thank you very much. Thank you.